interim orders which expire before the vacation.
Application.
Right now, no. There are too many applications. Please come back after the vacation.
Order 41, my lord.
Correction. No, order 41 application we are not adding. Correction and extension of interim order, please mention.
My lord, my respective submission on 24th September, your lordship was pleased to direct the matter for mediation center. Matter is not settled. That's why I am mentioning this matter.
It has been settled.
Not yet been settled.
Whenever we take up after
That's
the
why
vacation.
I've been-
We'll have to hear it then after the vacation, yes.
Lord, already we served notice.
Leave is granted, yes.
Not an application for
Lordship.
stay or contempt.
Application order 41 we are not taking up.
Lord,
Lord,
already we
this
served
is-
notice.
I am
We need to take
super,
it.
No.
I'm
This is
super
the
senior citizen. I'm counting days. And
Please wait for some time after the vacation.
it will be
Your lordship,
justice to
You will get it, but after the vacation, yes.
your lordship, may I permitted your lordship 9th January delivery of possession, your lordship date.
No.
Your lordship.
Lordship,
Call-
allow me to
May I have my lord's leave to
Second
mention for
sentence.
upgradation, my lord?
No.
Item number 164, my lord, the date fixed in London trial
Sorry,
court is
no,
5th
no.
January, my lord.
Cite the pendency before this court, no.
My lordship, I'm mentioning for correction of the order.
Great.
Correction, yes. Correction, extension of interim order, yes.
Lordship, mentioning for inclusion, Lordship.
My lord,
But this is
Correction
because
of
the
the
matter
application.
was earlier listed before the Chief Justice.
Not right now, after the vacation.
Now retired.
But,
Lordship, kindly.
my lord, may I have your lordship's kind leave to mention item number 163, my lord.
No upgradation, please.
My lord, I understand, my lord, but the urgency
You
is that
understand, then please let us.
my lord, this
proceed.
application is not
Call
maintainable,
on the
my
list,
lord.
please. Accordingly, FMAT 466 of 2025 is allowed on contest, thereby setting aside the impugned order dated such and such. Can one is consequentially disposed of. It is made clear that none of the above observations shall operate to the prejudice of the parties in any proceeding before any forum, either pending or to be instituted in India or in the UK, and are only of a tentative nature. No order is to cause urgent certified copies.
My lord, I'll be praying for stay of the order, my lord.
After the above judgment is passed, comma, you are for the respondent, obviously.
My lord, I pay for the respondent.
Yes, yes.
You are asking for,
Yes, my lord.
comma, learned counsel for the respondent seeks a stay of the operation of the above order. Full stop. However, comma, in the event stay is granted, comma, the same shall operate counter to the very grain of the above judgment. Full stop. Accordingly, we refuse such prayer.
Grateful, my lord.
এটা তাহলে ইয়ে করার দরকার নেই, একসঙ্গে ওটা ঢুকিয়ে দিয়ে তারপর একসঙ্গে লাস্ট পাতাটা এটা লেটারটা ঢুকিয়ে দিয়ে কলাম।
My lord, item number 2, my lord, I'm appearing for the state respondent. My lord, in this matter, lordship had directed filing of notes of argument. My lord, I'm beseeching your lordship, my lord, for 3 more days' time. My lord,
You are ready with
my learned senior friend has given me their version.
Very well.
But
The
I'll just
written
take,
notes
my lord,
filed
2 days to give them.
Written
And
notes filed by the appellant today be kept on record. Full stop. Let the matter be listed on December 22, 2025 under the heading to be mentioned for filing of written notes by the respondents.
I'm deeply grateful to your lord.
Yes.
Lordship, I'm speaking on behalf of the appellant.
Non-prosecution.
Yes, Lordship. What has happened, Lordship? The petitioner filed the writ petition annexing some documents. Those were not representations. Those were RTI applications. So, learned single judge, in my opinion, has rightly.
Fair enough.
Only, Lordship, may I get liberty to file a fresh writ after making proper representation?
That you always have. The learned counsel for the appellant submits on instruction that the appellant does not want to proceed further with the appeal. Full stop. Written instructions filed in that regard today be kept on record. Full stop. Accordingly, MAT 1735 of 2025 is dismissed as withdrawn without any orders to costs. ওটা নিন ধরে দাঁড়িয়ে when does it expire? Well, 15th of
I appear for Agarwala Company Limited. My pleadings are yet to be completed in Can 3 of MAT 2030. You can an extension.
I appear for the respond number 10 and 11. Union.
We'll extend the interim order. Yes. We'll extend the interim
Yes,
order.
and my lord will extend the time to file affidavits.
The lordship will also, our pleadings are also not completed.
My lord, there is a question raised by us, my lord, as to the maintainability of the appeal.
That is kept open.
So, my lord, I am told, my lord, there is a reference to the larger bench and that hearing is commenced. So, my lord, if it could be adjourned for 6 or 8 weeks, my lord.
We'll keep it after the vacation.
My lord.
the interim order granted earlier is extended till January 31, 2026 or until further order, whichever is earlier, full stop. Let the matter be listed next on January 12, 2026, full stop. The time for filing affidavits in opposition in the connected matters, comma, if any, comma, stand extended till December 24, 2025. Full stop. Replies, if any, thereto shall be filed on the returnable date.
Obliged to your lordship.
Grateful, Your Lordship, for giving the extension.
In appeal
Grateful.
2030, my lord,
Yes.
we have to file an affidavit in reply.
Let them file the opposition first.
Yeah, there are certain oppositions, my lord, lying with me, my lord. May I
Yes,
just file them. Or we'll file it on the.
All can be
my lord.
filed by after that.
Otherwise, my lord.
Because the records will become bulky.
Yes,
Obliged to your lordship.
all three
Grateful,
matters.
All the three matters.
Deep.
Give the appearances with the match numbers.
My lord, we'll just do that.
Yes.
Thank দীপঙ্করা যাসনি একা এত ভারীতে সম্ভব না The delay in depositing the special messenger cost is condoned and the special messenger cost is accepted. Which of the office shall take steps to call for the records immediately. Full stop, next para. The office shall, comma, upon the service having been effected, comma, furnish a further report in that regard.
I'm for the applicant, my lord. We are required to file an affidavit of service, my lord. The affidavit of service being affirmed, my lord.
It has been served.
Yes, my lord.
You know it has been served.
My lord, I'm told by my junior that it has been served, my lord. The affidavit is being affirmed, my lord.
We can give you leave to file during the course of the day and you move the matter in the meantime. Yes. After line leave is granted on the prayer of the appellant, comma, for the appellant to file the affidavit of service during the course of the day. Full stop. Since learned counsel for the appellant submits that service has duly been effected, comma, the matter is taken up for hearing. Yes. First, section 5.
Yes, my lord. Can one is section 5, right? There is delay of 179 days.
120. What is the reason? Mr. Bishash, what is the reason?
My lord, can you turn to page?
You were informed after 26 days.
Yes, my lord. Page 6 onwards, my lord.
The petitioner cites some delay in coming to know about the judgment of the trial court which has been challenged herein, as well as medical grounds, full stop, upon perusal of the averments made in the application for condonation of delay, comma, we are satisfied that sufficient explanation for the delay has been given. Accordingly, can 1 of 2024 is allowed, comma, thereby condoning the delay in preferring FMAT 206 of 2024. Full stop. প্রথমেই করে দিন যেখানে বলেছিলাম যে অ্যাফিডেভিট সার্ভিস লিভ দিলাম যে since none appears for the respondents despite service, comma, the matter is to be taken up ex parte, তারপর যা বলেছি। আচ্ছা, what is the appeal about?
An application under section 9 of the Guardians and Wards Act was filed before the London District.
You are the mother?
Yes, my mother.
What has happened by the impugned order?
My lord, the Lanet.
You filed the application?
Yes, my lord.
The child is with the father?
No, no. Father is dead, my lord. He had asked for a guardianship sale of the property where the minor share is there.
This is regarding property of the minor.
My lord.
What is the age of the minor?
At the time of filing of this petition before the London District Court, well, he was 10 years of age. Now he has attained the age of 15 years, my lord.
15 years. Achha, why was it refused?
My lord, it has been held that the petition is not maintainable, my lord. Relying upon a Bombay High Court judgment, my lord, the land court has held that it's not maintainable.
Find that the subject property being definite. An order whereby the appellant, comma, in the capacity of capacity of the mother and the natural guardian of her son, comma, her minor son, comma, who is now about 15 years old, comma, for dealing with the property of the minor. Full stop. Next para, we are informed that the father of the child, that is the husband of the appellant, has expired previously. Full stop. Next para, from the impugned order, comma, we find that the application has been dismissed as not maintainable on grounds which we do not find prima facie tenable in the eye of law. Full stop. Accordingly, the appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal. Full stop. You have annexed everything. The application.
Yes, my lord, with the
Their objection has been annexed.
objection has not.
Who is for the other side? Who is the other side? The respondent?
Well, they're the close relations who had gifted the property in favor of the petitioner's husband during his lifetime, my lord. And
so have them. They are virtually supporting your case.
yes, my lord.
So have them appear through somebody.
My lord.
We'll direct it a fresh service to be effected because there was no written objection filed to your application.
No, my lord. Nothing was filed.
Since the annexures to the application filed in connection with the appeal virtually contain all the relevant papers, comma, we dispense with filing of formal paper books and calling for the records. Full stop. Next para, as the disposal of Can 2 of 2024 shall tantamount to disposing of the appeal itself, comma, we direct the application along with the appeal to be listed for hearing under the heading application on January 6, 2026, when an affidavit, 6, 2026, full stop, further notice to the shall be served on the respondents, comma, including a server copy of the present order, and an affidavit of service in that regard shall be filed on the returnable day. You serve a copy of this order so that they know that the appeal will be taken.
And in course of they will file the affidavit of service, my lord.
After one other thing, my learned brother's copy is in micro Xerox this thing. Please file a better copy. This is not law college.
My lord.
Yes.
Well, affidavit service will file in course of the day, my lord.
That you do. Otherwise, this order goes.
My lord.
And better copy on the next occasion.
My lord.
You have it Xerox to itself. Yes. 7? 7 to her. Yes. 9 who is appearing?
I beg to appear for the appellant.
Yeah.
Would it be my lord's kind sanction to release this matter, my lord?
Yes. Why? I appeared.
Mrs. Chakraborty is the caveat.
The caveat.
View of in view of a relative of one of us within bracket Shobhoshachi Bhattacharya J, comma, having already entered appearance by lodging a caveat on behalf of the respondent, comma, let the matter go out of the list on personal grounds with liberty to the parties to seek an assignment before the Honorable the Acting Chief Justice before a different bench. Thank you. মামা যখন ডিটারমিনেশন নিতে আমারই অবস্থা
My lord, item number 10, I'm paying for adjournment.
You are for the appellant?
Yes, my lord. Kindly.
No, then it goes out of the list. On your mentioning, it has come. No adjournments on these matters. We can't include matters in the list
My lord,
because of these matters.
defective, my lord, remove, my lord.
What is the defect? Why did you mention the matter?
Means,
Why did you mention the matter for inclusion in the list if it is defective?
last Monday.
An adjournment is sought by learned counsel for the appellants at the time of call. Full stop. Next para, comma. Although the matter was included in the list on the mentioning of the appellants. Full stop. Next para. Defective. You are for the appellant?
Yes, my lord.
Let the matter go out of the list with a direction upon the appellants to file the certified copies of the judgment and decree of the trial court by January 9, 2026, full stop, liberty to mention the matter for inclusion in the list, thereafter, comma, upon curing the defect. Cure the defect, come back, I can go out of the list.
My lord, I am for the appellant, my lord.
I am for the respondent, my lord, appearing on caveat, my lord. But one thing I should indicate at the very outset, my lord, though I am on caveat, I have not been served a copy of any application.
My lord, it has not yet been admitted, my lord, since, and my lord, there is some minor defects, my lord.
Not admitted. You won't serve a copy on the caveator because it has not been admitted.
Caveat, my lord, filed, my lord, after institution of this
So what? You know of the filing of the caveat. You don't know that a copy has to be served on him. Whenever he files a caveat, you have to serve a copy.
I will definitely serve, my lord. I will
Why have you
definitely
mentioned
serve.
the matter without service?
Because, my lord, there was no caveat at the time of filing
You have
this
such a loud
appeal.
voice.
That's why
You should be ashamed.
No, my lord, I am my.
No, my lord. What no, my? Yes, yes.
I will definitely serve. I will.
Has lodged a caveat, given you a notice. You have not served a copy.
I will definitely serve.
It is unfortunate that despite having lodged a caveat, comma, the respondent has not been served with a copy of the connected application. Pusha, learned counsel for the appellants is directed to immediately serve copies of the memorandum as well as the connected applications on the learned advocate appearing for the caveat respondent during the course of the day. Pusha, let the matter stand adjourned till December 17, 2020.
In the meantime, my lord, some defects, minor defects are there, my lord.
Liberty to the learned advocate on record for the appellant to amend the memorandum of appeal for the purpose of rectifying the defects pointed out by
here and now I am correcting, my lord.
By the stamped reporter. Next. Correction. Give a copy right now.
Yes, my lord.
Appeal memo as well as the application.
Yes, details is on start for which.
Number 12.
My lord, Mr. Mukherjee is appearing for the my lord,
Mr. Mukherjee.
Mr. Prabal Mukherjee Senior.
Yes.
My lord, he's on his.
That is not a ground.
Lord,
you have to move the matter. We won't grant time in any of these matters because you are mentioning you are not being able to add other matters.
Short passover, my
No, no.
Passover,
You are the advocate on record.
No, I am not the advocate on record, my lord.
You are not in this matter at all.
My lord, I am assisting him, my lord.
You have to start the matter. Otherwise, it goes out of the list. The first few matters we are definitely not granting time because we are not being able to add other matters due to these matters.
Short passover, kindly, my lord. Short passover.
No, what is the matter about? You have to apprise us about the matter.
My lord,
we'll direct you to go out of the list otherwise. Start the matter. What is the matter? You have the file. You are not in the matter at all.
My lord, I'm not, my lord, prepared, my lord.
Prepare yourself right now. Move the matter. Otherwise, we will prepare and that may be at your risk. We don't require your assistance if you are not prepared. Why do you come to court then? I've heard us.
Put for my lord, declaration decreed by the trial court and subsequently it was upheld by the appeal court.
Evidence Act din to? Agar Evidence Act. Indian Evidence Act. Declaration of title.
Declaration of title. Title and possession.
They sought eviction or they are in
No,
possession.
no.
They are seeking that they are in possession.
The trial court did not.
Power of attorney holder was permitted to adduce evidence, although the plaintiff was present in court.
Yes.
Have you got a copy of his evidence?
Evidence, my lord, copy I have annexed in the can.
Which page?
Lord, 42 onwards.
Pardon?
42 onwards.
Which I am the plaintiff in this case. His name, what is his name?
My lord, his name is
Salimuddin is not a
Salimuddin
party.
is not a party. He is the power of attorney holder.
He says I am the plaintiff.
He says he is the plaintiff.
Oh no, then he says the original plaintiff has not come to court, etc. The original plaintiff never deposed.
Original plaintiff never deposed.
He sought for a declaration of absolute title or his share?
Absolute title with regard to
share.
The share. The undemarcated property?
No, declared to have absolute right titles over the suit property. Suit property is a share.
There are two schedules.
Yes.
Part they are claiming possession. They are claiming title.
They did not produce any partition deed.
No. There is in fact no partition deed at all.
They have not even claimed there is any partition.
Not even claimed.
15 decimal पे absolute title अच्छा बोले दिलो हाँ কিন্তু এখানে 15 decimal যে description রয়েছে হ্যাঁ তার উপর absolute This appeal will be heard on the following substantial questions of law. Whether the learned courts below substantially erred in law in relying on the evidence of PW1, comma, who is admittedly a constituted attorney of the plaintiff, comma, without drawing any adverse inference, comma, despite the PW1 having admitted that the plaintiff is in court, but the plaintiff having not adduced evidence in support of the plaintiff case, comma, particularly since there is nothing in the evidence of the PW1 which clearly indicates that he had direct knowledge of the facts involved in the case. Roman 2, whether the learned courts below substantially erred in law in declaring the absolute title of the plaintiff in respect of a portion of the suit property, despite the plaintiff stroke respondent number 1 having failed to show, plead or prove that any partition by metes and bounds has been effected in respect of the suit property. Full stop. Ground. Any interim, any application is there?
Application is there, my lord.
Mr. Mukherjee is in court.
Mr. Mukherjee is in court, my lord. Number
ঠিক আছে।
6.
Sir, I have the instructions to appear on the plaintiff.
We'll direct to serve copy. What is this stay application? Give a copy and come back then. Tomorrow we'll take up.
My lord.
Since Mr. Tiwari, learned advocate, appearing for the, who will be the advocate on record?
Aniruddha Tiwari.
Achha, Mr. Tiwari covers it. Since Mr. Tiwari, senior advocate, submits that Mr. Aniruddha Tiwari has instruction to appear on behalf of the respondent. Respondent number 1, obviously. Plaintiff stroke respondent number 1, let a copy of this stay application be served on Mr. Aniruddha Chatterjee during the course of the day.
Aniruddha Tiwari.
Aniruddha Tiwari during the course of the day. Full stop. The matter will grant, will consider ad interim order because it goes to the single judge.
Yes.
What stay of operation of the decree?
Stay of operation.
There shall be a stay of operation of the impugned judgment and decree till January 15, 2026 or until further order, whichever is earlier. Full stop. Liberty to the parties to mention the application and the appeal for inclusion in the list before the appropriate learned single judge, then having determination. You can mention it tomorrow also.
Great.
আগেরটা প্রবালের নামও ঢুকে যাবে appellant হয়ে yes
So one of the lordship, the plaintiff respondent lordship, the refuse I'm appealing showing the address is left.
you are appearing for the left person also?
All the respondents.
What's all? Well, move that. What is it?
So to 10 days.
There are 2 defects.
10 days.
No, not that. Not informed. Certified copies of decree of lower appellate court has not been filed. Decree of the first appellate court has to be filed.
Yes,
before order for 10, it has to be filed.
Yes, lordship.
Because the name of the parties could not be
So
verified.
we have subsequently applied, not available.
Appeal value furnished in instant memo does not tally with the certified copy of the trial court decree. No, unless you remove the defect, these defects cannot be. At the outset, we find 2 serious defects in the appeal. So first, certified copy of the decree of the first appellate court has not been filed with the memorandum of appeal, and as such, the name of the parties and other particulars could not be verified from the first appellate court's decree. Secondly, the value of the appeal furnished in the memorandum of appeal does not tally with the certified copy of the decree in the trial court, which all the more requires the certified copy of the appellate court's first appellate court's decree to be filed. Let the matter stand adjourned till after the vacation and shall be listed in the monthly list of January 2026. The appellant shall file certified copy of the first appellate court's decree in the meantime.
Because the landlord to supply memo of memorandum of appeal.
The affidavit of service filed to be kept on record. Since despite service not having been effected properly, the respondents are represented through their counsel today. Let copies of the memorandum of appeal as well as the connected applications be served on the said learned advocate having instruction to appear for the respondent.
The appeal has not been till date admitted.
By tomorrow. So it is made clear that the direction to serve copy shall not be construed as admission of the appeal. Thank you.
There is a delay of 10 days, lordship.
Serve everything.
Item number 14.
Yes.
Well, I am appealing on behalf of the appellant, my lord.
Yes. Now service has been effected?
Yes, yes, yes.
There is a section
Well,
5. Section 5.
Yes, section 5.
What is the delay?
60 days calculation. Well,
Good service effected?
yes, yes.
What is the reason for the delay?
Medical ground, my lord. I am 68, my lord, paragraph 14. My lord, paragraph 14.
You wait
I'm
till
18
paragraph 14 to give the.
I'm 18 years old, my lord, and I have
Very good.
seriously in the
From-
month of March 2025 and
Affidavit of service filed to be kept on record. Full despite service, none appears on behalf of the defendant's respondents. Full accordingly, we take up the matter ex parte. Full next para. We find from the application that the appellant is an octogenarian and was suffering from various ailments during the relevant period, comma, which prevented her from. But what about his son?
so as a power of attorney holder, my lord.
Yes, he could file the appeal on her behalf.
During the illness of the mother, he was busy with mother, my lord. That's why timely not filed.
কোনখানটা ছাড়লাম লাস্ট না ওটা না যে লাস্ট ওয়ার্ডগুলো from preferring the appeal personally, footstep, it has been pleaded in the condonation application that the son of the appellant, comma, who is her constituted attorney, comma, was also engaged in looking after the appellant during the relevant period due to her illness. Footstep, we are satisfied, comma, upon perusal of such averments that sufficient explanation for the delay has been furnished. Accordingly, can 1 of 2025 is allowed, thereby condoning the delay in preferring SAT 123 of 2025. Push up the said appeal is now taken up for hearing under order 14 rule 11 of the Code of Civil Procedure. Yes, what is the appeal?
Well, the brief fact of this case is that the plaintiff appellant is
This is a judgment of affirmance or
this is judgment?
Both courts, lost in both courts.
Yes, yes.
Right, yes. Brief facts.
The brief fact is that the appellant plaintiff instituted suit against the defendant respondent for cancellation of deed.
1 second.
And declaration of injunction.
Defects, other defects also. Decree signing date you have given in the memorandum of appeal. There is no separate date of the decree that you have to delete. Please follow the stamp reporter's report and make the correction.
Yes, ma'am. Today.
বলার আগে the appeal is now taken up for hearing এর ঠিক আগে একটা লাইন হবে. The learned advocate and record appearing for the appellant shall carry out the necessary amendments to the memorandum of appeal to rectify the defects as pointed out by the additional stamp reporter during the course of the day.
Yes, ma'am.
Even if you lose. Yes. What is the matter?
Well, to the appellant plaintiff instituted suit against the defendant for cancellation of deed and for cancellation deed and declaration of injunction. Subsequently,
Of what? Gift.
Deed. Thereafter, subsequently, the respondent defendant have filed the written statement, and thereafter, subsequently, the suit was dismissed.
No, deed was a gift deed executed by the appellant. When you say the facts, you have to be, you have to know the particulars of the fact. Mechanically reciting whatever you have noted, that won't do. You have to know what sort of a deed it was. If there's gift deed, our consideration should be different from a sale deed.
My lord. Let's see. Plenty copy. Registered date, well,
gift or sale
okay, no. Well, deed of sale deed.
You have not filed the trial court judgment and degree. You have to file certified copy of the trial court judgment degree also. Stamp report or sham report then. Ache. You have given only the filed only the appellate court judgment and degree.
Well, the
Trial court judgment degree has to be given. This is the second appeal.
Yes.
Then appeal is now taken up for hearing and order for turn হবে না ওটা. The appellant is directed to file the certified copies of the judgment and degree of the trial court by January 9, 2026. Full stop. Let the matter be listed under the same heading on January 12, 2026.
None.
Item number 15.
But I'm for the appellant.
Yes.
Please, Your Lordships, I'm appearing for the respondent in the matter.
But this is not
But before my learned friend starts,
দেখেছেন?
but before my learned friend starts, my lord, I'll not be opposing the condonation application. It's a 71 days delay, I believe. They're filing a supplementary, my lord. I'll not stand in the way. But only one prayer, because my lord, I have not been served with a copy of the stay petition and the memorandum.
There is no
for
stay
that
application.
in the memorandum of appeal.
There was
We've
no
not been
caveat.
served, my lord.
There was no caveat. Was there any caveat?
No, my lord. No caveat.
But since section 5 was there, your lordship directed me to.
What is the delay?
Delay 71 days, my lord. It was wrongly calculated. That's why, my lord, the supplementary affidavit on the last occasion, your lordship.
The supplemented affidavit and affidavit of service filed to be kept on record. Push up. Should we record, Mr. Bagh, your
May I only pray if it did not be recorded, my lord? Order.
upon hearing learned counsel for the parties, we find that sufficient cause for the delay has been explained. Accordingly, can 1 of 2025 is allowed, thereby condoning the delay in favoring SAT 253 of 2025. Push up. Since Mr. Bagh, learned counsel submits that he has instruction to appear on behalf of the respondents, push up, let a copy of the memorandum of appeal as well as the connected stay application be served on the learned advocate in record having instruction to appear for the respondent during the course of the day. Full stop. Let the matter be listed tomorrow for tomorrow under the same heading.
Very deeply.
Thanks.
Item number 16.
Item number 16, my lord, I am appearing for the plaintiff appellant. There is, my lord, delay of 150 days in filing the memorandum of appeal.
Your lordship.
My lord,
You have served on both the parties.
Yes, my lord, as per instruction of my learned advocate, my lord, I have served all the applications.
You are appearing for whom?
Respond number 1.
Number 2 did not contest.
No, number 2 did not contest at the trial court.
Are you sure? Please check up.
Yes, my lord.
You have checked up. You have checked.
150 days delay has been caused, my lord, due to that the appellate.
No, you have checked up that the defendant number 2 did not appear in the trial court.
No, did not appear.
Did we direct you to serve?
No.
Was there any direction to serve?
No, your lordship may direct to serve upon you, but he will not appear, my lord, he did not contest.
How did you get a copy? You wrote a letter.
No, he previously we have filed a caveat in this matter. That's why the learned advocate has served upon us.
Defendant number 2 is the owner of the land, my lord. He sold the property.
Preemption.
He suit for preemption.
Then we'll record your submission that he did not contest in the trial.
Yes, fine.
Very well. Since
Lordship, we want to use an affidavit. It's a 150 days delay. We want to use an.
Wait, since it is submitted by the appellant that the defendant stroke respondent number 2 did not contest in the trial court, copy service of copy of the application on the said respondent is dispensed with. Post up, the principal defendant stroke respondent is represented through counsel. What is the reason for the delay? You want to use an affidavit?
I want to use an affidavit.
Let us see what is the reason.
Yes.
21st January 2025, order
Yes.
has been passed by the learned civil judge senior division,
Right.
the trial court.
What is the reason for the
But
delay?
against the on the refusal of interim order under order 39 rule 1 and 2 reduced 151.
Reason for the delay?
Reason for the delay, my lord, at the initial stage, my lord, the plaintiff appellant filed the misappeal before the learned district judge, which is, my lord, pecuniary jurisdiction barred, as the, my lord, appeal value is 8,60,000. Therefore, the my lord,
A 75 years old fell ill.
yes,
Why are you?
75 years old.
We'll make it an order of the court.
And my lord,
Your Lord,
as per
Will you
provisions of the Bengal, Assam,
Upon hearing, the present condonation application has been filed on the ground that the appellant is aged about 75 years and suffered from various ailments during the relevant period. First up, application is vehemently opposed by learned counsel for the defendant stroke respondent number 1. First up, however, upon hearing learned counsel for the parties, we find sufficient credible reasons having been furnished for the delay in preferring the appeal. First up, accordingly, can 1 of 2025 is allowed, thereby condoning the delay in preferring FMAT 425 of 2025. The appeal is now taken up for hearing under Order 41 Rule 11 of the Code of Civil Procedure. Yes, what is it?
my lord, the plaintiff is the appellant before your lordship.
Suit for?
The plaintiff has filed the suit for preemption
Under Mohammedan law.
Section 231, 232 of the principles of
Mohammedan
preemption
law,
on
yes.
Mohammedan.
Why refuse? That is
Kindly come to the plaint, my lord. My lord, order is at page 32. Order is
yes, but there is, you have seen the impugned order.
not yet, Your Lordship. We have not.
When you lodge a caveat, you should take a copy of the order.
Your Lordship, the caveat has been lapsed. That's why the memo of appeal has not been served up.
When you lodge the caveat initially, you did not have a copy of the order. Whenever you lodge a caveat, we have a copy of the order.
I have annexed this order upon the injunction petition also.
Then look into the I have not gone through the injunction.
Yes, not gone through because I've been led by Ms. Manali Ali in this matter.
Maybe we will set aside this order right now.
Your Lordship,
see, we are telling you the reason. On perusal of the case record together with the documents, it could be prima facie found that the plaintiff is the adjacent owner of the issued property as he has purchased the southern side of the property and defendant number 1 is a stranger purchaser, and considering provisions of 236, plaintiff has sufficient material to go into trial. But at this stage on perusal of the documents, this court does not, on the basis of the possibilities that may happen, pass an ad interim order restraining defendant number 1 such and such. This is a ridiculous order.
Your Lordship, this is second round of litigation, Your Lordship. Previously, it has
maybe, but at this stage, at the expert stage, you were not even there.
Your Lordship,
so there today application should be taken as sacrosanct.
Your Lordship, today I'm not ready with this matter any day, Your Lordship.
No, your Lordship, then either we admit the appeal and grant injunction and wait for eternity when the appeal is disposed of, or we dispose of the appeal, direct the injunction application itself to be decided quickly, and you file your written objection thereto. We'll restrict the time.
Your Lordship, the injunction shouldn't be passed today. For
injunction will be passed. Injunction either during pendency of this appeal, which will you will be languishing in this court for I don't know, we don't know how long. Yes, or we'll dispose of the appeal itself and direct the learned trial judge to decide the injunction
then
application.
Make it just a not today.
No.
I will come back tomorrow.
When you are not seeking your instruction.
No, Your Lordship, no, Lordship.
You choose either of the two.
Your Lordship, then don't dispose of the appeal itself.
Very well.
Don't dispose of.
We find from the impugned order that the plaintiff stroke appellant has filed a suit for preemption under the Mohammedan law. In the impugned order itself, the learned trial judge observed that on perusal of the case record together with the documents, it could be prima facie found that the plaintiff is the adjacent landowner of the A schedule property as he has purchased the southern side of the property being C schedule property, and the defendant number 1 is a stranger purchaser, and considering the provisions of section 236 of the Mohammedan law of Muslim law of preemption, the plaintiff has sufficient material to go into the trial. However, even after observing the same, the learned trial judge, surprisingly, observed that at this stage on perusal of the documents annexed, the court did not, on the basis, on the basis of possibilities that may happen, pass any order of ad interim injunction as prayed for. We fail to understand the logic, which is we fail to understand such conclusion, which was patently contrary to the findings of the learned trial judge himself. Even on the papers on record, we prima facie find a sufficient case having been made out for grant of injunction. Accordingly, the defendant number 1 you have prayed for.
Defendant number one.
Accordingly, the defendant stroke respondent number 1 shall remain restrained by an ad interim order of injunction from changing the nature and character of the suit property and or from disposing of the same and or from creating any third party interest in respect of the suit property till disposal of Can 2 of 2025. Full stop. Affidavit in opposition to the said application shall be filed by the respondent number 1 by December 24, 2025. Full stop. Reply, if any, shall be filed by January 9, 2026. Full stop. The application shall be listed for hearing on January 12, 2026.
Your Lordship, my submission should also be noted. My three submissions in respect to that should also be noted in the.
Should have made the submissions before.
Your Lordship, my only submission is the preemption suit filed beyond a year. The beyond a year and the mutation was done. We are in the possession of the suit property, and
we'll consider that. Don't transfer the property, change the nature and character. We have not said don't disturb possession. We have said don't transfer the suit property, don't change the nature and character. That presupposes
just
probably
the
that you will.
submissions, if the submissions have noted, because otherwise
no, after submissions are made after next.
Item number 17, my lord. Same appellant, same plaintiff appellant.
What is different?
The difference, my lord, if this is the separate deed told to the defendant number 1, the same delay, my lord. Same plaintiff appellant, same delay, and according to Bengal Bear Assam Civil Courts Act, my lord, the appeal was preferred by the plaintiff appellant and
যেটা আগে অর্ডারটা দিয়েছি
সেম
দুটো একসঙ্গে করে দিন করে প্রথমেই বলুন both the appeals are taken up together in view of the identity of the subject matters of the same and the parties they are not the same.
Parties they are, my lord, dependent number 1
and the parties কথাটা তো দরকার নেই যেটুকুনি বললাম আর এই পুরোটা প্লুরাল করে দিন both them at the same order. Please come back on the rest. Next.
18, my lord, same. Also 19.
Up to which item?
18 also same.
19.
Up to which item?
Up to 19.
19. You have got copies in all matters?
I've got only Can 1 and Can 2 in all the matters, not the memo of appeal.
No, memo you are not entitled.
Yes, I'm not insert.
So, all the 4 appeals are taken up for hearing today. যা বললাম যেটা 2 এর বদলে 4 প্লুরাল করে দিন otherwise similar.
Also item 25 also is the same.
Otherwise similar.
Similar.
25 also same.
Yeah, 25
is section 5 already earlier.
On earlier occasion, item number 25 was taken.
These matters were previously
have the file of 25.
These matters have previously been heard by your lordship. These are the
25 file টা
section 5 allowed.
Sorry. এটা চারটি ম্যাটার এটা 4 করে দিন
199 injunction 199
বোর্ডে 25 দেখাও
last order
199
last order
199 তুলেছে বলে আমাকে জানাওনি তো
ওনার কপিটা দাও
199 ওখানে কি 199
না এটা অন্য দেখিনি আগে Now 25 will take separately.
Yes.
25 is there is a ground of limitation specifically mentioned in the order itself.
Yes, Lord.
The other 4 matters were identical copy paste of the
copy paste, but there is also the limitation point.
Point is there. We are directing to file opposition.
That's why
take every point in the opposition.
Yes,
you have not disclosed. That's why you didn't.
Yes.
But 25 will take separately, Saudi Gari.
Yes.
25 এখন টাকা দরকার নেই সাইড করে যখন কল সিরিয়ালি কল 25 এ অন্য কিছু আছে specifically order লেখা আছে
20 I appear for the appellant, my lord.
Yes.
So this is one matter where your lordship had the occasion, my lord, to previously pass an order in the circumstances, my lord. Just to recapitulate your lordship, my lord, I'll just place the order passed by your lordship on the last occasion.
Yes.
My lord, that's at page 114 onwards. your lordship would remember, my lord, this is
In a
pertaining.
different appeal. In a
This is
different.
a different appeal by a different plaintiff. Why I am showing this? Because it will be easier for your lordship, my lord. Because my prayer is very simple, my lord. I am only seeking modification, my lord, which will not aggrieve the defendant as well, because it was the prayer of the defendant in the injunction application. But the court, yes, the order 39 rule for application.
Page 114 is that
Your lordship's order. Where, my lord, the joint.
no caveat here.
No caveat, my lord.
Would be better for if there is a caveat.
Yes.
This could be disposed of.
This could be disposed of because kindly sees, my lord, the scope of the application under order 39 rule 4, page 98. And prayer portion, your lordship will directly come at page 100.
So first let us see our order. Yes.
Yes, yes. This is the order whereby your lordship, my lord, had appointed the joint special officers for conducting the election of the council, because the council became defunct.
The appellant is the same now.
No, appellant is not the same, my lord.
You're the other side.
They are the other members. They are the other members of the council. My lord, this is a different suit.
You are on the same footing as the previous appellants.
Yes, footing is the same because here the issue is, my lord, with regard to the operation of the. Yes, I'm sorry.
Oh, the previous committee has defunct, but there is a gap in the rules as to what happens.
Yes, they have.
And we interpreted that, and we.
Yes, committee was appointed in presence of both the parties. Now what happens?
We were appointed for holding election.
Yes. Yes, holding election.
Then
now, my lord, what has happened, my lord? We had prior to this filed a suit by a different person because the erstwhile secretary, my lord, were acting towards the rules, and my lord, he was operating the bank accounts. So, my lord, the scope of the suit was to restrain him. Thereafter, my lord, an order 39 rule for application came in, wherein, my lord, I'll show the scope. My lord,
different suit.
Different suit. I just placed the order for your lordships, my lord. Now,
but the same council, same
council. Now, my lord, kindly sees what is the prayer there. Page 112, this prayer in the order 39 rule for application.
You filed the order 39?
No, the defendant filed.
You got an injunction.
I got an injunction restraining the, my lord, the erstwhile.
Ad interim injunction.
Ad interim injunction.
Page 112
is the prayer, my lord. I'm only in short, I'm showing, my lord, the prayer, the scope of the prayer. I am happy if this prayer is allowed. What the court did, court exceeded its jurisdiction and only granted permission to the, my lord, the president, which cannot be, that is dehors the rules. I'll show, my lord, kindly comes to page.
So you would be happy if president and treasurer both are allowed?
Both, because both has to be, that is the rules.
Treasurer is your man.
It has to be both. Kindly comes to the rules once, page 75. That is the rules, my lord. I am not asking for something which is not there. Rule 8C, my lord, which says, my lord, it has to be joint signatories. Either the treasurer or the secretary or the president. So secretary is no more there. Lord, he has retired. So it's only the
page 75 C.
C, custodian of funds.
Let us see the impugned order once.
Yes. The impugned order starts at page 132, my lord.
We'll just see from the memo. It will be easier for us.
Your lordship will only look into the ordering portion. Your lordship will find, my lord.
What is the reasoning given by the trial court?
Lord, I do not find any reasoning, my lord, to be very honest. Lord, perhaps the reasoning is that since the election is upcoming, if there is no funds, what will happen?
No, that is fully.
But that cannot.
You are agreeing to that, in fact.
But that cannot be because it has to be jointly operated. Cannot be a single person. Because your lordship order says in terms of the bylaws.
Oh, we said that the president would hold the election in assistance with the joint administrator. That was taken by the trial court to mean that the
misconstrued, my lord.
So let us see that portion of our order once. It cannot be go contrary to our own order. We also have to see that.
Paragraph 9.
Paragraph 9.
That's a very. Under the aegis of the president. এটাকে ইকুয়েট করে ফেলেছে প্রেসিডেন্ট ইলেকশনটা হোল্ড করতে পারে ওদের নিয়ে স্পেশাল অফিসারদের নিয়ে বাট
and your lordship will kindly see paragraph 10 as well because with the erstwhile executive committee of the said council, which includes the, my lord, the treasurer, not the president alone. Because there was an allegation of defalcation of funds against the president. Paragraph 10 as well, my lord, of your lordship's order.
That's a fair.
11 as well, my lord, in consultation with the
The
committee.
present appeal arises out of the present appeal arises out of an order whereby an application under Order 39, Rule 4 of the Code of Civil Procedure, filed by the defendants stroke respondents in a suit challenging the operation of the respondent number 1 council by the erstwhile members of the executive committee has been inter alia challenged. Next para, by the impugned order, comma, the learned trial judge modified an ad interim order of injunction passed by the learned trial judge by allowing the erstwhile president of the defendant number 1 society to operate the bank accounts of the same. Next para, learned counsel for the appellants rightly points out that the impugned order was beyond the prayer made in the vacating application itself, comma, which sought for the president as well as the treasurer to operate the bank account of the respondent number 1 society. Next para, we find from the impugned order that the learned trial judge proceeded on the premise of a previous order passed by this court in connection with an appeal taken out of a different suit but challenging the same challenging the functioning of the same erstwhile executive council. Although the learned trial judge proceeded on the premise that since the president was directed by this court to hold the elections with the help of the special officers stroke administrators, comma, we find from the said order, the said judgment stroke order dated July 10, 2025, passed in FMAT 261 of 2025 and FMA 857 of 2025, that we had observed that the election shall be a fresh election of the council shall be held under the AEGIS of the president of the erstwhile executive committee with the help of the independent administrators who were appointed by this court. It is conspicuous, it is to be noted that we further observed that the joint administrators shall hold the election of the respondent number 1 hyphen council, double inverted, with the assistance of the president of the erstwhile executive committee of the said council, double inverted close, we had further observed in the said order that all arrangements for the said election shall be made by the president, double inverted, in consultation with the erstwhile committee members, double inverted close, comma, strictly in accordance with the rules and regulations of the respondent number 1 hyphen council. From regulation 8 within bracket small c of the council, comma, we find that the funds of the council shall not be used or invested for the personal gains of any member of the council, and there shall be a bank account in the name of the council. It further provides that the president, comma, general secretary and treasurer would be entrusted with the task of operating the savings bank account. Next para, thus, comma, both as per rule 8 within bracket small c as well as the prayer of the defendants respondents themselves in the vacating application, comma, it was necessary for both the president and the treasurer to be directed to operate the bank account. Accordingly, an arguable case has been made out. FMAT 456 of 2025 is hereby admitted, comma, to be heard on the above questions as well as the other grounds taken in the memorandum of appeal. Next para. There shall be during pendency of Can 1 of 2025, comma, there shall be a stay of the impugned of the order impugned herein, comma, with a rider that both the president of the erstwhile council as well as the treasurer of the said council shall, comma, in terms of the prayer made in the application under Order 39 Rule 4 of the Code of Civil Procedure made in the trial court, comma, be entitled to operate the account in question, that is bank account number 20014820804, held with the Indian Bank, comma, Calcutta main branch in the name of the respondent number 1 council, full stop. Next para, the application shall next be listed on January 12, 2026. Full stop. The appellant shall serve copies of the memorandum of appeal as well as the application on the defendant stroke respondents, indicating the next returnable date, comma, if possible with a server copy of this order, and file an affidavit of service to that effect on the returnable date.
Lordship could have disposed of the appeal. But
Could have, they're not appearing.
They're
That's
not,
why.
that's
That's why we said that it will be
nothing
beneficial,
remains basically.
beneficial to you if they appeared, and to them also.
No, he had prayed for an adjournment on the last occasion. They were aware. I do not know. I expected them to appear, my lord.
Exactly.
Nothing is there.
We have allowed their prayer only. In the
Yes, because nothing is there in the appeal.
Number 21.
Should I appear on behalf of the appellant?
Yes.
Lordship, this is my appeal challenging and
First, let us
refusal
check up
of
the
an-
defect. You should have checked up. Why should we check up? Your appeal, your defect. Classification furnished in words erroneous. What is appeal from this order passed? You should have. Anyway, leave is granted. No, the learned advocate and record for the appellant is directed to carry out the necessary rectification to the memorandum of appeal during the course of the day. The report of the additional stamp reporter. Yes, what is the matter? Do that immediately.
Yes.
Irrespective of the result.
Yeah.
Yes.
Lordship, this is challenging and refusal of my adding order of injunction.
No caveat. No caveat.
No caveat.
What is
In
the suit
a
for?
suit for specific performance where I've already put in substantial amount of 22 lakhs.
Put in means in the court?
No, I've already made over to them by
You
bank
produce
transfers. Yes, the bank transactions.
Very well. Then why refused?
And Lordship, there were 2 plots, and there was certain, when we checked up the records, we saw that there is a name of a particular person who has been recorded as a Borgadar. So we requested the owner, and that was the understanding that they would take steps to remove that name. And Lordship is aware these are all departmental things, although a timeline was set, but time not being the essence in a.
He was to do it.
He was to do it. He could not do it, and he kept us that we have already proceeded with the initiation of the process. It is taking some time. That took us through some period, and thereafter 2 letters were given by us that we call upon them that either you do it or you sell it to us, and then we rectify.
Letter from their end in the interregnum.
Nothing.
No, they do not write to you that we are taking some time.
No, these are all oral communications, because we call up and we request them what is the status.
Then
They
you
do
wrote
not.
the letters, then what happened?
And nothing. They are still sitting silent over it.
So why refused injunction?
Yes.
Delay.
The court holds that since there is a clause of cancellation in the agreement, hence all that you can get is refund. Lordship, the impugned order would appear at page 65 of my application, and on the memo it's already there. I was relying upon the last paragraph of the first page. Simply on that score. And the court records that all that I can get is I can get back my money. Which I have paid in advance.
The present appeal arises out of the refusal to grant ad interim order of temporary injunction in a suit for specific performance filed by the plaintiff stroke appellant. First, যাচ্ছি না? First, বলে বলে। Appellant in the code below. Push up next para. The case, comma, as per the plaint as well as the temporary injunction application in the trial court made out by the plaintiff was that in pursuance of an agreement for sale dated July 15, 2023, comma, the defendants stroke proposed sellers, proposed vendors were to were to take steps for rendering the property free from Borgadar and obtain clear marketable title within the time period stipulated in the agreement, that is 60 days. Full stop. Next para. In the agreement itself, comma, it was mentioned that the purchaser, within bracket present appellant, comma, may at its own discretion either give 2 months grace period to the owners to fulfill such obligations or call upon the owner to refund within 30 days the entire amount paid together with interest at the rate of 18% per annum. Who's up next para? Proceeding on the basis of the said clause, comma, the learned trial judge refused to grant ad interim injunction, comma, on the apparent premise that the relief of the plaintiff lies by way of refund of the advance money along with interest as provided in the agreement. However, comma, we prima facie find that the learned trial judge failed to take into consideration the position of law that on the on the failure of one of the parties to perform his part of the contract, comma, whereas the other party has performed the said party apostrophe s part, comma, it was a discretion and the option of the second above mentioned party either to call off the agreement or to seek specific performance of the same. Full stop. The above principle is based on the premise that one cannot take advantage of one's own wrong. Full stop. Next para. Moreover, comma, as per the pleadings of the plaint and the injunction application, comma, there was communication in the interregnum between the parties whereby the appellant insisted upon performance of the agreement and granted further time by implication to the defendants to do so, as well as wrote letters to the defendants stroke respondents to perform the latter apostrophe s part of the contract. Push up thus, comma, we find that a prima facie case for grant of injunction as prayed for was made out in the trial court on the strength of the agreement between the parties, comma, which was refused by overlooking the aforesaid aspects by the learned trial judge. Full stop. Accordingly, the appeal is admitted and shall be heard on the grounds taken in the memorandum of appeal as well as the above questions. Full stop. Next para. The defendants stroke respondents and or their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, comma, encumbering, and or creating any third party interest and or dealing with the suit property till disposal of the application. Full stop. The application shall next be listed on January 12, 2026 under the heading applications, when an affidavit of service shall be filed by the appellant, comma, the appellant shall serve copies of the injunction application as well as the memorandum of appeal on the respondents indicating such returnable date in the meantime. Full stop. Affidavits in opposition and reply, comma, if any, shall be exchanged in the meantime.
I'm so grateful.
My appeal, my lord, I have not checked, my lord, what the defects are. I should have. There are some defects, my lord, as I.
Your Lordship, I appear for respond numbers 1 to 4, Your Lordship. I beg to appear virtually.
Yes, yes. Let us just check up the defects first. Someone has filed the Vakaladam as considered attorney, your power of attorney has not been filed. How soon can you file it? Ask.
Milord, the power of attorney we can put in, Milord, in course of
In course of
today. In course of today.
today.
Yes, Milord, that's what my next.
Very well. We find at the outset that uh, there is a defect pointed out by the additional stamp reporter to the effect that the person who signed the vakalatnama on behalf of the appellants has not filed his power of attorney. Full stop. Upon query of court, comma, learned counsel for the appellant submits on instruction that such power of attorney shall be filed during the course of the day. Full stop. Accordingly, the appellants are directed to file the power of attorney during the course of the day. Full stop. Next para, the appeal is now taken up for hearing under Order 14 Rule 11 of the Code of Civil Procedure. Yes.
Milord, there might be one more defect. I should indicate that first. Milord, Order 39 rule for application of my learned friends was allowed by passing the impugned order. Milord, there are two sets of Milord Order 39 rule for application. One by different numbers 1 to 4, the other one by different numbers 5 to 9. Both of them succeeded by a single order. Milord, a single appeal is filed.
They have not taken that objection. Is it?
I think, Milord, my duty to indicate, so Milord, I just indicate. By a single order, the reasonings are same, but Milord, by a single order.
Two. Anyway, what is the merit?
Yes, Milord. Kindly take, Milord, this, Milord, family tree, Milord. Without this, Milord, it won't be possible for any of us, Milord, to understand. Milord, this is with regard to, Milord, I just indicate what is the suit was about.
Exactly. Just give us the basics.
Yes. Milord, the suit was, Milord, for declaration, for, Milord, injunction, for cancellation of instruments, etc. Declaration that, Milord, I have, Milord, right title interest in the suit property. Cancellation of instruments, Milord, executed by my learned friends in favor of others. And also, Milord, instruments executed in their favor.
Showing themselves to be the owners.
Yes. And, Milord, one set is, Milord, are showing themselves as the owners. The other set are developers appointed by the other set. 1 to 4 are, Milord, projecting themselves as the owners. 5 to 9 are, Milord, the developers who have been appointed or engaged by the 1 to 4. Now, Milord, this ownership, according
related to you in any manner.
Milord, remotely, distantly related. Now, Milord, kindly take, Milord, this chart, Milord, this family tree. Milord, the original owner, Milord, of the property, Milord, this is in, Milord, undisputed position was this Mary Winfred.
Anglo-Indian family.
Yes.
Yes.
But the names are very difficult, Milord, for me to utter. Milord, Mary Winfred Arle was the first.
Utter two of the most difficult ones, then we'll consider your case favorable. Let us choose the third one, Mr. Cyril.
Milord, he is on my side.
So mention your client's name. Anyway, what happened?
Yes, I just indicate. Milord, this Mary Winfred Arle was the, Milord, owner of the property. She, Milord, executed with.
Are these admitted? Where do we differ from their case?
Milord, I will indicate that also where we are differing. Mary Winfred Arle, Milord, indisputably was the owner. Executed a will, Milord gave it to Neville. Milord, on the right hand side, second tier.
You are Neville's side or?
Milord, I'm on the other side.
Sorry.
Neville. Milord, it was given to Neville.
Your Lordship, I beg to intervene, Your Lordship. Their application and the text thereof states something completely different. There they allege that Redmond Percival Maurice Earl and Neville William Earl were bequeathed the suit property, Your Lordship. That is what their application states.
They start from Redmond and Neville.
Yes, they start from Redmond and Neville. We start from Neville only. They are now saying that they start from Neville, even though in the trial court they stated that they start from Redmond Percival Maurice Earl and Neville William Earl, Your Lordship.
Achha, let Mr. Banerjee complete, then we'll permit you, Mr. Theory, to.
Grateful, Your Lordship.
Yes.
Now, Milord, by virtue of the will of Mary, Milord, this comes to Neville. Neville, Milord, executes a will, Milord, giving the property to Shoti Bhushan Dotto and Herbert Cyril Lloyd. Now, Milord, the will by which, Milord,
they gave only to Herbert.
No, Shoti Bhushan and Herbert. Both of them were legatees, Milord, under the will of, Milord, Neville.
But in your chart, you have shown Shoti as only the executor.
Milord, that's not, Milord, correct. Milord, he was executor cum legatee. My Lord will kindly take it from me. Milord, there are some, Milord, mistakes in the chart. Shoti Bhushan Dotto was, Milord, executor cum legatee. Herbert Cyril Lloyd, according to them, was the residual legatee.
Yes.
Now, Milord, Herbert also, Milord, executed.
Residuary legatee. After lifetime of Shoti.
Milord says, Milord, everything has gone to Soti. Milord, what was left under the will, Milord, according to the will, Harbert was entitled to that.
If everything was given to Shruti, how can that?
Milord, major chunk of it was given to Shruti. Milord, the residual part of the estates of the deceased, Milord, was given to Harbert. Now, Milord, Harbert, Milord, also, Milord, executes a will. And Milord gives it, Milord, according to them, Milord, to Augustine Robert de Cruz. Milord, the next year. Now, Augustine, Milord, gets a probate of Milord Herbert's will. But Milord Neville's will was never probated. Herbert, in his will, Milord, attempted to bequeath what he was supposed to get, Milord, had Neville's will been probated. Now, this Augustine, he, Milord, apart from getting a probate of Herbert's will, also applies for letter of administration of Neville's will and gets it.
So putting the cart before the horse.
Yes.
All right.
Now, Milord, we say since Neville's will was never probated, and Milord, this was at a point of time when Christian's will, Milord, were also supposed to be, Milord, were to be probated under the law. So, Milord, since Neville will was never probated,
Now Christian wills are not.
Milord, possibly no.
I'm not sure on
Possibly no. Milord, I'll show Milord the provision. Possibly no. After 1969,
they have been exempted.
Oh, 2002. 2002.
They've been exempted from the Indian Succession Act. This
Yes, Milord, probate is no more required. Probate is, Milord, no more required.
So at that point of time,
it was required.
Required.
It was required.
Yes.
Now, Augustine gets a probate of Milord Herbert's will and gets, Milord, a letter of administration of Neville's will. Milord, this Shoti Bhushan Datta, who was the sole executor appointed under Neville's will, Milord, he renunciated. He did not act as executor. Now, Milord, our case was, since Neville's will was never probated, Neville's property, Milord, will not, Milord, go by, Milord, testamentary succession. Milord, that will fall back upon intestate succession, and Milord, this estate of Neville will, Milord, now go to, Milord, Clarence Broderick Edwin's, Milord, Edwin Arles, Milord, legal, yes. Milord, at the, Milord, left mode.
What happened to Redmond?
Milord, Redmond, Milord, he died intestate and Milord was issueless also. ঠিক আছে. Milord, there is no legal heir from Milord Redmond's branch now.
Who are these people? Unadopted means?
Milord, I'll come to
Stepchildren, Your Lordship. Stepchildren.
Milord, I'll come to that. Milord, even if Redmond's, Milord, legal heirs are there, Milord, a portion of it will come to, Milord, Clarence Broderick Edwin Arles branch. Milord, if Neville's will is not probated. And Milord, we are, Milord, at the bottom on the left hand side, Milord, this Rosemary and Milord Margaret. So we say, Milord, we have an interest in the property. Which Milord?
Margaret is the who is she?
Margaret is, Milord, daughter of Anastasia.
Very well. David was the son and he
Yes.
died, his wife.
Rosemary is David's wife.
Very well.
Now, Milord, this was our case. Milord, we filed a suit.
The entire case is based on Neville's will not being probated.
Milord, we filed a suit, got an expert interim order of injunction. My learned friends, Milord, filed 2 sets of 13-4 applications
saying they won't be able to transfer in it.
Yes. So that there is no transfer, no alienation of, Milord, that Neville's estate.
Then what happened?
Now, their 13-4 was based on, Milord, section 104 of the Indian Succession Act. They say,
Succession Act, Indian Succession Act. একটু অ্যালার্ট থাকবেন যখন মামলাটা হচ্ছে।
আরে আসছি না।
হ্যাঁ, একদম। থ্যাংক ইউ।
They say, I'm sorry, Milord.
Yes.
Immediately, by reason of section 104 of the, Milord, 1925 Act, Milord, immediately upon the death of, Milord, the testator, Milord, the legacy gets vested. And Milord, he gets, Milord, an interest in the property. So, Milord, they want to say, the moment Neville died, Milord, Herbert got, Milord, an interest in the property, which stood automatically vested by operation of law. That's their case. And so, Herbert, Milord, could have, Milord, bequeathed the property, this estate which stood automatically vested in him by reason of section 104, he could have bequeathed it, Milord, to Augustine by executing a will. That's, Milord, their case. Milord, and they say, Milord, I have suppressed in my application that, Milord, this Augustine De Cruz, my lord, had also got a letter of administration in respect of Neville's will. That's the suppression that I have made according to them in my suit and in my injunction application. Augustine got a letter of administration in respect of Neville's will. That is what I had, my lord, suppressed.
Augustine was also one of the legatees in Neville's will.
No.
Could she get a?
But he got a letter of administration.
You are admitting that she got?
My lord, they have produced, my lord, in their order 13 rule for application and order. My lord, what I had asserted in my injunction application was that, my lord, there was no probate granted in respect of Neville's will. I have never said that, my lord, this person has got letter of administration.
On the ground of suppression.
Yes, this suppression.
Not merely this, Your Lordship. We have many allegations of great many factums that have been suppressed.
Anything else, Mr. Banerjee?
I may now show the order, and my lord, this 104 has been completely misinterpreted. My lord, this vesting of legacy, now, my lord, the honorable courts have held so. My lord, this is a limited vesting. My lord, this is not absolute. It's not that, my lord, once, my lord, the testator dies, though, my lord, there is no probate, my lord, automatically gets vested and he becomes the owner of the property. My lord, this vested is a limited, my lord, vesting. This is not vesting in possession. This is vesting in legacy. And, my lord, I have personally, my lord, a doubt whether, my lord, 104 applies, my lord, to Christian wills because of section 57 of the Act. (57) says, my lord, to whom, my lord, this part would apply. And, my lord, there Christians are, my lord, not there.
Set out in Schedule 3.
Schedule 3, my lord, I'll take your lordships too. But, my lord, kindly just have a look at section 57 first. And this 104 comes under, my lord, part 6.
It does not speak out. Part 6, yes.
Chapter 6.
But it says.
Schedule C. No, my lord, kindly take Schedule.
This part which is set out in Schedule 3.
Kindly take Schedule 3, my lord, side by side. My lords have kindly got, my lord, Schedule 3.
Yes.
Provisions of Part 6 applicable to certain wills and codicils described in section 57. So, my lord, it again falls back upon section 57 only.
104 is there.
104 is there. Now, my lord, section 57 says the provisions of this part which are set out in Schedule 3 shall, subject to restrictions and modifications, apply to, my lord, then, my lord, it indicates to whom it would apply. My lord, C is to all wills, codicils made by any Hindu, Buddhist, Sikh, Jaina on or after the 1st day of January 1927. My lord, Neville's will was of, my lord, 1958. 18 July 1950. I'm sorry, 16th February 1955. After 1927. Now, if my lords kindly, my lord, again come back to Schedule 3. My lord, there are certain notes, my lord, appended to this schedule. Restrictions and modifications. Nothing therein contained shall authorize a testator to bequeath property which he could not have alienated inter vivos. So, my lord, Part C also says, Schedule 3 also says that, my lord, if I was, my lord, unable, not in a position to transfer something by, my lord, way of inter vivos transfer, I could not have bequeathed it, my lord, by a will. Here, my lord, Herbert Cyril did not get the property. Could not have, my lord, made a will. And, my lord, grant of letter of administration did not decide title.
No, one says nothing herein content shall
authorize a testator
to bequeath property which he could not
my lord,
fail
I
in.
take Herbert as the testator here. Herbert is giving what he was supposed to get from Neville to, my lord, Augustine under his will, which Herbert couldn't have done because of this.
But if 104 is not applicable at all, then this also is not.
Correct. My lord, in case it applies, then also.
Your Lordship, again,
It applies, it's a catch-22 argument you are making. In case it applies. then Herbert has the right.
No, I'm sorry, my lord, subject to correction, of course, by
104 then
lordships.
applies.
If 104 applies.
If 104 applies, only then restriction will also come in.
Correct. So, my lord, if 104 applies, 104 would apply along with the restrictions.
Yes, restrictions say nothing here in content shall authorize a testator to bequeath property which he could not have alienated inter vivos. But if 104 is applicable, then he could have.
Minute, I was reading it otherwise. Minute, I'll come to that. Firstly, minute 104, subject to minute my limitation of
says,
understanding.
Let us boil it down to 57 says 104 does not apply. Let us forget the other things.
Very well. Minute, it's for them.
57 says 104 does not apply to Christians. Your argument, second argument is based on if it was applicable.
Correct.
Your premise of saying that Herbert did not have the right is that 104 is not applicable.
Right.
See, if 104 is applicable, then this restriction also does not come in.
Restriction then comes in possibly. Minute.
Restriction says nothing there in content.
Yes.
Shall authorize a testator to bequeath property which he could not have alienated inter vivos.
So 104 will not authorize Herbert to bequeath something.
But if 104 is applicable to Herbert,
yes,
then he is entitled to alienate inter vivos. Because 104 would permit him to. Do you understand, Mr. Banerjee?
I am, it's my incapability. Nothing therein, nothing
about
in section
Kalidas,
104.
same branch. That principle applies. Kalidas principle. This is called the Kalidas principle.
Very well.
So same branch.
Very well.
Here, your very premise of saying that Herbert did not during his lifetime have alienated the property.
Because he did not get it from Neville.
Because he did not get it from Neville, that argument is premised on 104 is not applicable.
That argument is premised on two things.
Taking
Firstly,
104 is
not
applicable. If you say 104 is applicable to Herbert, then he not having capacity to alienate does not apply.
104 is
by
not,
virtue of 104.
104 is not a proposition that says that even if there is no probate, by reason of simply 104, the beneficiary would get an interest in the property immediately after death of the testator. That is not what 104 says.
It speaks about legatee.
It speaks about an interest in the legacy. It says.
So let us come to your second argument. First argument first.
Now, kindly, and the suppression was only to the extent, according to them, that I suppress this letter of administration granted to Augustine de Cruz.
They say there are other suppressions also.
I will show from the 39(4) application and also from the impugned order. They had argued before the learned court and also before this honorable court that there was a probate granted in respect of Neville's will, which is completely incorrect a statement. Neville's will was never ever probated. Now, when it comes to letter of administration, Augustine had
this appeal because hearing. So
the job is a little now. Minors will have some comfort because of this order passed by an honorable coordinate bench. From the probate proceedings also, an appeal was preferred before the honorable coordinate bench, where there has been an injunction order passed. Restraining all the parties. Yes.
So we are directing the appeal to be heard.
And in the meantime, this direction may continue in this appeal also.
Direction is already there.
That may continue in this appeal also.
Any direction passed in view of that order is where I'll join some issues, my lords.
We are not recording anything on this order at all.
Lordship, over here, just
we are putting the appeal for hearing immediately after. We are admitting it. Questions are arguable. We admit the appeal. We direct it to be heard. All the papers are annexed to the.
Yes, everything is there.
Lordship.
If something is left, then we'll direct you to put in your affidavit in opposition. Otherwise, we'll say you are denying all the allegations made in the application and proceed on these papers.
Your Lordship, the issue here is this: the way in
we
which
hear the appeal on merits. We are not saying that we are.
It's subject to final hearing in the court below. Your Lordship, the issue is this: the way in which the submissions have been cast before your Lordship, as though all these facts were already there before the learned trial judge when the ad interim order was moved. That is not the case, your Lordship. This question of letters of administration being granted in favor of Augustine Robert de Cruz, that is the father of the respondent numbers 1 to 4.
Anyway, we are not hearing arguments now. We'll hear after the vacation.
The Lordship's not.
We'll just admit the appeal.
Lordship is not contemplating any order of injunction as of this point.
No, we are not contemplating. We are looking at, not contemplating. We're looking at a different.
Lordship can look at it. Lordship may not contemplate it in this matter.
Upon hearing learned counsel for the appellant, we find that sufficient arguable case, a prima facie arguable case has been made out as to whether the appellant was guilty of suppression of material facts, entitling the learned trial judge, comma, as done in the impugned order, comma, to vacate an ad interim injunction initially obtained by the appellant. Full stop. Questions arise as to whether the provisions of section 104, comma, read in conjunction with section 57 of the Indian Successions Act would be applicable to the matter, as well as whether the suppression was not only limited to the issue of no probate having been obtained for the will of Neville William Earl, Neville William Earle, Earl, but to other suppressions as well. Full stop. Accordingly, we admit the appeal to be heard on the above issues as well as the grounds taken in the memorandum of appeal. Full stop. In view of the interim order sought being virtually akin to the order which may be passed finally in the appeal itself, comma, we decide to hear the interim application along with the appeal itself. Pusab, since the papers annexed to the interlocutory application are sufficient to decide the appeal on merits, comma, we dispense with service, we dispense with preparation of preparation of paper books, and shall hear the appeal on the papers already on record. Full stop. We also dispense with calling for the trial court records to expedite the matter. Full stop. Since all parties are represented before us, comma, service of notice of the appeal is also dispensed with, and the appeal be treated to be ready as regards hearing. Full stop. Let the appeal be listed in the month list of January 2026 along with the connected application under the heading application. It will appear under the heading application so that we can take up quickly.
I'm grateful.
We are not passing an interim order.
I'm grateful.
We are not saying that we are not passing, but we are not passing.
Grateful, Your Lordship. Because the
Yeah,
issue is,
the
Your Lordship,
affidavit of size failed to be kept.
Injunction
Section
application is
58
kept for
resolves the issue of Section 57. Section 58 says generally this part
These are
applies.
arguable questions raised by them. We have not decided anything on that.
Well, the
We'll meet
injunction
those arguments, Your Lordship.
Yes.
Injunction application is going to be heard finally by the learned trial court in February. Milord, so may it be Milord a little Milord in the top of the Milord monthly list of
No.
January.
It's hard out, it's hard out. At interim stage, observations do not bind the final temporary injunction stage. So why are you worried on that?
Right.
Rather, if we go against you, that may create problem for you. And them also, the other way.
We'll keep our fingers crossed for the first one.
Milord, I don't
Yes,
see any
Your Lordship.
possibility of pilots going against me in this matter at least.
I'm so grateful.
Grateful to your Lordship.
Stop the next matter after 10 minutes. This matter is over.
Grateful.
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 আপনাকে দিয়েছি আপনাকে দিয়েছি অন্তত এই অবস্থা খারাপ হয়ে যাচ্ছিল
Item number 23. I appeal for the appellant in this matter, my lord.
size. Yes, Ms. Oja, what is it?
Yes, Lord, I am led by Mr. Siddhartha Banerjee in this.
Mr.
Mr. Banerjee in this matter, my lord.
Yes.
Comparatively simpler a case, my lord. My lord, I purchased a property, my lord, from surface sale.
No defect.
All right.
Should be admitted on that ground. This is the first appeal probably from the morning.
But
Last
my lord,
week,
we desperately need, my lord, an injunction order.
then we are very hesitant. What is the matter, Mr.?
I just indicate.
Yes,
My lord,
yes.
I am, my lord, an auction purchaser.
No caveat is there.
No caveat. My lord, this is from, my lord, an order granting status quo in my favor. My lord, I am not happy with status quo on alone. My lord, I want, my lord, a positive order of injunction.
Give us the nature of the suit.
Yes, the suit is for declaration of title to the property. My lord, that was
Trying
unnecessary.
to interdict surface action.
Not challenging surface action, based on surface action. I tell your lordship, I am the auction purchaser.
First convince Ms. Oja that you're entitled and then
No,
because
I am.
she'll be appearing for the bank in most of the matters.
Miller, no challenge has been thrown to any action taken under Surface Act. Rather, Miller, Surface Act Miller has been relied upon.
Surface Act আছে
It says Miller, any person aggrieved by a measure taken under Section 13(4).
True.
That's what Miller, the opening words of Section 17 are.
Absolutely. We have held that also in case.
So Miller, this is
Anyway, what is your suit for? Title declaration.
title declaration. That is an unnecessary prayer, but made in the plaint. And Miller, perpetual injunction is Miller the ultimate relief which Miller we are asking for, so that Miller the defaulting borrowers, the mortgages, Miller they do not Miller stand in the way of my free ingress, egress, and utilization of the property.
You are a co-owner.
No, I am auction purchaser.
Auction purchaser in a previous purchase.
In the loan purchase, Miller, the property was put on sale, Miller, once only. I purchased the property in auction. Miller, the defendants default.
Purchase on auction.
I
The
purchased
entire property.
entire property.
Then what are you apprehending now?
Now, Miller, they are causing disturbance in my egress and egress of
He means the
the
previous.
defaulters.
But you should have got clear position.
Miller, I have been Miller handed over the possession.
After that.
After that,
Why was it refused?
Miller,
I mean, why?
status quo, only status quo. Saying nothing, says that Miller, I have made out a prima facie case, so order of status quo, as if Miller, both parties are to Miller now. Miller should maintain status quo as regards possession of the property. Miller, this is absolutely vague and somehow Miller grants an injunction against me.
You are protected.
Miller, it is Miller kind of a vague order. Miller, if I may say so at all.
Status quo as regards nature, character, and position. You are in position.
Miller, I am in position, but Miller, I am not being allowed. Miller, I put it under lock and key. This is Miller for commercial purpose. The property was purchased. I do not stay there, Miller, overnight. So, Miller, when I come out and then Miller in the morning, Miller, I want to get into the property. Miller, there is an obstruction.
The present appeal has been preferred against an order whereby, on an application filed by the plaintiff stroke appellant, that is the auction purchaser of the suit property, inter alia seeking injunction restraining the defendants from obstructing the plaintiff apostrophe's free egress and ingress into the suit property
and utilization of the property,
and in disturbing the plaintiff apostrophe's utilization of the suit property, the learned trial judge has merely granted a general order of status quo in respect of the nature, character, and position of the suit property, directing the same to be maintained by both parties. Learned counsel for the appellant submits that in view of the vague nature of the status quo order, the defendants respondents may take undue advantage of the same and carry on disturbing the ingress and egress of the appellant to the suit property. Next para, the premise of the suit is that the appellant, being an auction purchaser, was handed over clear possession of the suit property. However, the original mortgagors, on whose default the auction purchase took place in the first place, being the present defendants stroke respondents, have since been disturbing the nature and character, disturbing the plaintiff's ingress and egress to the suit property, as well as enjoyment of the same. Trespassing, we can understand, lawful possession, we can understand, Mr. Banerjee, but what about this changing nature character? That means they're in possession. How can they change nature character? You have asked for that also.
Well, kindly have a look at
Did
my
you ask
prayer.
for that in the trial court?
Page 45, my lord, is my prayer in the injunction application. Page 45.
You have prayed the injunction here before this court, beyond your prayer in the trial court.
My lord, kindly restrict me, my lord, to the prayer.
So
made in
next
the
para.
injunction application.
Thus, comma, we find a prima facie case for hearing the appeal on merits. So accordingly, the appeal is admitted and shall be heard on the questions formulated above, as well as the other grounds taken in the memorandum of appeal. Full stop. Next para. There shall be a stay of operation of the impugned order till disposal of the application, comma, subject to the rider that the defendants, respondents, and/or their men and agents shall remain restrained during pendency of the application from illegally trespassing into the suit property, as well as from unlawfully obstructing the entry or access of the plaintiff and/or wrongfully interfering with the plaintiff's lawful possession stroke occupation of the suit property in any manner whatsoever. First of the appellant shall serve copies of the memorandum of appeal as well as the application on the respondents, indicating that the application shall next be listed on January 19, 2025, when an affidavit of service to that effect shall be filed by the appellant. Full stop. The affidavits, comma, if any, shall be exchanged in the meantime in connection with the injunction act.
Grateful, my lords.
Yes.
24, I am for the appellant petitioner for company.
Here for the appellant, right?
Already in this matter, my lord,
Yes.
your petitioner company offered or financed a loan amount of rupees 48 lakh rupees.
You took a loan?
No.
Or you are finance company.
Respondent took loan.
Right. Yes.
48 lakhs rupees 87,846 as the monthly EMI of payment of monthly installments of
Please
rupees
repeat the amount again.
48 lakhs 87,846.
Yes.
Took loan for purchasing a vehicle for the business purpose. And my lord, monthly installments of payment of rupees 1,10,019 paisa. Monthly installments commencing from 7th January 2024 to 7th October 2028. 7/10/2028.
Right.
Now, my lord, respondent S.K. Nodulul Islam have become defaulted, and in apprehension of seizing vehicle, he has filed an application under Order 39 Rule 1(2) before the Honorable City Civil Court for injunction, and in this matter, he got injunction. And taking advantage of the ad interim order of the injunction, an injunction order extended, and taking advantage of the ad interim order of injunction, respondent absolutely stopped to pay the amount.
Achha, have you initiated surface action?
No, my lord.
If you have not initiated, then they have a right now. Because unless 13th stage comes, tribunal won't have jurisdiction.
It's my lord, loan EMI case, my lord, agreement for loan agreement case, my lord.
Let us see his injunction application or plaint. Let us see his plaint. You have annexed that.
My lord, kindly see the order, my lord.
No. First, let us see the plaint. We will come to the order. Does it say that he has taken the loan? He has admitted.
Yeah, loan agreement is there, my lord. My lord, kindly come to my memo of appeal, my lord. It is annexed in the memo of appeal. Suit for declaration and page number. Memo and permanent injunction
Cannot be annexed to the memo of appeal.
Yes, my lord.
Cannot be annexed to the memo of appeal.
Yes. Certified copy of memo.
Oh, certified copy.
Yes, my certified copy.
Annex it to the main.
My lord, I have challenged the order dated, my lord.
3rd of
December
3rd
2025.
December, yes. Let us see that.
And along with my lord, I have annexed in the memo of appeal suit for declaration and permanent injunction.
Never do that. Annex only the certified copy.
Yes, my lord.
Anyway, let us see. Yes. You had already obtained an ad interim injunction.
Yes,
They
ma'am.
had already obtained an ad interim. Then you appeared and this is on contest.
Yes, my lord. And my lord, 3rd December 2025, Honorable City Civil Court had passed an order. My lord, kind of last paragraph, my lord. And ultimatum is given there, my lord. My lord, from the last 5 lines, if any, it has not given them any authority to take the law in their hand and to act like a dictator. Defendant company is hereby directed to return the vehicle within 7 days. In default, court
So
shall.
it says that you have violated the ad interim order of injunction and seized the vehicle. There was an injunction order.
Yes, sir.
There was an injunction order from taking forceful possession. Despite that, you had taken possession.
Attempted to take the possession.
What attempted? You have taken possession. You have been directed to return the vehicle. You cannot violate an order of the court. We cannot give a premium to you. You should have gone and just have that injunction order vacated. If there is an injunction, you cannot violate that. Sorry.
Well,
We won't
that's why
interfere. We are dismissing the appeal. You have liberty to have that order vacated. Go and have that order vacated. We'll make it clear that this does not prevent you from having the ad interim order vacated in due process.
Well, because they have totally stopped the
You
EMI.
cannot violate an order of the court. Sorry.
Well, kindly admit my appeal, my lord. Then
Definitely not. Definitely not. You are a violator of court's orders. Your appeal should be dismissed with costs. Why did you take possession like this? Court is absolutely right. You cannot act like a dictator and take possession in violation of an injunction order. Did you take a point that you were not aware of the injunction order? You have not even filed an application. What is the 151 for? You have filed an 151 and 151 application that was dismissed. What is that 151 application? Where is that?
my stay application.
The very first line of the order says that it's on the 151 application filed by you. Where is that application?
That was filed by the defendant, plaintiff.
Plaintiff.
Yes, plaintiff.
No, along with hearing of the petition filed by the defendant, what is that petition? Your petition?
We filed for the vacating of the injunction order. Last date we have filed on petition for vacating of the injunction order as they are not paying the EMI.
Now, vacating your entered. We want to see a copy of that 151 application.
Yes, sir, 151.
Just give a copy of that 151 application. Or if you have annexed, just tell us where.
Just one copy, my lord.
One copy.
Why one copy? That is the only document that has been decided by this. Why did you ask for, you filed this application for
So this was not
help
filed.
and assistance for taking physical possession?
So this is not filed by us. This is filed by the petitioner.
Plaintiff petitioner. But the order says 151 by defendant?
No, sir.
Oh,
We are not filed any.
No, order says that they filed 151.
Yes, sir.
And also an application filed by the defendant.
Yes, sir.
What was your application? That is what we are asking. The first sentence of the impugned order says today is fixed for hearing of the petition under section 151. That is their application.
Yes,
along with hearing of the petition filed by the defendant and filing WS. That was for filing WS.
Yes, sir. The date was fixed for filing one copy. This application was filed on the previous date.
Next date is fees for 18.
One page application for filing vacating.
Also, they have not served the copy of plaint and injunction.
We'll make it clear that this will not prevent you from moving or vacating application before the court. But the present appeal arises against an order whereby an application, although captioned under section 151 of the Code of Civil Procedure, but in the nature of mandatory injunction, filed by the plaintiff stroke respondent, has been allowed by the learned trial judge. Full stop. The plaintiff stroke respondent filed the suit from which the appeal arises, for declaration that the plaintiff is entitled to ply a vehicle bearing number WB 53 capital C 7055 peacefully without any disturbance and or interference by the defendant, and inter alia seeking injunction protecting such possession of the plaintiff with regard to the vehicle. Full stop. Next para. By an ad interim order dated June 3, 2025, the learned trial judge had granted granted injunction restraining the defendant stroke appellant and their men and agents from seizing and or taking forceful possession of the said vehicle from the possession of the plaintiff without due process of law. Full stop. Next para. However, in violation of the said order, the possession of the vehicle was taken by the appellant. Full stop. Next para. Simultaneously, the appellant filed an application, filed a half-page application seeking vacating of the ad interim order, whereas the plaintiff filed an application. Plaintiff filed the application in question under section 151 of the code for getting back possession of the vehicle. Full stop. Next para. By the impugned order dated December 3, 2025, the learned trial judge granted such mandatory injunction, directing the present appellant to return the vehicle to the plaintiff stroke respondent within 7 days, since the possession was taken in stark contravention of the ad interim order of injunction passed by the trial court. Full stop. Next para. We do not find any infirmity or illegality in such impugned order, since any action taken in violation of an ad interim order passed by the trial court ought to be negated at the inception. Full stop. Hence, since the possession of the vehicle was taken in contravention of and in violation of the ad interim order passed by the learned trial judge, we do not find any illegality on the part of the learned trial judge in directing restoration of possession of the vehicle to the plaintiff stroke respondent. Full stop. Next para. Accordingly, FMAT 490 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Full stop. Consequentially, Can 1 of 2025 is also dismissed. Full stop. There will be no order as to cost. Full stop. Next para. However, we make it clear that nothing in this order shall prevent the defendant stroke appellant from filing a proper application under Order 39 Rule 4 of the Code of Civil Procedure to vacate the ad interim order dated June 3, 2025, passed by the learned trial judge. Full stop. If such an application is filed, the learned trial judge shall decide the same upon giving opportunity of hearing to both parties in accordance with law, without being influenced in any manner by any of the observations made by the impugned order or by us. Full stop. We also make it clear that it will also be open to the defendant stroke appellant to file a written objection to the injunction application and, if necessary, have the main injunction application heard along with the vacating application. Full stop. It is expected that if a vacating application is filed within a week from date, the learned trial judge shall make all endeavor to dispose of the same as expeditiously as possible, if necessary, along with the main injunction application, positively by the end of January 2026.
This agreement has arbitration clause also.
Go and take all the points. You have not filed a section 8. Arbitration is waivable.
Yes.
If you don't file a section 8, the court will proceed. You know that.
So,
Take all your points in the trial court, but you cannot take position in this manner. We have made it abundantly clear that if you file a regular order 39 rule 4, that will be decided independently. Do that and have the order vacated and then enjoy your vehicle. Yes, next.
May please your lordship.
Yes, Mr. That
I'm
is that,
appearing
the other
for
matter.
Plaintiff appellant.
Let us hear
My lord,
this.
here the learned my lord civil judge senior division passed the order rejecting the interim application under order 39 rule 1 and 2 read with 151 CPC only on the ground that this is the time limit bar under article 97 of the limitation act. Now my lord kindly come to the my lord section 236 of the Mohammedan law.
We don't have it.
Principal section
মোল্লার মোহামেডান লোকে আমাদের আছে এখানে? মুশকিল নেই। একটা মোল্লা আনিয়ে নেবেন। লাইব্রেরিতে আছে, দুটো কপি আনিয়ে নেবেন। We don't have Mullah's Mohammedan law in this court till now. It was never required, that's why it's not.
আমাদের আরেকটা বই ছিল তো।
Read it out for us.
No person is.
This is probably the original book which Mullah wrote.
Yes.
The first print.
Mohammedan law. No, Hidayatullah.
This is Hidayatullah?
Hidayatullah.
Very good. Yes.
Demands for preemption. No person is entitled to the right of preemption unless he has declared his intention to assert the right of immediately on receiving information of the sale. My lord, that is the talab-i-muasibat. Talab-i-muasibat. And my lord, subsection 2, he has with least practicable delay affirmed the intention referring expressly to the fact that the talab-i-muasibat has already been met and has made a formal demand, either in the presence of buyer or the seller or the premises which are the subject sale and at the presence of at least 2 witnesses. My lord, as per plaint and also my lord application under order 39 rule 1 and 2, there is specific pleadings and averments that the land is sold secretly behind the back of the without notice or without offering sale to the plaintiff. And also my lord, after hearing the sale proceeds, when my lord the defendant has come to take possession, then the plaintiff immediately my lord immediately completed his formalities talabi-muasibat. And after that, my lord, immediately jumped and my lord, he completely completed formalities, the talab-i-ishad at the presence of witnesses appearing at the spot of the, my lord, suit land. Now, my lord, I am coming to the, my lord, deed executed by the, my lord, defendant number 2.
একটু লিমিটেশন একটা দেন।
এই যে ডিড, দুটো ডিড আমি এখানে রেখেছি। Article 97, that is my lord preemption of 1 year.
Yes, yes.
But there is exception under section 17. If there is concealment about the fact and my lord concealment and mistake and fraudulent transfer, then my lord there is exemption. My lord, kindly see the deed executed by the defendant number 2.
Why are you going further? Please come to 97 itself.
Yes, my lord, I have gone through the 97.
No, 97 is in your favor. 97 says 1 year, not
1
from
year.
this.
That is 1 year. But there is exception, my lord, kindly come to the section 17 of the Limitation Act.
You did not go there. 97, please come to 97 once. Please come there. 1 year is not from the deed of sale. Deed.
Yes, physical possession.
1 year from when the purchaser takes under the sale ought to be impeached physical possession of the whole.
Physical possession.
You are saying that when he came to take possession. So
came to
your
take
limitation is
possession
saved by this itself. Why should you go to 17? Why should you go to either 17 or Hidayatullah? Limitation Act is saving you. At least an arguable case subject to hearing them. As per the Limitation Act itself, when the purchaser takes under the sale ought to be impeached physical possession. So
physical
if your
possession.
plain case is that when they came to take possession,
Yes,
then you got
he
knowledge.
had, yes,
So that is sanctioned by Article 97 itself.
yes,
Why should you go further? Show us the plain pleading on that.
yes.
What when he
My
came?
lord, paragraph number 7.
16 December
330.
16 December 2024. When did you file the
Yes,
suit?
6,
When did you file the suit, Mr. Adhikari?
18th January 2025.
Arguable case. We'll admit that on this question. By the impugned order, comma, ad interim injunction sought at the behest of the appellant, a plaintiff stroke appellant, in a suit for preemption under the Mohammedan law was refused primarily on the ground that the suit was barred by limitation, comma, apparently by placing reliance on Article 97 of the Schedule to the Limitation Act 1963. Full stop next para. However, comma, the appellant has raised an arguable question as to whether, comma, at the ad interim stage, comma, the pleadings in the plaint and the injunction application are to be taken as sacrosanct for the limited purpose of deciding whether the plaintiff is entitled to injunction on such pleadings, comma, since the pleadings of the defendant are not available at that stage, comma, on which premise the starting point of limitation of Article 97 being when the purchaser takes under the sale sought to be impeached, comma, physical possession of the whole or part of the property sold, comma, and it has been pleaded in the plaint itself that the possession was sought to be taken by the defendant for the first time on December 16, 2024, and the suit was filed on in the month of January 2025, comma, the learned trial judge erred in law in refusing ad interim injunction on the ground of limitation, comma, despite an otherwise prima facie case for grant of injunction having been made out. For the next para, the appeal will be heard on the above question and the other grounds taken in the memorandum of appeal and is accordingly admitted. Full stop. The principal defendant stroke respond number 1 and his men and agents shall remain restrained during pendency of the injunction application from changing the nature and character of the suit property and or creating any third party interest during pendency of the application. Who's the next para? The respondent shall file his affidavit in opposition to the injunction application by December 24, 2025. First reply finish shall be filed by January 9, 2026. The application shall be listed next on January 12, 2026. Full stop. In view of appearance of the principal defendant stroke respondent, comma, service of notice of the appeal on the defendant is said defendant is dispensed with. Full stop. Since no, we are not dispensing with service on the other defendant at this moment, but if necessary,
copy to be served upon us of the.
Oh, a copy of the memorandum of appeal as well as the application shall be served
No,
on the learned
application served.
advocate.
the, my lord, application has already been served upon him.
Application served.
A copy of the memorandum of appeal shall be served on the learned advocate for the respondent number 1 by the appellant during the course of the day.
Your Lordship, in other matters also, the Lordship not directed for serving the memorandum of appeal.
What were the numbers of the other?
16 to 19.
16, 19 কে নিয়েছি আমি
বলো
মেঘনাথ একটু বলে দিও যে
My lord, interim order.
the appellant shall serve copies of the memorandum of appeal on the respondent number 1 during the course of the day.
My lord, interim order is granted not to change the nature and character of the property.
As well as transfer. We'll vacate the transfer portion.
Yes, transfer.
Very good.
Should not be.
This comes from
Yes.
your learned friend's cottage industry. These matters. When I used to sit in his bar, we used to say that he runs a cottage industry. Now it has become a full-fledged industry. MSME Act governed by the MSME. Yes. Yes. Area থেকে না একটু আলাদা আলাদা নাম্বার ফেলে বুঝলেন
Item number 26, my lord, I am appearing for.
Yes, yes, yes.
Have you permitted? My lord, the appeal concerns, my lord, an order granting status quo, my lord, in connection with
So
the suit for
one thing
partition.
your application does not contain any caveat note. You have to take a report regarding caveat. Without that, we cannot take up the application. Please, Mr. Banerjee, please ensure that it is done. We'll keep it day after tomorrow so that you can
My lord,
have it in the
I'll do it
meantime.
in the course of the day.
In course of the day, where we will send the file to the department for the limited purpose.
My
We
lord.
find at the outset that there is no caveat report on the back sheet of the application which has been filed in connection with the appeal. Accordingly, leave is granted to the appellant. Accordingly, the office is directed to give a caveat report by tomorrow. For such limited purpose, the file be sent down to the department during the course of the day. The matter shall be listed under the same heading on December 17, 2025. এটা অনিন্দিতা এটা আপনি ইয়েকে পাঠিয়ে দিন ডিপার্টমেন্টে। আচ্ছা, we are keeping it Monday on Monday. It cannot be done during the course of the day. তাহলে during the course রিপোর্টটা যেটা বললাম যে during the course of the day বললাম নাকি বললাম একটা ওই অফিসকে যেটা করতে বললাম সেটা বাই ডিসেম্বর 17, 2025 অফিস যেটা করবে। হ্যাঁ, the matter shall next be listed on December 22, 2025 under the same heading. ঠিক,
Grateful.
থ্যাংক ইউ। বাট অফিসকে পাঠিয়ে এটা বলে দিতে হবে যে ক্যাবিনেট রিপোর্ট করে দিতে হবে, কি করে ছাড়ে জানি না।
My lord, I am for the, my lord, plaintiff appellant before your lordship, my lord.
27, my lord, I am for the respondent. My lord, before my
affidavit service, my lord.
My lord, before my learned friend starts, my lord, only one thing, my lord. Respondent number 5, my lord, died prior to filing of this appeal. In the suit, my lord, they have filed a substitution. That is, my lord.
No, you have to include them before moving the matter. Learned counsel for the contesting respondent submits that the respondent number 5 has met her demise. Noniwala met her demise prior to filing of this appeal, and appropriate steps for substitution of her heirs has already been taken in the trial court by the plaintiff appellant himself.
Yes.
Accordingly, on the prayer of the appellant, leave is granted to the learned advocate on record for the appellant to to carry out the necessary amendments to the cause title of the memorandum of appeal as well as the connected application, by deleting the name of respondent number 5 and incorporating the names of her heirs who have already been substituted in the trial court. Such corrections shall be done by tomorrow. Let the matter be listed under the same heading on December 17, 2025. We have given you till tomorrow. The affidavit size file to be kept on record. But do it during the course of the day if you have the names. If you have the names, please.
Yes, certainly, my lord. The
Just
application
give
is
him a
here.
copy so that he can do that. It will come up day after. Thank you very much.
Caveat nahi, thoda to caveat karo.
28.
My lord. 20, I am for the, my lord, plaintiff, my lord, petitioner before your lord.
28.
28, my lord.
Plaintiff petition.
My lord.
Yes.
Suit for, my lord, partition and injunction.
No caveat.
No caveat, my lord. My lord, in this matter, my lord, the father of the plaintiff, my lord, purchased the, my lord, land in the year 1977. And thereafter, my lord, in 2022, the father of the plaintiff, my lord, gifted the property to the, my lord, present petitioner before your lordship, plaintiff petitioner before your lordship. And my lord, the other plot owners, my lord, they disturbed my peaceful position, my lord.
He was a co-sharer.
We have
He purchased the share. Father purchased the share.
Yes, my lord.
Father purchased the share or the entire property?
Father purchased the share.
So that was transferred to you.
Yes, my lord.
The other co-owners are disturbing.
My lord. Thereafter, we approached the, my lord, learned executive court, my lord. The, my lord, kindly see page 31, my lord. And the learned executive court, my lord, holding that the dispute is
executing court,
my lord. Executive magistrate, my lord. Page 31, my lord.
How does the magistrate's order matter?
they disturb my position, my lord. So the plaintiff approached previously before filing the suit.
So
Approached
he granted a 144.
that is a new act, my lord, 163.
Yes, 163.
B
That was granted in your favor.
No, court holding that the dispute is in civil nature. Thereafter, my lord, suit filed. And in the suit, my lord, the plaintiff took out an application under Order 39 Rule 1 and 2, read with Section 151.
No, but your original deed contained a demarcation, specific demarcation. It contained demarcation. Do you understand the question?
My lord, I have.
Are you understanding our question?
Yes, my lord.
What have you asked you?
My lord, demarcation in my deed.
In your deed, there was a demarcation.
Yes.
That could not be shared.
But
how can you get an injunction regarding a particular portion of the property if you are a pusher?
But my lord, the learned court below, my lord.
Court is right.
Holding that, my lord, kindly the impugned order, my lord.
We have seen the impugned order. You read it out?
My lord, you
have seen the
relevant portion, my lord.
And it's a good order, actually.
My lord, the paragraph 11, my lord.
We have read it. You can read it.
Last line, my lord. The dispute on title is substantial and, my lord, triable. My lord, my humble prayer, my lord, during the pendency of the suit, my lord, the interim order may be granted, my lord. Otherwise, my lord, they are trying to, my lord, dispose my client, and, my lord, they are, my lord, the installing the petrol pump there in, my lord. So, my lord, also they, my lord, transferring the property by way of lease, my lord.
যদি মার্কেটের কোশ্চেন ছিল সেল করে সেলটা অটোমেটিক্যালি ভিসুয়েটেড হয়ে যাচ্ছে কিনা the plaintiff stroke appellant filed the suit, comma, from which the present appeal arises, comma. You have filed the suit for partition also.
My lord.
Inter alia for partition and consequential reliefs on the strength
page 16
of a transfer deed executed by the plaintiff's father in favor of the plaintiff stroke appellant, who, comma, in turn, comma, had purchased the property in the year 1977 by a registered deed. Full stop. By the impugned order, comma, the learned trial judge dismissed the temporary injunction. This was at the administrative stage, it was dismissed. Administrative stage dismissed. Dismissed the temporary injunction application of the plaintiff stroke appellant altogether at the administrative stage on the ground that the transfer deeds relied on by the plaintiffs contain specific demarcations in respect of the subject of such transfers, which, according to the learned trial judge, runs contrary to the fact that the predecessor in interest of the plaintiff and his vendor, comma, in turn, comma, had acquired only shares, undemarcated shares in the property. Full stop, next para. However, comma, we are of the prima facie view that even if there were specific demarcations in the transfer deeds, comma, despite transfer of specific portions of the property by a co-sharer not being permissible, comma, a question arises as to whether such transfers would take effect to the extent of the shares owned by the transferors, comma, which would entitle the plaintiff to maintain the suit for partition. Full stop, next para. The present appeal is admitted and will be heard on the above questions and on the other grounds taken in the memorandum of appeal. Full stop, next para. The defendant stroke only, you have sought for injunction against only 1 and 2.
Yes, my lord.
The defendant stroke respondent numbers 1 and 2 shall remain, and not the main and agents shall remain restrained by an order of injunction from changing the nature and character of the suit property and or altering the status quo with regard to possession in respect of the suit property in any manner till disposal of Can 1 of 2025. Full stop. The appellant shall serve copies of the application as well as a copy of the memorandum of appeal on the defendant stroke contesting respondents, indicating that the application shall next be listed for hearing on January 19, 2026, when an affidavit of service to that effect shall be filed by the appellant. Push up. The service of notice is dispensed with for the time being on the respond numbers 3 to 9 in view of no relief having been sought against the same against those respondents either in the trial court or before this court.
Right. Okay.
Number 29.
I'm for the 29, my lord. Yes. I'm led by Miss Susmita Shahadatta, my lord. I'm for the
Mr.
appellant.
Mr.
Miss Susmita Shahadatta. I'm led by Miss Susmita Shahadatta, my lord.
Start the matter.
Well, I'm for the plaintiff appellant, my lord, in
Right.
this matter, my lord. Partition suit.
Name of the presiding judge, do you know that? It's not there in the memorandum of appeal. Oh, you have subsequently rectified.
My lord, it was.
Yes, rectified.
My lord, the fact of the case is that, my lord, one partition suit is filed by the plaintiff, my lord, appellant, my lord, and thereafter, my lord, the plaintiff came to know that the partition suit was filed against my mother and the other brothers, my lord. And my lord, subsequently, my lord, the plaintiff came to know that the sum of the portion of my mother is transferred to the sister-in-law of my two brothers.
Is transferred, already transferred?
By way of deed. My lord, thereafter, my lord, I filed as order 1 rule 10, my lord, application, my lord, to substitute to add the part as a party of my lord. Thereafter, my lord, without hearing my application, my lord, the injunction application was heard, my lord, and thereafter, my lord, that was rejected on ground that, my lord, I have not added those parties, my lord.
You had filed the order 1 rule 10.
Yes, my
It
lord.
was already on record when this order was passed.
Yes, my lord. The order 39 rule 4 filed on 5th of August 2025.
39, not 39.4, order 39 1 and 2.
Order, my lord, no, my lord. Yes, my lord. And thereafter, my lord, they have filed one order 39 rule 4 application, my lord, petition, my lord, on 5th of October. My lord, 5th of August 2024, my lord, and on that.
You have challenged the 8th of August order.
Yes, my lord. Yes, my lord. The deed was the portion of the property, my lord, transferred on 5th of May 2025, my lord. Thereafter, order 1 rule 10 filed on 5th of October, my lord. My lord, August, my lord. Order passed on 8th of October.
You are enjoying an ad interim order, that means, before that?
No, my lord. That was
then how could they file order 39 rule 4? That is for vacating.
Yes, my lord. Sorry. I'm sorry, my lord. I'm sorry, my
Why
lord.
are you getting nervous? You are doing very well. You are arguing very well.
My lord,
don't get nervous. You are arguing very well. You are enjoying an injunction, temporary injunction application. We find that from the record. Status quo, you are enjoying a status quo.
My lord. Status
regarding
my lord.
nature.
Thereafter, my lord, the application of injunction, my lord, heard out on merit, and that was rejected, my lord, on ground that I have not added this.
We are admitting the appeal. The present appeal has been preferred by the plaintiff. The suit is for partition.
Yes, my lord.
The plaintiff in a partition suit, against an order whereby the plaintiff stroke appellant apostrophes application for temporary injunction has been dismissed on the ground of non-joinder of other co-sharers to the property. Next para. Learned counsel for the appellant points out that on the date on when the impugned order was passed, the plaintiff stroke appellant had already taken out an application under order 1 rule 10 of the Code of Civil Procedure for addition of third parties to the suit on the ground that during pendency of the suit, the plaintiff stroke appellant came to know about transfer of portions of the property in favor of such third parties. Next para, however, the learned trial judge, without first taking up the said application for addition of parties, refused to grant injunction on the technical ground of non-joinder. we find a sufficiently strong prima facie case having been made out on the above question as well as the other grounds taken in the memorandum of appeal, and accordingly admit the appeal to be heard on the said grounds. For sub next para, your injunction period is only against defendant numbers 1 to 3.
My lord.
Because
Yes, my
those
lord.
parties, order 1 rule 10 is
Yes,
not
my
yet.
lord. My lord.
Acha, the defendants during pendency of the application, comma, the defendants stroke respondents 1 to 3 shall remain restrained by an order of injunction from changing the nature and character of the suit property and or
My lord, one indulgence, my lord. They are constructing a building, my lord.
changing the nature and character
Yes, my lord. They
of
are
the suit property and or that was the only status of granted. Changing the nature and character of the suit property in any manner. Push up, the appellant shall serve copies of the memorandum of appeal as well as can 1 of 2025 on the.
My lord, I have already served the copy of the stay application.
He could not have before the appeal is admitted.
Oh,
On the defendant stroke respondent numbers 1 to 3, indicating that the application shall be listed for hearing on January 19, 2026, when an affidavit of service to that effect shall be filed by the appellant. Footstep. A service of notice on the respondent numbers 4 and 5 is dispensed with for the present, since they are the added parties. The
No, my
proposal.
lord. They are the other co-sharers of the.
You have no. Since no relief has been sought against respondent numbers 4 and 5.
Deeply obliged, my
Thank you.
lord.
Thank you. Ms. Shahadattu is in court.
My lord.
Ms. Sushmita Shahadattu is in
She,
court.
she's coming, my lord. She's suffering for knee pain, my lord, for the morning, my
She is
lord.
not in the court
No, my
building. Don't give her name.
It will not
ও না, সুস্মিতা শাহাদাতের নামটা কাটা যাবে কোর্টে না
Deeply
থাকলে
obliged, my lord. I'm singing apology, my lord, if I may get.
you did not commit any wrong. Yes. Why should you apologize? Yes. Yes.
Suit for partition.
Right.
Filed by co-sharer, inherited property inherited from father, as well as gifted by other sisters and mother.
To you, their
To me and other defendants. The predecessors of the other defendants. I have filed suit for partition, pray for injunction, which the other defendants are trying to sell, transfer, and income the property to third person. Kindly come to the impugned order, Lordship.
Interesting.
Lordship, kindly come to the second page.
What injunction did you ask for?
Not to sell, transfer, encumber the property to the outsiders. Lordship, kindly comes to my prayer. This is in page 23.
29.
29 is the injunction application status. And yes, page 29 running page of the application. Transferring, alienating, encumbering
A
any
prima facie case has been made out for hearing of the appeal, inasmuch as the plaintiff stroke appellant in a partition suit. Now, inasmuch as the plaintiff in a partition suit, comma, being the present appellant, comma, filed an application for temporary injunction, which has been on which an ad interim prayer has been refused by the impugned order, on the ground that there is no specific allegation in respect of the suit properties, comma, described in two broad heads, and the allegation regarding transfer of property is quia-timate, QUIA-TIMET in nature. Full-stop. It was further held by the learned trial judge that there is no specific overt act on the part of the defendants, and the schedule of the plaintiff does not disclose whether there is any dwelling house over the suit properties or not, comma, since the instant suit and being co-sharers, the plaintiff and the defendants have equal right in every portion of the suit properties, and that balance of convenience and other factors were not established by the plaintiff. Next para, however, comma, on a bare perusal of the plaint and the connected injunction application, comma, we find a sufficiently strong prima facie case having been made out for grant of injunction, comma, keeping in view the nature of the suit being a joint property between the parties, as well as the necessary averments with regard to
paragraph 4 onwards,
regard to apprehended transfer as well as alteration of the property has been made substantially in the injunction application. Full stop. Accordingly, the appeal is admitted to be heard on the above question and as well as the other grounds taken in the memorandum of appeal. The defendant respondents shall remain restrained and or their main agents shall remain restrained by an order of injunction from selling, transferring, alienating and or encumbering the suit property and or from changing the nature and character of the suit property as well as from altering the status quo with regard to possession in respect of the suit property till disposal of the application. First of the appellant shall serve copies of the memorandum of appeal as well as the application on the defendant's respondents indicating that the application shall next be listed for hearing on January 19, 2026, when an affidavit of service to that effect shall be filed by the appellants. First of affidavits in opposition and reply, if any, shall be exchanged in the meantime.
Lordship, kindly appreciate creating any third-party interest in any manner because if any surreptitious transfer has been made,
selling, transferring, alienating, creating third-party, everything.
Got Lordship.
More than that, you have given more.
Lordship. Now get.
Number 31.
I appear for the appellant.
Yes.
Well, this is a suit for eviction. I am the defendant tenant.
Achha, let us see the defects first.
Oh. Perhaps the second copy was not annexed and thereafter it was rectified.
You have cured, yes, rectified.
This appeal is against a judgment passed in appeal. An appeal remanding the matter back to the trial court. Lordship, this is a suit for eviction. I am
matter
the
of
tenant.
course it should be admitted. Questions of fact and law.
There are
For the other
questions of
side,
fact and law, my lord.
Remand against remand order, yes, satisfy as prima facie.
Lordship.
Why should we entertain the appeal?
Lordship, the suit for eviction, Lordship, the suit was dismissed. Was dismissed on the ground that on several grounds. One of the ground being reasonable requirement they could not establish since the commissioner's report which they had produced was neither the property where the plaintiff is residing nor the suit property. That was a third, a different flat altogether in the same building. And on that basis, the trial court held that the trial court cannot come to a conclusion that they require it reasonably. So that issue was decided against. And the appeal was preferred. In the appeal, my lord, Order 41, Rule 27, and an application for local inspection that was filed.
Regarding
And
the suit property.
regarding the suit.
Their alternative account is represented.
Lord, no, there's the suit property. And my lord, the appeal court, my lord, while deciding that, said that this has to be, to do complete justice, 4127 has to be allowed and remanded back.
Right, so why should you interfere?
My lord, Lordship, Lordship, I am carrying decisions to say that the 4127, Lordship, cannot be used to patch up lacunas, my lord.
No, yes, you're right, but B also comes in. Court requires it for adjudication of the appeal.
Lordship, that is why I am carrying a judgment, my lord.
Shall you know that in a partition, in an eviction suit, till the date of passing of the decree, and appeal is a continuation of the suit, till the date of passing of the decree, court has to ascertain what the reasonable. So there is this leeway of them.
Yes, but they have not said that there is any new reason, there is any new circumstances for reason of which 4120.
It will be technical because just because they did not. Anyway, cite a judgment.
May I first cite ওটা কোথায় এটা দাও হ্যাঁ বসন্ত কুমার সাইটেশনটা হচ্ছে ভয়ানক সাইটেশন একটা কপি দিয়ে দাও 2017 ACC online Allahabad 3018. Well, here, my lord, the issue was the tenant did not produce the written permission by which he has sublet. My lord, paragraph 2, my lord, in the middle, the critical issue which is relevant for these proceedings was as to whether the defendant without permission in writing of the landlord had sublet the premises. The said issue was decided against the tenant by holding that there was subletting for which no written permission of the plaintiff landlord was obtained. Now, let kindly see paragraph 5, where order 41 rule 27, Lordship. This is the UP amendment, but the
Similar.
It is similar. Clause A is where it was refused. Clause B was not within his knowledge and could not have been produced by him. Clause C is, my lord, what?
A has been made B and B has
Yes,
been made
A, double A and B.
double has been made B and
B,
B has been
Lordship,
made C.
Lordship.
Yes.
The appellate court requires any document to be produced or any witness to be examined to enable it to pronounce judgment. My lord, this is what has been relied upon by the appeal court.
Yes, we are also thinking in that. those
Lordship,
lines.
Lordship kindly takes, my lord, paragraph 11 thereafter.
Yes.
Lordship, there has been extensive discussions about the various judgments. And now
Yes.
paragraph 11, which is the internal page
Yes,
5.
yes, yes.
From the law noticed herein above, the legal position as it stands is that the parties to an appeal are not entitled to produce additional evidence, oral or documentary, in the appellate court, except on the principles enumerated in clauses A, B, C of subrule 1 of Rule 27 or Order 41 as applicable in the state of Uttar Pradesh, which is para-immaterial clauses of clause A, AA, B of the code. Clause C, which is para-immaterial clause B of the code, is applicable where appellate court requires a document to be produced or any witness to be examined to enable it to pronounce the judgment or for any other substantial cause. The expression to enable it to pronounce judgment has been interpreted so as to mean that when the appellate court finds itself unable to pronounce judgment owing to a lacuna or defect in the evidence as it stands, it may admit additional evidence. But that does not mean that the clause should be resorted to patch up the weakness of the evidence of the unsuccessful party before the trial court. Though, if the court itself requires the evidence to do justice between the parties, it may accept it. The ability to pronounce a judgment is to be understood as to the ability to pronounce a judgment satisfactorily to the mind of the court delivering it. But a mere difficulty in coming to a decision is not sufficient for admission of evidence under this rule. This provision does not entitle the appellate court to let in fresh evidence at the appellate stage, where even without such evidence, it can satisfactorily pronounce judgment in the case. It does not entitle the appellate court to let in fresh evidence only for the purposes of pronouncements of judgment in a particular way. This is what I am relying on. The additional evidence cannot be allowed to decide an issue in favor of the plaintiff only. The words or for any other substantial cause must be read with the word requires, which is set out at the commencement of the provision, so that it is only where for any other substantial cause the appellate court requires additional evidence for this clause would apply, that this clause would apply. Furthermore, if the recourse is to be taken to the clause, that is clause C, which is parameter to clause B, the appellate court is required to consider the entire evidence on record to come to an independent conclusion whether for arriving at a just decision, adduction or additional evidence as to as has been prayed for is necessary. Now, my lord, I am relying on this judgment only to say, my lord, this cannot be number one, cannot be used to patch up the lacuna. They have. It's not that they have not given any the commissioner's report. They have given commissioner's report for a third party property, which is in the 4th floor, where neither the plaintiff resides nor is a suit property. So, my lord, there the trial court has come to a conclusion. It has found no difficulty in coming to the conclusion that there is no reasonable requirement. My lord, the appellate court, my lord, in one para, lordship, it has summed up. Lordship, the appellate court judgment starts at page 55, and there are discussions on other issues, but I think they are not relevant because I think they're mostly, first of all, there is a default. The remand is not for deciding the issue for default. There is an issue of non-joinder. The remand is also not for that.
Turn down the suit also on default.
Yes.
The grounds were default and reasonable.
Ground of default, And there is also a discussion about misjoinder of parties, but I think the trial court has held that there is a landlord-tenant relationship.
So, as an open remand, or only for that purpose.
My lord, this is this.
Yes.
It has to be understood, my lord.
The
But
appellants are given liberty.
it seems that it is only for taking additional evidence on matters which are set forth. So this is not really an open remand. It is for on reasonable requirement only.
But directed to pass judgment afresh, taking into consideration additional evidence. So
Additional evidence is only with respect to reasonable requirement.
With respect to that, and the other portions apparently are affirmed.
The other portions are affirmed.
Seem to be affirmed because
although no, there is the discussion on default that there should have the
default also. The appellate court's view was something else. A default, it was
the trial court said that there is no default because 7172 provisions has been complied with.
Yes.
But the appeal court lordship, page 59, lordship will see.
Give us the internal page.
The
Of the appeal, bottom.
The bottom, page 5. The last paragraph of page 5, the payment is also clear acknowledgement of the default by the principal defendant tenant. There is no case of the landlord that it is the second or subsequent default, and as such the principal defendant is entitled to the protection of 7(4). The learned trial court ought to have recorded while deciding the issue that it is the first default by the principal defendant tenant. Hence, the decision rendered in issue number 5 by the is not sustainable. So this is, I do not know what sort of a reasoning is this. And my lord, for the second reasoning, this is from bad for misjoinder of parties. Lordship, the immediately next paragraph, the last line of the next paragraph, it has held that trial court has held that suit is bad for misjoinder as well as non-joinder of necessary parties. I see from the trial court has held that there is a landlord-tenant relationship between the plaintiff and the defendant.
If a misjoinder is not a strong ground.
So misjoinder was, how can it be an issue? I do not know. And then, my lord, the trial court starts with
trial court dismissed their suit also on the count of misjoinder.
No, my lord. There is a
misjoinder he could not have. But
yes.
Further held
once there is a landlord-tenant relationship, what else? Who else can be not joined?
It says that trial court further held that suit is bad for misjoinder.
I think this is wrong recording, my lord. That's very. And thereafter, my lord, the appeal court the takes up the issue of reasonable requirement, and then
it shows that finding, the relevant finding here.
The relevant finding, lordship, there is some discussion.
The vacant
at page 6, internal page 9, my lord. The third paragraph, admittedly, no local inspection was held in respect of the suit property. The plaintiffs had placed on record one commissioner's report which was filed and marked as exhibit in title suit number such and such. The trial court had clearly stated in the impugned judgment that such report is of no relevance in the present suit as it relates to only the 5th floor of the suit premises. The learned trial court further opined that bona fide requirement has to be established by the plaintiffs with necessary evidence. It was also stated that no proper explanation or reasons have been shown by the plaintiffs as to why a prayer for appointment of advocate commissioner for local inspection with respect to the suit premises was not sought by the plaintiffs in the instant suit. The learned advocate for the respondent has placed reliance upon several authorities in support of his contention, and then the authorities are discussed. Then the last paragraph, my lord, on perusal of the decisions referred by the parties, it is needless to state that local inspection of 6-storied apartment was necessary to bring out a clear picture of the rooms accommodation in the suit building. The trial court has rightly refused to entertain the inspection which was done in another suit inter se.
In another suit, the same building was
yes, but a different floor. 5th floor was being
that fifth floor, that report was in another suit.
And another suit. That was title suit number 25 of 2010. That was showed here. It's not that they were not aware of the law. The plaintiffs are also burdened with the duty to establish their family composition and other parameters for relief in the form of decree.
So, will continue after the recess with this. This will take some more time. So, we'll continue after the recess.
Very well. Great. Yes. Right. We are placing page 9 of
Page
the
10.
judgment. Yes, madam. 10.
Just started page.
Just started 10. May I please the bottom pair of page 9, madam? On perusal of the decisions referred by the parties, it is needless to state that local inspection of 6-story apartment was necessary to bring out a clear picture of the room's accommodation in the suit building. Then a trial court had rightly refused to entertain the inspection, which was done in another suit inter se between the co-sharers. The plaintiffs are also burdened with the duty to establish their family composition and other parameters for relief in the form of decree on the ground of reasonable requirement. So this also they say that they have not been established. The court is aware of the fact that the application seeking local inspection of the suit property and another under Order 41, Rule 27 for additional evidence being Aadhaar card and death certificate are required to be disposed of. The case of such and such was referred, wherein the Honorable Apex Court observed that inadvertence or non-realization of importance of a document or lack of proper legal advice does not bring the case within the expression of other substantial cause. In case of the Honorable Court observed that explanation is required as to why the intended documents were not produced before the learned trial court and whether those documents are really required for pronouncing the judgment. In the case of state of Karnataka, it was reiterated by the apex court that additional evidence at the appellate stage can be permitted only if evidence sought to be produced could not be produced in the trial court in spite of due diligence and evidence was not within his knowledge. This double A, my lord. After considering the cited cases and ratio of the decision laid down in various forum, it will appear that Honorable Supreme Court
CPC are 97.
The Honorable Supreme Court in the case of Union of India laid a standard for receiving additional evidence with the following observation. Where the additional evidence sought to be adduced removes the cloud of doubt over the case and the evidence has a direct and important bearing on the main issue in the suit, an interest of justice clearly renders it imperative that it may be allowed to be permitted on record, such application may be allowed. To sum up on the issue, it may be held that an application for taking additional evidence on record at a belated stage cannot be filed as a matter of right. The court can consider such an application with circumspection, provided it is covered under either of the prerequisite conditions incorporated in the statutory provisions itself. The discretion is to be exercised by the court judicially, taking into consideration the relevance of the document in respect of the issues involved in the case and the circumstances under which such an evidence could not be laid in the court below, and as to whether the applicant has prosecuted his case before the court below diligently, and as to whether such evidence is required to pronounce the judgment by the appellate court. In case the court comes to the conclusion that the application filed comes within the four corners of the statutory provisions itself, the evidence may be taken on record. However, the court must record reasons as to on what basis such an application has been allowed. However, the application should not be moved at a belated stage. An application under Order 41, Rule 27 is to be considered at the time of hearing of appeal on merits as to find out whether the documents and or evidence sought to be adduced have any relevance bearing on the issues involved. The admissibility of additional evidence does not depend upon the relevancy to the issue on hand or on the fact whether the applicant had an opportunity for adducing such evidence at an earlier stage or not, but it depends upon whether or not the appellate court requires the evidence sought to be adduced to enable it to pronounce judgment or for any other substantial cause. The true test, therefore, is whether the appellate court is able to pronounce judgment on the materials before it without taking into consideration the additional evidence sought to be adduced. Such occasion would arise only if, on examining the evidence as it stands, the court comes to the conclusion that some inherent lacuna or defect becomes apparent to the court. In the instant case, the parameters for allowing local inspection or the case of laying additional documentary evidence are on similar footing. It appears to the court that for deciding issue number 6 in its proper perspective, local inspection was necessary as well as the documents which are listed in the application under Order 41, Rule 27 of CPC. Honorable Court had observed that the admissibility of additional evidence does not depend upon relevancy to the issue on hand or on the fact whether the applicant had an opportunity for adducing such evidence at an earlier stage or not, but it depends upon whether or not the appellate court requires the evidence sought to be adduced to enable it to pronounce judgment or for any other substantial cause. The true test, therefore, well, this is the only paragraph, therefore, is whether this court is able to pronounce judgment on the materials before it without taking into consideration the additional evidence sought to be adduced. This court finds that allowing documentary evidence and holding of local inspection will lead to complete and proper adjudication of the issue number 6, whether the plaintiffs reasonably require the suit premises for their own use and occupation. Hence, the application for Order 41, Rule 27 for reducing additional evidence filed by the plaintiff appellant on 18 July 2024 merits to be allowed. The appellant is given liberty to move the application for local inspection before the learned trial court, and the learned trial court, after giving opportunity to the defendants, will consider the said application in the light of discussion made above. The learned trial court, the present appeal stands disposed of accordingly. Accordingly, it is ordered that the instant appeal be and the same is disposed of on contest. The judgment is set aside. Parties are directed to appear on 18 June. The appellants are given liberty to move the application for local inspection before the learned trial court, and the learned trial court, after giving opportunity to the defendants to file objection or additional points, will consider the said application in the light of the discussions made above. The discussions are Order 41, Rule 27. Anyway, the trial court is further directed to take additional evidence on matters which was set forth by the appellants in their application dated 18 June 2024, and also in connection with the report of local inspection, if submitted. Is further directed to pass judgment afresh, taking into consideration the additional evidence if led by the appellants. So, the only reasoning why the documents are required to be to do complete justice is the second last paragraph of page 65, which is page 11 rather, of the internal page. That the true test, therefore, is whether the court is able to pronounce. The court finds that is allowing will do complete justice.
That was also quoted from that.
That was the Supreme Court judgment. So, there is no independent finding, which is a requirement of Order 41, Rule 27, that why it is allowing it. So, except for complete justice. So, the court cannot keep on allowing the plaintiff to keep on adduce evidence till the time the decision is in his favor. That is my summation.
We'll dispose of the appeal itself because nothing else is required to be gone into apart from these judgments.
Lordship.
The judgment impugned before us.
Yes, there is no case of remand which has been made, my lord. That is also.
And the questions of law, whether this violates Order 41 or 27 directly, and to fill up their lacunae, which is more important.
Lordship. And my lord, I'm also carrying a judgment.
Now the other yes, cite to judgment. On the other grounds, we are satisfied with what you said. Regarding non-joiner, misjoiner, there was no issue. That's an admitted
no issue
question.
at all.
And regarding default, obviously, we set aside that portion of the order. Don't cite too many.
My lord, remand, my lord, it's an unreported decision.
Don't cite too many.
Lordship?
Don't cite too many.
No, one. Huh? It is unreported. It is 1517 SCC. আমারটা কোথায়? ওটা নেই? Paragraph 21 to 22, my lord. Wait. 23 SCC online 196. 22, as regards the question of calling for determination in the present appeal and with reference to the submissions made, we may in the first place take note of the relevant provisions of law and the expositions of this court in the cited decisions. The provisions contained in Rule 23, 23A, 24, 27 and 33 of Order 41 read as under. 23, remand of the case by appellate court. Well, this is on a preliminary point. If 23, if the court has decided on a preliminary point, where the court from whose decree an appeal is preferred has disposed of the suit upon a preliminary point, and the decree is reversed in appeal, the appellate court may, if it thinks by order, remand the case, and may further direct the issue or issues shall be tried in the case so remanded, and shall send a copy of its judgment and order to the court from whose decree is appeal preferred, with directions to readmit the suit under its original number and register of civil suits and proceed to determine the suit and the evidence recorded during the original trial shall, subject to all such exceptions, be evidence during the trial after remand. Now, 23A is relevant, my lord, where the court from whose decree and appeal is preferred has disposed of the case otherwise than on a preliminary point, and the decree is reversed on appeal and the retrial is considered necessary. Well, this is vital. The appellate court shall have the same powers as it has under Rule 23, where evidence on record sufficient, the appellate court may determine case finally. The 24 lordship is what I'm harping on, where the evidence upon the record is sufficient to enable the appellate court to pronounce judgment. The appellate court may, after resettling the issues, if necessary, finally determine the suit, notwithstanding that the judgment of the court from whose decree the appeal is preferred has proceeded wholly upon some ground other than that on which the appellate court proceeds. And then production of additional evidence, which I'm not reading. And next is 33, Rule 33. The appellate court shall have the power to pass any decree and make any order which ought to have been passed or made and pass or make such further or other decree or order as the case may require. And this power may be exercised by the court, notwithstanding that the appeal is as to part only of the decree and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed any appeal or objection, and may, where there have been decrees in cross suits and where two or more decrees are passed in one suit, be exercised in respect of all or any of the decrees, although an appeal may not have been filed against such decree. Now, paragraph 24, I'm just placing this discussion and I shall conclude. While explaining the scope of Rule 23 and 23A of Order 41 in case of Municipal Corporation Hyderabad, this court has observed as under a distinction must be borne in mind between the diverse powers of the appellate court to pass an order of remand. The scope of remand in terms of Order 41, Rule 23 is extremely limited. The suit was not decided on a preliminary issue. The Order 41 Rule 23 was therefore not available. On what basis the secondary evidence was allowed to be laid is not clear. The High Court did not set aside the order refusing to adduce evidence. Order 41 Rule 23A of the CPC, of the Code of Civil Procedure, is also not attracted. The High Court had not arrived at a finding that a retrial was necessary. The High Court again has not arrived at a finding that the decree is liable to be reversed. No case has been made out for invoking the jurisdiction of Order 41 Rule 23 of the Code. An order of remand cannot be passed on ipse dixit of the court. Well, the finding has to be there, my lord. There has to be a retrial. That will be my submission, my lord.
Yes, Mr. Shen.
But so far as the decree for reasonable requirement and mallet on the point of reasonable requirement and default mallet, the trial judge mallet held against the plaintiff mallet. And so far as the other points mallet, it was held in favor of the plaintiff's mallet. Now mallet, the lower appellate court has come to a finding mallet so far as the issue number 6 mallet, additional evidence is required and mallet application for documentary evidence was allowed mallet that was containing certain statutory documents, Aadhaar card and death certificate. And so far as the inspection that was not done, that was liberty was given to in holding mallet the application, in filing application for local inspection mallet. Mallet, the suit is for reasonable requirement mallet, the recurring cause of action mallet. So that even if mallet it goes back to remand, it's in there, it will inure to their benefit so far as time is consumed, it's more mallet.
I'm asking for dismissal.
Very bad argument.
Mallet,
Worst possible argument.
no, mallet, if it will go, if it goes is for remand mallet, it's for inure for the benefit.
They're not interested in that. They're interested in winning right now.
Mallet, so far as the court
have won in the trial court.
Mallet, court has come to a definite finding. Mallet, the additional evidence is required. Mallet, that finding is there. Mallet, so far as the different issue number 6.
How can you be permitted to fill up your lacunae? That is the question, Mr. Shen.
But so far as the lacuna, that is
you had opportunity. You could have taken local inspection. You did not. You chose to cite a report from another suit, which is in respect of 5th floor only.
Mallet.
So after coming to that conclusion, the trial court coming to that conclusion that you have failed to prove your reasonable requirement, why should the appeal court give you a new lease of life?
But so far as the new lease of life, only mallet to a limited extent mallet. So far as the
reasonable requirement,
so far as the my occupation in the suit premises is concerned.
That is the only concern of a court in a reasonable requirement suit, ground suit.
But
you failed to establish that in the trial court. You had the opportunity, despite opportunity, did not produce, have a
the
local
trial
inspection.
court also came to a finding, mallet, the evidence so far as the reasonable requirement is concerned, further evidence is required, mallet. In that case, mallet, dismiss the suit. In the appeal court, mallet, we have filed an application for
What is that
additional
observation of the trial court?
Trial court is page 43 of the application, mallet. Internal page 17. 17 of the trial court's judgment, mallet. It deals with the reasonable requirement, mallet.
Yes. Let us come there.
As such, the court thinks that there is no straitjacket formula. Page 20, mallet, last paragraph. Formula in coming to the conclusion that bona fide requirement of a suit premises by landlord for his own and user needs a practical approach based on the realities of life. But as held in such and such, the landlord must show that need or necessity, which is more than a wish or convenience or the fancy for the landlord. Accordingly, the court is aware the bona fide requirement has to be established and proved independently by the leading necessary evidence, so that all the claims are proved beyond shadow of reasonable doubt. But no such materials have cropped up, or the documentary evidence is not clear. To clear the doubt that the suit premises is reasonably
Not held that further evidence is required. You say you failed to prove your case.
But it says, mallet, but no materials cropped up in the form of documentary to clear the doubt, mallet. Clear the doubt of mallet suit premise. That the
Yes,
suit premises is
obviously, because
reasonably
you did not produce any evidence to. It's your cardinal responsibility in a suit for reasonable requirement, Mr. Shen.
Mallet, if mallet I place mallet the reasonable requirement issue number 6 from the very beginning, mallet, as the plaintiff they required suit premises for their own use and occupation, mallet. Family number 1, there are 5 members, mallet. Plaintiff number 1. Plaintiff number 2, mallet, it comprises of 4 members, and the plaintiff number 3 members. As such, the plaintiff requires at least 7 rooms.
You live in the same house, Mr. Shen. The same house. So you should have shown the other floors how they are occupied. Otherwise, your alternative accommodation is an essential
we
ingredient.
have tried to show, mallet,
Ground says there's
that
suitable.
some of the other plaintiffs, mallet, whose requirement has been sought for resides elsewhere. We have given the agreement license that they are residing elsewhere, mallet. So far as this this building, mallet, that evidence has not been produced by giving local inspection, by taking local inspection in this suit. But so far as the local inspection was held in an earlier suit, mallet, that is title suit number 25 of 2010, mallet, that has been marked exhibit that from.
That is only regarding the 5th floor.
Only regarding the 5th floor. But from the perusal of the report, it appears that pro forma defendant number 2, namely Shaukat Hossain Khan, was a party to the said suit, and he was a tenant in respect of some of the portions of the premises numbers situated at 5th floor, and whereas the instant suit has been filed with respect to the piece and parcel of land in the 4th floor. We wanted to show, mallet, so far as the 5th floor, it is occupied by one of the mallet land owners. So that evidence was brought by title suit number 25 2010, mallet. But so far as the other things, mallet, no local inspection was held. But at the same time, mallet, we produced certain documents from where we could show, mallet, that some of the plaintiffs for whom the reasonable requirement has been claimed but staying elsewhere. That has been marked.
Where? Trial court judgment, where is it reflected?
That is in the appeal.
Yes. Page 19. Second paragraph. Third. Moreover, the leave and license agreement in the name of 2922 merely proved that they reside in a different place. But from nowhere it can be presumed that they are landlords of the defendant number 1. And due to paucity of accommodation, they reside somewhere else. So paucity of accommodation in this premises was not shown. That is the basis of this. Only your 29(1)'s reasonable requirement court says was to be considered.
My lord.
Leave and license agreement in the name of plaintiff 2 to 4 was proved. But you are still the owner of this building.
My lord, ownership, so far as ownership, that is not disputed. my
Not
lord.
disputed, very well. But that your accommodation in this premises, whether you have any other accommodation in the premises, had to be shown.
Well, that was not the case of the that I have enough accommodation. Although this was
Your
the-
case,
My lord.
alternative accommodation, lack of alternative accommodation has to be shown by the landlord, Mr. Shen. You know that.
Well,
that's too well settled.
But so far as the inspection was not done, that remains. my
That
lord. I can't
obviously-
improve that. my lord. My lord, but fact remains, my lord, the suit is for reasonable requirement, my lord, ought to have been done, my lord, inspection as a matter of course, my lord. That was not taken, my lord.
Anything else, Mr. Shen? We'll go back to them. Yes, Mr. Ali, anything in reply?
I
Not
think
much to reply because
not much to reply. The lordship, they have pretty much admitted that they had opportunity. They did not. Fifth floor was shown.
But
No
Mr. Ali,
illegal.
reasonable requirement has to be proved till the last date of the last fact.
But that is not
fact.
their case, my lord. That is a
Not
new.
their case, it's a law. That the last court of fact, up to that you have to, because the date of decree, there is a language, you know that. The date of decree, till the date of decree, there are several
Dynamic.
judgments.
It's dynamic in nature.
Dynamic.
But
Dynamic.
but the 4127 is not that there are changed circumstances and this
So
is
that
not.
is not there. But court had the power. This is one of the possible views. Not perverse or not a view that no reasonable man could take. Because there is an interplay of B and AA in this matter. That is the most important thing. Now there can be a view that even if A is not satisfied, B overrides. If court says that I want under B, then B overrides double. There is no doubt on that. But B court says that yes, B is necessary because I have to come to a finding at the end of the day, being the last court of fact that has not so much has not been said. That
Nothing has been said. Even if the application
we'll
nothing
add that.
has been said.
We'll add that. But
Well, no reason has been given. It's a matter of course it has been allowed, and
no,
till the time they.
It's your ill luck, Mr. Ali, that it's before us, because another court might have taken a different view. It's absolutely a 50-50 case, but we tend to hold in favor of the first appellate court, not either of you. Before interfering, we have to be satisfied that it's yes, it's a patently erroneous view of law. It's not a patently erroneous view. One of the possible views, Mr. Ali. That is where we are very hesitant. We are being very candid. One of the possible views. Court could say that B, here I require it under B, although they have not done it. But I have to ascertain myself, by myself, I have to ascertain as to what is the position. Yes, you are right that subsequent change has not been pleaded by them.
No. This is that I have
What
to
is the
do
last
some
court of
voter
fact?
card,
That
Aadhaar
is-
card,
if
and
it
I have to
was-
do local inspection.
Aadhaar card and death certificate, I have.
Local inspection.
Those would not affect you any.
That is to show possession elsewhere, that they are residing elsewhere.
Whose position?
Plaintiffs.
Plaintiff number 1.
My
Achha.
No, plaintiff number 1 resides in the suit building.
Let us see your address. You'll find it in the trial court decree or the appeal court's decree.
Ustad Inayat Khan Road.
Yeah,
Koraya Road.
same.
154, Koraya Road.
Same. You reside there, Mr. Shen. Even, yes, the rest have different addresses, I think, for the rest.
I have to research
2, 3, and 4. But 1, you have,
Huh?
this is your address.
I have to research
You reside there, so this was necessary.
No, Lordship will give me 1 week to do some more research.
No,
on
no.
this. Very well.
We'll make it time bound for the trial. And this other aspect
The-
definitely will set aside.
Lordship will not run me over that way by
Right.
making it time bound.
No, the trial court will make it time bound for the trial court to decide. Oh, acha, acha.
In my appeal,
Right, we will not make it time. Will not make it time. Will not make it time. Trial courts are under heavy pressure, so double jeopardy you cannot be.
in my appeal at least.
No, right. Take your seat, both of you will just pass out. Since questions of both facts and law are involved in the present appeal, which is against an order of remand passed by the first appellate court, we admit the appeal to be heard on the grounds taken in the memorandum, in view of the short conspectus of the appeal, and since the same can be decided on the basis of the pure questions of law raised by learned counsel for the appellant, upon a scrutiny of the judgments of both the courts below, without entering into further material evidence, we take up the appeal itself for hearing. Next para. The matter arises out of a suit for eviction filed under Section 6 of the West Bengal Premises Tenancy Act 1997 by the plaintiffs stroke respondents primarily on the grounds of reasonable requirement and default in payment of rent. Next para. The suit was dismissed by the learned trial judge on both the grounds. Insofar as default is concerned, the learned trial judge opined that since relief has been given to the defendant stroke appellant under Section 7 within bracket 4 of the 1997 Act, the defendant stroke appellants under Section 7 within bracket 4 of the 1997 Act, no eviction decree on the ground of default in payment of rent could be passed. Next para. While dealing with the ground of reasonable requirement, the learned trial judge returned the finding that although the leave and license agreement in the name of plaintiff numbers 2 to 4 merely prove that they reside at a different place other than the suit premises, from nowhere it can be presumed that they are landlords of the defendant number 1 and due to paucity of accommodation they reside somewhere else other than the suit premises. The trial court further opined that only the reasonable requirement of the plaintiff number 1 is to be taken into consideration. The learned trial judge proceeded further to observe that the plaintiffs had relied upon the commissioner's report filed in a different suit bearing title suit number 25 of 2010, marked as Exhibit 8, but from the perusal of the report it appeared that the pro forma defendant number 2, namely Shaukat W. Hussain Khan, was a party to the said suit and he was a tenant with respect to some portion of the suit premises situated on the 5th floor, whereas the instant suit has been filed with respect to a piece and parcel of land on the 4th floor of the suit premises. On such ground, the learned trial judge discarded the commissioner's report filed in title suit number 25 of 2010, which was marked as Exhibit 8 in the present suit, which was with regard to the 5th floor, since the same had no relevance to the instant suit. It was further observed that no proper explanation or reason has been shown by the plaintiffs as to why a prayer for appointment of learned advocate commissioner for conducting a local inspection with respect to the suit premises was not sought by the plaintiffs in the instant suit. At the same time, it was held that the oral testimony of PW1 and PW2 does not disclose about the accommodation of the plaintiff number 1 or the description / number of family members of the plaintiff number 1 over the suit premises. Next para. The learned first appellate court, after considering several judgments cited by both parties, ultimately came to the conclusion that the true test is whether the appellate court is able to pronounce judgment on the materials before it without taking into consideration the additional evidence sought to be adduced. Full stop. It was further observed by the first appellate court that allowing the documentary evidence and holding of local inspection would lead to complete and proper adjudication of the issue number 6, that is, whether the plaintiffs reasonably require the suit premises for their own use and occupation. Full stop. On such ground, the first appellate court allowed the application under Order 41, Rule 27 of the Code of Civil Procedure, whereby the plaintiff stroke respondents sought to bring as additional evidence Aadhaar card, copies of Aadhaar card and death certificate, in order to indicate the addresses of the plaintiffs. Full stop. Next para. Going further, the learned first appellate court set aside the judgment and decree of the trial court, granting liberty to the plaintiffs within bracket appellants therein bracket closed stroke present respondents liberty to move the application for local inspection before the learned trial judge, and the learned trial judge, after giving opportunity to the defendants, was directed, and after giving opportunity to the defendants to file objection or additional points, was directed to consider the said application in the light of the discussion made in the appellate court's judgment. The learned trial judge was further directed to take additional evidence on matters set forth by the appellants in their application under Order 41 Rule 27 and also in connection with the report of local inspection if submitted, and to pass a judgment afresh, taking into consideration the additional evidence if led by the appellants. For next para, learned counsel appearing for the appellants argues that in the garb of proper and complete adjudication of the LIS, the learned first appellate court could not, ought not, in law, to have permitted the plaintiffs stroke respondents to fill up their lacunae in the first place by not bringing on record sufficient evidence to show the lack of suitable alternative accommodation of the plaintiffs, by way of local inspection. Next para, learned counsel places reliance on the judgments cited by the appellants in the first appellate court in that regard, and also relies on the judgment of reported at 2023 SCC online SC 196. In the said case, the Honorable Supreme Court took into account several provisions, including the provisions of remand under Order 41, Rules 23, 23-A, as well as 24, and Order 41, Rule 27, the principle governing production of additional evidence, as well as the powers of the Court of Appeal under Order 41, Rule 33 of the Code of Civil Procedure. While explaining the scope of Rules 23 and 23-A, the Honorable Supreme Court relied on its previous judgments and observed that a distinction must be borne in mind between diverse powers of the appellate court to pass an order of remand. The scope of remand in terms of Order 41, Rule 23 is extremely limited, where the suit was not decided on a preliminary issue. It was held that in the said judgment, Order 41 Rule 23 was not available, and on what basis the secondary evidence was allowed to be laid was not clear. Also, the High Court had not set aside the orders refusing to adduce secondary evidence. The Honorable Supreme Court, by further relying on the said previous judgment in the matter of Municipal Corporation, Hyderabad, reported at 2008, 8 SCC 485, observed that Order 41 Rule 23-A of the Code is also not attracted, and the High Court had not arrived at a finding that a retrial was necessary. Next para. In the present case as well, comma, it is argued by the present appellants, comma, the first appellate court had not arrived at any finding that the trial court's decree was otherwise liable to be reserved or that a retrial was necessary. Next para, despite taking note of the judgment cited before it, comma, the learned first appellate court, comma, it is argued, comma, completely overlooked the rigors of subsection small aa within bracket of Order 41 Rule 27 within bracket 1 of the Code of Civil Procedure. It is argued that despite the plaintiffs having failed to establish before the first appellate court as to why the plaintiffs were unable, comma, despite due diligence, to produce bring on record the report of an advocate commissioner with regard to the suit building. Despite the same, comma, however, comma, the first appellate court reversed the findings of the learned trial judge and remanded the matter to the trial court. কে এটা আমার অফিসার একটু আসতে বলো মাইক থেকে দূরে আচ্ছা Next para. It is further pointed out by learned counsel for the appellants that the learned first appellate court, comma, erroneously observed that in the absence of any case of subsequent default having been made out, comma, the learned trial judge was not justified in holding that in granting relief to the tenant stroke appellants under section 7 within bracket 4 of the 1997 Act, comma, thereby coming to the conclusion that the decision rendered by the trial court, comma, negating the issue of default in payment of rent, comma, was not sustainable. It is argued that by granting the remedy of section 7 within bracket 4 of the 1997 Act, comma, it was presupposed that the default was the first on the part of the appellants, and as such, comma, the said finding of the first appellate court is also erroneous. Both learned counsel for both the parties before us concede that the finding of the first appellate court that the trial court further held that the suit was bad for misjoinder as well as non-joiner of necessary parties was incorrect. Next para. Learned senior counsel appearing for the plaintiff's respondents argues that in a suit for eviction on the ground of reasonable requirement, comma, it is the duty of the court, comma, till the very last date of passing of an eviction decree, comma, even up to the appellate stage, comma, to ascertain whether actually the plaintiffs required the suit premises for their personal use and occupation. Taken from such perspective, comma, it is argued that the learned first appellate court was justified in observing that for a proper and complete adjudication of the proceeding suit, comma, a local inspection was required to be held in respect of the suit building. Next para. It is next argued that in view of the provisions of Order 41 Rule 27 within bracket 1 within bracket small b of the code, comma, the first appellate court was justified in remanding the matter and directing a local inspection to be held. Also, comma, the production of the Aadhaar card and death certificate are necessary documents to ascertain the issue as to whether the plaintiffs live elsewhere and or in the suit property. Next para. Upon a careful consideration of the arguments made by the parties, comma, we are unable to accept the submissions of contentions of the appellant for the following reasons, niche. It is undoubtedly true that under Order 41, Rule 27, within bracket 1, within bracket small a, comma, the party seeking to produce additional evidence before the appellate court has to establish that notwithstanding the exercise of due diligence, comma, the additional evidence was not within his knowledge or could not, comma, after the exercise of due diligence, comma, be produced by him at the time when the decree appealed against was passed. Full stop. Next para. However, comma, clause small b within bracket of Order 41, Rule 27 within bracket 1 categorically empowers the appellate court, comma, if it requires any document to be produced or any witness to be examined to enable it to pronounce judgment, comma, or for any other substantial cause, comma, in which case it may allow such evidence or document to be produced or witness to be examined. Full stop. Next para. Clauses small a within bracket and small b within bracket operate in different spheres. Full stop. Whereas in the event the court allows production of additional evidence, comma, without any further finding that such evidence is otherwise required by the appellate to pronounce judgment or for other substantial cause, comma, the party seeking to produce additional evidence has to establish that despite exercise of due diligence, the evidence was not within his knowledge or could not, after the exercise of due diligence, be produced by him at the time when the decree appealed against was passed. Full stop. Next para. However, comma, clause small b is a power vested in the appellate court itself to require to direct any evidence or document to be produced or witness to be examined if it is of the opinion that it requires any document to be produced or any witness to be examined, তারপর italic say, to enable it to pronounce judgment or for any other substantial clause. Italics করে full stop. Next para. Learned counsel for the appellant, comma, apart from relying on Sirajuddin, যেটা আগে বললাম, Supra, comma, has also relied on a judgment of a learned single judge of the Allahabad High Court in the matter of such and such, reported at 2017 SCC Online ALL P018, where the learned single judge, comma, while discussing the scope of Order 41, Rule 27, comma, had arrived at the conclusion that the expression double inverted to enable it to pronounce judgment double inverted clause has been interpreted so as to mean that when the appellate court finds itself unable to pronounce judgment owing to a lacuna or defect in the evidence as it stands, comma, it may admit additional evidence, full stop, but that does not mean that the clause should be resorted to patch up the weakness of the evidence of the unsuccessful party before the trial court, though, comma, if the court itself requires the evidence to do justice between the parties, comma, it may accept it. Full stop. The learned single judge held further that the ability to pronounce a judgment is to be understood as the ability to pronounce a judgment satisfactory to the mind of the court delivering it. Full stop. But a mere difficulty in coming to a decision is not sufficient for admission of evidence under this rule. Full stop. The provision, comma, it was held, comma, does not entitle the appellate court to let in fresh evidence at the appellate stage, where even without such evidence, it can satisfactorily pronounce judgment in the case. Full stop. It does not entitle, it does not entitle the appellate court to let in, এটা বললাম না না এটা আবার রিপিট করেছে, না আবার রিপিট করেছে, it was reiterated that it does not entitle the appellate court to let in fresh evidence only for the purposes of pronouncement of judgment in a particular way. Full stop. Next para. Learned counsel for the appellants before us has argued on the strength of such judgment that even if the first appellate court was of the view that it required further evidence to pronounce judgment, comma, it could not be to pronounce judgment in a particular way in favor of the plaintiff. Full stop. The plaintiffs stroke respondents, comma, despite having ample opportunity, comma, failed to seek any local inspection or to produce before the court any evidence as to their current accommodation in the suit building. Full stop. Thus, comma, the first appellate court, comma, in defiance of the tenor of Order 41, Rule 27, within bracket 1, within bracket small a, comma, resorted to clause small b of the said provision, comma, which was unwarranted in the facts of the present case. Full stop. However, comma, from the very language of section 6 within bracket 1 within bracket small d of the 1997 Act, comma, it is evident that the stage till which the ground of eviction has to be established is not the point of time when a suit for eviction is instituted, but the juncture at which the final decree is passed by the last court of appeal. Full stop. By applying the principle that by applying the legal fiction that an appeal is a continuation of the suit, comma, thus, comma, it is the last court of appeal which, comma, passing a decree of eviction on the grounds as stipulated in section 6, comma, has to satisfy itself that the grounds were available as on that date. Full stop. Going by such principle, comma, section 6 within bracket 1 stipulates that no order or decree for the recovery of possession shall be made unless the ground stipulated therein, comma, including the ground of reasonable requirement, is established. Full stop. Next para. We also have to keep in mind that the first appellate court was the last court of fact and was empowered under several provisions akin to the trial court, comma, to enter into questions of fact as well as questions of law. Full stop. Apart from section 107 of the Code of Civil Procedure, comma, Order 41, Rule 33 permits the first appellate court to enter into the factual domain, comma, which could be entered into by the court of first instance, comma, for satisfying itself that the ground pleaded by the plaintiffs, comma, in the present case reasonable requirement, comma, was available as on the date of passing of decree by the first appellate court. Full stop. On such premise, comma, read in conjunction with Order 41, Rule 27 within bracket 1, our within bracket small b of the court, comma, it was one of the plausible conclusions for the first appellate court to arrive at that it requires a commissioner's report by way of local inspection and the documents regarding residence by way of Aadhaar card and other documents sought to be produced by the appellants to enable it to pronounce judgment. Full stop. Next para. Hence, comma, read comprehensively, comma, we do not find that the view taken by the first appellate court was not one of the possible views which could be taken. Full stop. It is well settled in law that where there is an overlap or a conflict between clauses small b and small aa of Order 41, Rule 27 within bracket 1 of the code, comma, the provisions of clause small b shall override the parameters of clause small aa within bracket, comma, since clause b empowers the court itself to come to a finding that it requires some evidence for a proper and complete adjudication of the lease, whereas clause small aa only puts fetters to the rights of a party by itself to produce additional evidence. Full stop. Hence, comma, seen from such point of view as well, comma, the learned first appellate court was justified and took one of the plausible views by observing that for a proper and complete adjudication of the suit, comma, a local inspection was required to be held for the purpose of complete adjudication for the purpose of ascertaining whether the ground of reasonable requirement was available to the plaintiffs stroke landlords on the date of passing of the final degree by the first appellate court. Full stop. Insofar, thus, comma, we do not find any illegality in the first appellate court having remanded the matter to the trial court for the purpose of permitting the plaintiffs to adduce additional evidence in terms of their application for such purpose made in the first appellate court, as well as to make an application for local inspection upon grant of opportunity to the defendants stroke appellants to file objection or additional points in respect thereof. Full stop. Next para. Insofar as the finding of the first appellate court, to the extent that the decision rendered on default in payment of rent by the trial court in favor of the defendants is not sustainable, comma, we are unable to agree with such proposition, comma, since the said portion of the impugned judgment of the first appellate court is perverse. Full stop. Per se, comma, once relief is granted under subsection 4 of section 7 of the 1997 Act, comma, it presupposes that the default was the first on the part of the tenant. Full stop. By virtually, comma, by its finding, comma, the first appellate court reopened the order passed under the relief granted by the trial court under section 7 within bracket 4, comma, whereas no challenge was preferred thereto at all. Full stop. Next para. Hence, comma, such portion of the findings of the first appellate court in the impugned judgment are required to be set aside. Full stop. Also, comma, it was nobody's case that the suit is bad for misjoinder or non-joinder of necessary parties, which was also not backed by reasons by the first appellate court. Full stop. Thus, comma, the said portion of the findings of the impugned judgment cannot also be sustained. Full stop. Next para. In view of the above, comma, FMA 1765 of 2025 is allowed in part, comma, thereby setting aside the portion of the impugned judgment and decree dated April 25, 2025, passed by the learned additional district and sessions judge, second court at Shialda, district South 24 Parganas, in ejectment appeal number 21 of 2023, whereby the said court had held that the decision rendered in issue number 5 by the trial court is not sustainable, as well as, full stop, we set aside as well the portion of the impugned judgment of the first appellate court, whereby it was held that the suit is bad for misjoinder as well as non-joinder of necessary parties. Full stop. Next para. However, comma, we do not interfere with the principal order of remand of the first appellate court and sustain the same. Full stop. The appellants will be at liberty to move an application for local inspection. The plaintiff's respondents herein will be at liberty to move the application for local inspection before the trial court for the purpose of ascertaining the accommodation of the suit building. Full stop. If such an application is filed, comma, in
Well,
terms,
you have already filed an application, my lord. We are out of time because of pendency of this appeal for file objection. Lordship will just extend my time to file. They have already filed.
At this juncture, comma, it is pointed out that such an application has already been filed in the trial court. Full stop. Accordingly, we extend the time for the defendant stroke appellant's hearing to file objection thereto for a period of till December 24, 2025.
Well, till the next date of hearing. The next date is somewhere in January, my lord.
Acha, sorry. No, they very well advance copy. Acha, ওটা till December 24 না করে till the next date of hearing in the trial court after remand, push-up advance copy of the same shall be given to the plaintiff stroke respondents herein sufficiently before. Push-up next para. The portion of the impugned judgment of the first appellate court whereby the trial court was directed to take additional evidence on the matters in terms of the application of the landlords in their application dated July 18, 2024 before the first appellate court, and also in connection with the report of local inspection if submitted is also sustained. Full stop. The learned trial judge, in consonance with the impugned judgment and decree, shall pass a judgment afresh after taking into consideration such additional evidence, if led by the landlords. Full stop. Next para. This much. There will be no arrest cost. Can is there. Some can is.
There is can 1.
Can 1 of 2025 is disposed of consequentially as well. No arrest cost.
Good.
Thank you. এদি হ্যাঁ এটা ওর মধ্যে যেটা
My lord, I am the plaintiff appellant herein. My lord, suit for eviction on the ground of
section 5 is there.
No, it is already been over. There is no section 5. It was defect last occasion, so defect is removed.
Achha. We had held that.
Yes, my lord. Last order.
Yes. Yes. What is the matter?
A suit for eviction on the ground of trespasser. So prior to framing of issues, the learned trial court fixed this matter on the head of a mental levity.
On the
prior to framing of issues, the learned judge fixed the matter under the head of for mental levity of the suit. Since the suit is work property.
Oh yes, yes.
It is a for eviction. The last occasion, Lordship was pleased to direct me to bring the plaint and written statement in respect of this matter. My lord, this is the plaint, my lord.
Yes.
And the written statement. Petition type of copy taken from the column.
Do they dispute that it is a work of property?
No, there is no dispute. This case only for simple case for eviction. The trespasser.
1 minute. No, but in paragraph 11 of the written statement,
yes, they have pointed out
these
one
defendants deny and dispute that 5 Nawawali that property is a duly enrolled work of property. So they have raised a dispute regarding whether it's a work of property at all. Para 11, please come to para 11.
Yes, they have stated. They have stated.
Therefore, it's an issue. It will be an issue in the suit.
No, my lord, the suit for eviction.
Suit for
eviction. They have at the time of trial. If I am not been able to produce the documents in respect to the work property, the suit will go.
No.
The judgment, my lord.
Got a copy of the Work of Act?
Yes, my lord.
If a question arises as to whether a property is a walk-up property, no, you don't have a later version.
No, this is not the according. I have available this the library. My lord, this is. It's not been changed. This
No
particular act is not been changed.
Very. No, walk-off and other things have come in now.
Okay, but this particular order has not been changed. So may I submit the part of the point, my lord, our High Court in single bench.
Yes, please cite it.
Our High Court in single bench already passed this on the part of the point, my lord. This is article of the point.
Six. If whether particular property is walk-up or not. Question to arise incidentally. Now, incidentally in the sense that eviction suit, declaration of title suit. Yes, this judgment. Which
this
part?
is the upper High Court, my lord, kindly.
Paragraph.
Yes, everything has been mentioned in this particular judgment, but as per the Walk-up Act also. So for the dispute in respect of the work property, whether it is work property or general property of the Thika property, that will be decided by the work tribunal. It is the eviction suit.
Justice Chatterjee held that in my considered view, if it is an ejectment stroke eviction suit of the walk-up property and no dispute raised which are specified in section 6 or 7, then the suit for eviction is very much within the domain of civil code. Nobody doubts that. Here they are specifically raised. Here Justice Chatterjee's decision says no dispute raised which are specified in section 6. Here a dispute has been raised.
My lord, I am the plaintiff, this is my suit. In the trial, my lord.
In your suit, the defendant will raise a dispute. In
Yes,
their own suit, they will not raise a dispute. Exactly. Will the plaintiff raise a dispute in his own suit? It is a defendant who has to raise a dispute.
Yes, my lord.
That is what had been held here. This also goes against you, in fact.
At the time of trial, my lord, if I am failed to produce the
no, the civil court does not have inherent jurisdiction to take up the matter. If a question arises, because section 6 very categorically says, if any question arises whether a particular property specified as walk-up property in the list of walk-ups is walk-up property or not, or whether a walk-up specified in such list is a Shia Sunni or not, whether it's a walk-up property or not, the board or the Motwali of the walk-up or any person interested therein may institute a suit in a tribunal for the decision on the question, and the decision of the tribunal in respect of such matter shall be final. So a question has been raised.
Yes, my lord, I am work deed is also with me. They have made an objection in the written statement. They have raised these questions. So my lord, so landlord tenant is concerned. If dispute is arise, the relation between the landlord tenant, the suit court has power to decide the landlord or tenant. As so far the work is concerned, my lord, they are raising questions. This property is no work property. Very well. At the time of trial, my lord, I will show the documents so that it is.
Question is not at the time
yes,
of
my
trial.
lord,
obviously, you have to prove. Question, Mr. Mishra, is whether the civil court has jurisdiction to decide. This will be one of the issues in the suit, whether it's a walk-up property or not.
It's a settled proposition 2022, volume 4, SCC, page 414. This specific proposition has been answered. The eviction suit will lie before the work trial. 2022, volume 4, SCC 414.
It is mentioned in the imputed order.
414.
Rashid Wali Beg judgment, Lordship. After considering all these 12 judges
to be. Thank you. It has been mentioned in the judgment. You brought it.
No, in the impugned order, judgment is there, madam.
Let us see that.
2022, volume 4, SCC. That is Rashid Wali.
Yes.
Rashid
Wali Beg.
Yes. This is my lord.
That is what has been held here.
Supreme Court case, my lord, 2014. Kindly see.
Fasila has been considered in Rashid Wali.
12 judgments have been considered after considering this.
I was not remembering the name of
Rashid Wali.
Everything has been considered.
Lordship.
No, Mr. Mishra, no interference. Learned counsel, Now, the present appeal has been preferred against an order whereby the learned trial judge has returned the plaint under Order 7, Rule 10 of the Code of Civil Procedure for presentation before the proper forum on the finding that the eviction suit filed by the plaintiff appellant involves a question as to whether the property is a walk of property. The learned trial judge held that the said court has no jurisdiction to entertain and try the instant suit on such ground. Next para, learned counsel appearing for the appellant hands over copies of the plaint and written statement filed in the suit as per the court's direction and places reliance on a judgment by a learned single judge of this court in the matter of Sheikh S.K. Abdul within bracket CO 4061 of 2015 for the proposition that in an eviction suit, there is no question of the walk-off tribunal having determination, but it is a civil court which has the jurisdiction to decide such suit. Next para. However, we are unable to accept such contention. Section 6 of the Waqf Act 1995 categorically stipulates that if any question arises whether a particular property specified as Waqf property in the list of Waqfs is a Waqf property or not, the board B capital or the mutawali of the Waqf or any person interested therein may institute a suit in the tribunal for the decision of the question, and the decision of the tribunal in respect of such matters shall be final. Next para. In the judgment of the learned single judge cited before us, in paragraph 11, it was held that if it is an ejectment stroke eviction suit of the Waqf property and no dispute raised which are specified in section 6 and 7 of the Act, then the suit for eviction against the tenant relating to a Waqf property is very much within the domain of civil court and not within the jurisdiction of Waqf tribunal. However, in the present case, a dispute has been raised by the defendants in paragraph number 11 of the written statement by stating that the defendants deny and dispute that the suit property is a duly enrolled Waqf property under Maulvi MOULVI Abdul Javed JAWED.
Waqf estate.
Waqf estate as alleged or at all. Thus, since the said objection has been specifically raised, which squarely comes within section 6 of the 1995 Act, the principle as laid down in Rashid Wali Beg versus Farid Pindari, reported at 2022 4 SCC 414, which has been relied by the learned trial judge, and in which case all the previous judgments governing the field was discussed, applies. Accordingly, the civil court does not have jurisdiction, which conclusion was rightly arrived at by the learned trial judge. In such view of the matter, we do not find any scope of interference with the impugned order. Accordingly, FMA 1877 of 2025 is dismissed under Order 41, Rule 11 of the Code of Civil Procedure without any order as to costs. Next para. Is there any connected application, Mr.?
No, there is no another.
Best this much. Can আপনি ওগুলো পেয়ে যাবেন জাজমেন্টে যেটা বললাম ইমপ্লিমেন্ট অর্ডারে রাশিদটা কোট করা আছে লাস্টে যে জাজমেন্টটা বলা হয়েছিল পিন্ডারি বলে ইমপ্লিমেন্ট অর্ডার যেটা যে অর্ডার এগেইনস্টে অ্যাপিল হয়েছে সেই সেখানে আছে সেই অর্ডারই কোট করা আছে
A written statement and plain the copy of the annex with the document.
We recorded it.
Yes.
Item number 33.
বইটা ফেরত বইটা Great. Thank you. Walk-up একটা টানিয়ে নেবেন তো। Yes.
My lord, I beg to appear on behalf of the petitioner.
Is the matter?
My lord, this is a my lord, the petitioner, my lord, she is the owner of my lord about
Petitioner?
the petitioner, my lord, is the owner. She by virtue of a purchase,
Yes.
my lord, she is the owner of 65 decimal of land, out of which, my lord, 24 decimal is a pond and 41 decimal is the embankment. Now, my lord, dispute cropped up, my lord, in 1985. My lord, a wasting notice was floated, my lord, and for which, my lord, 19 decimal of petitioner's land was declared as wasted. Now, my lord, challenging that order of wasting, my lord, the petitioner came up before this honorable court, filed a writ petition. My lord, the writ petition was allowed in favor of the petitioner and the wasting order was set aside. Now, my lord, after that, my lord, the petitioner was asked to appear before the respondent authorities for correction of records and all these things. In the writ petition, though the state appeared, but subsequently on the final hearing day, they did not appear, my lord, did not file any opposition, and the order of vesting was set aside. Now, my lord, what happened after that, the respondent authorities are still now, my lord, it stands in the name of as a vested plot, contending that it is a post-vesting purchase that I have purchased the land, and my lord, even my lord,
now your mutation is being refused.
My lord, it is still, my lord, I have, my lord, the mutation is in my name. There is a separate Khondokhotyan issued, but still, my lord, there is no separate allotment has not been done. If your lordship kindly sees the
allotment means where?
My lord, in my name, my lord, the land has not been. They are saying, but I have the mutation documents, but they are saying no, it is not the mutation that has been done.
But it's a question of allotment. You are the owner of
no, my lord, not allotment as stand character. My lord, the mutation has not been done.
You said mutation stands in your name.
That is the document I have annexed in this writ petition. In this.
What is the cause of action of the writ petition?
If your lordship kindly sees my prayer in the petition before the tribunal, my lord. Well, it has.
So name has not been recorded or what?
No, name has not been recorded. My lord, at page 17.
Page
17, my lord, of my writ petition.
Yes.
Writ in the nature of mandamus to issue commanding the concerned respondents and their men and agents to set aside, revoke, rescind all proceedings in connection with.
You said that was already set aside?
My lord, even that, my lord, if your lordship now kindly sees, my lord, the order that was passed in the writ petition, it is at page 57.
If this has already been decided, where is the question?
Now, after that, my lord, if your lordship kindly sees, after that, even I was at page 63, I was asked to appear.
No, where is that order for High Court's order?
My lord, High Court order starts at page 57.
Where does it set aside the?
My lord, page 58, my lord, page 60, my lord, the learned advocate appearing for the petitioner contended that the petitioner has become Rayat under the state and the new tenancy was created, duly mutating her name in the rent roll and recording her name in the LR record of rights by opening new Khotiyan in her name in respect of said plots as Okrishi Poja, that is non-agricultural tenant. And the petitioner is paying rent to the respondent, and the respondents are realizing the same from the petitioner regularly. Under such circumstances, it is submitted that the impugned order of vesting should be quashed and set aside. Now, my lord, the state did not. Then, my lord, the next paragraph. In that view of the matter, the petitioner remains uncontroverted. Also, the point raised in the writ petition is fully covered by a decision such and such. And then, my lord, in respect to like that, in view and expression taken by his lordship and view of the aforesaid judgment, the writ petition succeeds, and that the rule is made absolute. Later, read in the nature of mandamus to issue commanding the respondents not to give effect or further effect to the impugned order of vesting as obtained from such and such. My lord, that is page 62. Now, my lord, what they are contending, my lord, this is a plot of land. There is a vast
further question of this.
My lord, that is what my humble submission is. Well, if your lordship kindly sees the impugned order which has been assailed, the learned tribunal has considered all these things and then says that that the Honorable High Court has not set aside the order of vesting. If your lordship, may I just place the impugned order, my lord?
What is the prayer in the application before the tribunal? Let us see that first. Have you annexed that, or have
Yes,
you
ma'am.
got a copy?
Yes, I have annexed.
Do you by any chance have a copy of that writ petition which was before Justice Banerjee?
No, my lord. In fact, my lord, what
That
in fact,
rule, the prayer of the rule
no, my lord, the thing
must have been set aside.
The difficulty, my lord, what they all the other authorities are doing, my lord, there was subsequently a writ petition preferred because this was a vast land. My lord, I have purchased only for, my lord, 65 decimals. My lord, I have purchased it by a order of court from, my lord, a receiver, because the property originally belonged to one Ram Kumar Sen. My lord, their order of by
It was
which
a court sale purchase.
court sale purchase only for 65 decimal. Now, my lord, the other diaties they were, my lord, they subsequently preferred a writ petition before this honorable court against the state, saying that their vesting has also not been properly dealt with. Honorable Justice N.K. Mitra has directed them to file Form B. My lord, that order is there with
You are not direct.
I am not a party to that.
No, if the because the rule has been made absolute by the
yes, my lord.
So we have to look at the rule. The rule must have been to set aside the vesting or such proceedings. You
Yes,
understand what we are
yes,
saying?
yes. My lord, what is the prayer there in the writ petition?
Yes, because that has been made absolute. A perusal of the prayer would show that if you had prayed for a rule, do issue calling upon the respondent to show cause as to why, that must have been to why the vesting order should not be set aside on all those prayers. And that has been made
absolute. Then, my lord, everything
goes. So
even in fact, the order of
copy
vest,
of
I do not have even the order of vesting is also not there, because the order of vesting must be including my property as well as the properties where the other petitioners have come forward.
Yes.
Has come forward.
Under which act?
My lord, under the old act, my lord.
Estate acquisition or
no, my lord, where's Land Reforms Act?
Land Reforms Act.
State acquisition.
Then vesting is automatic. Only your right is to retain. File Form B for retain.
No, for my.
No, but this has been apparently set aside because not to give.
It has been set aside. Now, my lord, Form B was asked to submitted by the other petitioners who have preferred the repetition before Honorable Justice N.K. Mitra. Because my land, by this order, my lord, it stands divested. So, no, in my humble understanding, my lord, there cannot be. My lord.
First shows the prayer before the tribunal.
Well, page 36, if your lordship kindly sees. Relief sought for, my lord, to correct the record of right by inserting the name of the petitioner in respect of 19 decimal of land, 7 decimal from the pond, and, my lord, 12 decimal from the embankment.
Yes, so correction of record as we asked you. Once you are saying mutation, again you are saying. So correction of the records of right you are asking. Very good. Let us see the order of the tribunal.
My lord, it starts from page 194. My lord, may I please? My lord, the instant OA number such and such has been filed by Srimati Shivani Mondol, the appellant, challenging the impugned order dated 29/6/2007 of the respondent authority number 2 and ADM and DLRO South 24 Parganas in the appeal case number 18 of 2006, arising out of an order dated 26/5/2005 of the BLL and LRO Sonarpur in Miss case number 14 of 1991-92, initiated in compliance with the order dated 26 August 2022 of this tribunal in earlier OA number 2249 of 2002 of the present appellant. By filing this OA number 3885 of 2007, the appellant has prayed for a direction upon the respondent authorities to correct the ROR by inserting her name in respect of 19 decimals of land, 7 decimal of plot number 963, and 12 decimal of plot number 962, Mousa such and such. Submissions were made in both sides by learned counsel for the appellant and the learned government representative at length. No representation on behalf of the private respondent, that is the joint receiver of the Adda estate, in the OA is made before us. From such submissions and the averments made in the OA and the supplementary affidavit made by the appellant as well as the affidavit in opposition and reply submitted by the respondent authority,
and the appellant respectively, and the copies of the related order of the Honorable High Court of Calcutta and Learned Civil Court order and LCR in the case, the following facts have come out. Now, my lord, the case land got vested in BR case number 189 of 1962, vide the order dated 4th May 1985 under the West Bengal Estate Acquisition Act 1953 in the matter of ex-intermediary Bijon Kumar Addi and others. The ex-intermediaries Bijon Kumar Addi and others received ad interim compensation under Section 12 of West Bengal Estate Acquisition Act 1953 against their property vested. The appellant purchased the case land vide a registered deed dated 8 March 1977 from her vendor Bolai Chandra Mondol, who had been allowed to purchase the same land with other quantum vide order number such and such dated 20th April 1976, passed by the learned subordinate judge, 4th Court, South 24 Parganas, entitled such number 39 of 1945, related to said ex-intermediary and others. Now, my lord, Honorable High Court of Calcutta in CR number 5816W of 1986, vide the pronouncement dated 30th July 1989, accepted the petitioner Srimati Shivani Mondol, appellant, in the instant way as the post-vesting purchaser of the case plot number 963 and 962, area 24 decimal and 41 decimals respectively in Mouza Natgacha Jail 97 Shunarpur. His lordship, while passing the rule in the stated CR number 5816W of 1986, observed that the petitioner's name was duly mutated by the state authority in the relevant ROR by opening Khondo Khotiar number 449 to 452 and 517 to 531. And the petitioner paid the rent to the state government, and therefore state government cannot treat the said land vested. His lordship was pleased to issue a writ in the nature of mandamus not to give effect or further effect to the impugned order of vesting as contained in memo number such and such dated May 16, 1985 as mentioned in prayer A to the petition. A miscase number 14 of 1994 in the matter of BR Bijon Kumar Addi and others was initiated. I was made a party, I was also asked to appear in this matter. Was initiated under Section 616610 of the West Bengal Estate Acquisition Act 1953 by the BLNR Shunarpur in compliance with the order dated 15th of January 1991 in CO number such and such 1989. This order, my lord, I have the order with me. I am not a party in this writ petition. In this writ petition, what I was submitting, my lord, his lordship directed that the petitioner must file Form B. And subsequent additional order dated 6th of December 1991, whereby the Honorable High Court of Calcutta quashed the said vesting proceeding in BR case number 189 of 1962, and also directed the state respondent to consider B form to be submitted by the petitioners and to dispose of the same according to the conscience of the proceeding officer in accordance with law. After considering the B form submitted afresh by the side of the ex-intermediary and others, the said proceeding officer rejected the same vide his order dated 20th September 1994, allowing the ex-intermediary to retain those lands which he had already been allowed to retain in BR case number such and such as per his option, and pari passu declared the excess land inclusive of the case land in the instant way held by ex-intermediary vested to state with effect the cardinal date of vesting. The appellant moved this tribunal in earlier OA number such and such, in which Honorable Tribunal issued an order dated 26th August 2002, directing the BLLRO Sonarpur to conclude the miscase number 14 of 1992. And if the final order had already been passed, a certified copy of the said order to be supplied to the appellant within the stipulated time. In compliance with the order dated 26th August 2002 of this tribunal in OA number 2249 of 2002, BL and LRO Sonarpur concluded the proceeding number 14 of 1991-92, passing the final order dated 26th May 2005, wherein no relief was given to the petitioner. An appeal with number 18 of 2006 was filed by the appellant Srimati Shivani Mondol, assailing the order dated 26th May 2005 of the BLL and LRO Sonarpur before the appellate authority and ADM and DLLRO, South 24 Parganas, and the appellate authority disposed the said appeal, cause rejecting it with the order dated 29/6/2007.
You had approached the tribunal previously.
Yes, my lord. Tribunal previously.
Conclude that miscase. Now you're asking for setting aside that miscase.
No, I'm not asking for setting aside the miscarriage.
That is the prayer.
I am, but I am, yes, my lord. I have, my client had previously, he should have, my lord, then at that very inception should have said that I am not entitled to appear before any miss case when he was asked to submit the court order and to submit other records, my lord, as I was pointing it out to your lordship, my lord. But instead, my lord, when he was called for, my lord, at page 63, my lord, at that inception, my lord, it was a wrong step taken by, I mean, I cannot improve it, my lord. He has gone before the authority now and placed a demand justice since he was not given heard of. And then, my lord, when they refused to record her name of right, no, my lord, he has moved the tribunal. My lord, my client's case ought to have been that she is no longer required to submit the B form, because the B form according to the other riot, they were asked to submit the B form, but it does not apply to my client. And the court also, my lord, has held, my lord, at one point, the tribunal held that the Honorable High Court had said that in Khondo Khotian, my client's name has been recorded.
But you could not produce those.
No
Khondo Khotian.
But if your lordship kindly sees, it is
page 5, the last paragraph onwards.
If your lordship kindly sees page 52 of the writ petition. I presume that it was placed before the Honorable High Court when the writ petition was moved. That's why this observation was there, and it is there in the page 52, my lord.
Was it there before the tribunal? Otherwise, why not finding?
My lord, Khondo Khotian 449 to 452 at the right hand side.
But this should have been produced before the tribunal. Why didn't you produce it before the tribunal?
I cannot ascertain, my lord, because this is my client also. This is a long pending matter. I could not ascertain whether this document was, but I do not know, my lord. But even then, my lord, if your lordship kindly see that page 3, the learned tribunal says that the Honorable High Court has recorded that separate Khondo Khotian has been ascertained. Now, on the other breath, he comes to a conclusion that I failed to produce those documents.
So why did you submit before the tribunal again after getting the order of Justice Banerjee? Again, you went before the tribunal.
That is, my lord, I cannot improve it, my lord. That is also, my lord, but
that was much prior.
Because they have given demand justice that I was called for. Then because after this order of this Honorable High Court, my lord, this letter
what was the miscase about? Where you participated, miscase 14? What was that about?
For recording. If your lordship kindly sees the purport of the notice that was served upon me at page 63, my lord, it was immediately after the order passed by the Honorable High Court. যেহেতু সালের অনুসারে বর্তমান সেটেলমেন্ট যাবতীয় ব্যক্তিগতের পক্ষে কাগজপত্র দলিল অথবা স্ব স্বাক্ষর বিবরণ দাখিল করা প্রয়োজন, এবং যেহেতু প্রতীয়মান হইতেছে যে নিম্নলিখিত ভূসম্পত্তি আপনার স্বার্থ বর্তমান আছে, সেহেতু আপনাকে এত দ্বারা জ্ঞাত করা হইতে যে আগামী
This was 3 years after that.
Because this was perhaps, my lord, in my understanding, because the other big riots, they have filed a writ petition before this Honorable Court, which was decided by Honorable Justice N.K. Mitra. My lord, in that perspective, this notice was served. Because otherwise, my lord, after this writ petition, things must have settled down at a point that the vesting order there has been set aside. So my client is entitled to get her mutated. But as on date, my lord.
But the premise of that was that it has been mutated in your name. Justice Banerjee's order says, page 61, when the state government has mutated the name of the petitioner as a tenant. And that was the premise of holding that they have accepted you as a tenant. Page 61.
Yes.
So after that, how are you seeking mutation all over again? If the tribunal, you did not seek mutation, actually, you said correct the records of right.
Correcting the record right with regard to, my lord, the 19 decimal of that. That they are saying that
the mutation was regarding what?
No, for correcting the record of rights, my lord.
But how could mutation be given without correcting the record?
That's why, my lord, with regard to that 19 decimal of line, it is the difficulty, my lord, out of this total 65 decimal of line that I have purchased.
No, rest, apart from the 19 decimal, nothing else was ever under consideration.
Under vesting.
So regarding this 19, everything is happening regarding this 19 only.
Now, if they say that it is still vested, I am entitled to file Form B. They have not. This is the first time, my lord, coming before your lordship. My lord, there was no exchange of affidavit. My lord, I do not know what is the present position.
No, but you have a point in saying that justice after this court's order, which has attained finality, they have no option.
They
but to
cannot
correct
say that they have to again reissue a notice of vesting if they at all want to say. That is a different. Then I have to again challenge. But this cannot be because
there is a question of vesting, issuing a notice of vesting notification. But this order, yes,
fresh notice, my lord, because this order they have not challenged. It has attained finality.
Let us hear them and then we'll come back to you. Yes, what do you say? How do you overcome the order of Justice Bhagavati Banerjee?
My lord, in that event, I sought for instruction, my lord. Instruction.
That order is very clear.
My lord,
Otherwise,
I have gone.
Tribunal is fully justified. We agree with the
I have
tribunal.
gone through the order, my lord. I sought for a specific question from the department, my lord. Let me file my affidavit, my lord, the sortsman.
Very well.
Then, my lord, may I pray for an order of status quo, my lord, as of date?
No, my lord. Not let this be decided, my lord.
But I have documents.
So in the meantime, if you dispose of the property, do anything?
Status quo as of date.
Since long, we have not yet disposed of.
No, I have a document because I cannot improve it because this matter it's my fault it was kept pending. In the meantime, my lord, part of the property they have
19, yes.
19
decimals.
Don't transfer in the meantime. We'll pass that order.
Status quo as on date because already একটা করেছে.
The state seeks to file an affidavit in opposition to the present application. Most of the case of the writ petitioner is that by an order dated July 31, 1989, passed in CR number 5816 within bracket W of 1986, comma, a learned single judge of this court had made a rule absolute, comma, thereby holding that when the state government has mutated the name of the petitioner as a tenant in respect of the disputed 19 decimals of land, comma, and has mutated her name as a tenant and accepted rents from the petitioner as a tenant, comma, the state government cannot treat the said land as a vested land and settle the same to other persons. Full stop. The learned single judge thus issued a writ in the nature of mandamus, commanding the respondents not to give effect or further effect to the impugned order of vesting. Full stop. Next para. However, comma, subsequently, when the writ petitioner approached the appropriate authorities for correction of the records of rights, comma, the first authority, that is the BL and LRO, and the appellate authority refused to do so, comma, upon which the writ petitioner was constrained to move the West Bengal Land Reforms and Tenancy Tribunal. Push up the learned tribunal proceeded to affirm the orders of the two authorities on a finding that despite the premise of the order of the learned single judge being that the name of the petitioner had been mutated in respect of Hondokotian numbers 449 to 452 and 517 to 531, comma, such documents in support thereof were not produced before the tribunal. Full-stop, learned counsel for the petitioner places reliance on such documents, comma, photocopies of which have been annexed to the present writ petition, which prima facie indicate that Hondokotians were opened up as observed by the learned single judge while passing the order in the aforesaid writ petition. Full-stop, next para. Thus, the question arises as to whether, in view of the rule being made absolute in CR number 5816 within bracket W of 1986, comma, the learned tribunal erred in law in not directing the correction of the records of rights in the name of the petitioners in terms of the said order.
May I, my lord, you'll also kindly come to page 6 of the impugned order.
Yes.
There it has been stated that on thorough scrutiny,
on thorough scrutiny, it has not been found.
Scrutiny of CR, submitted herewith.
But they
We
have
do
put.
not find any khanda
Yes,
copy.
yes, we record. That is what we are saying. That it's recorded, but they have produced documents here annexed here. That's why affidavit is also
That
required.
document which they have annexed, that is true that is true or not,
To be
that
seen.
we have to check.
To be
it
seen.
upon.
Full next para. Since arguable questions have been raised, comma, the parties shall maintain status quo with regard to the subject plots of land till disposal of the writ petition till January 31, 2025 or until further order, whichever is earlier. Full next para, the respondent shall file their affidavit in opposition. How soon can you file?
Within 3 weeks.
By January 9, 2026. Full stop. Reply, if any, shall be filed by January 23, 2026. Full stop. The matter shall next be listed for hearing on January 26, 26. Full stop. আচ্ছা interim order যেটা January 31 হবে না তাহলে till February 28, 2026 interim orderটা আর টাইমলাইন গুলো যারা হইল থ্যাংক
My lord, 26 January, your lordship.
Oh, sorry. January 27, 2026. Thank you. 26 January calendar ये देखें yes.
Item number 34. It's, my lord, this is an application for expeditious hearing of the matter pending before the first bench of West Bengal Land Reforms and Tenancy.
What was the application for?
Application for expeditious hearing, my lord.
The tribunal. Before the tribunal, what is the original application for?
My land is vested, my lord.
Yes.
And after before purchasing of before I purchase the land, my land is vested, my lord.
So you're a post-vesting transferee.
Yes, my lord.
Are you entitled to any relief?
I don't have any knowledge that
That won't save you anyway. The order sheet you have annexed. That it's
yes, my lord.
the innocuous prayer of the writ petitioner is that the original application bearing OA number 399 of 2015 within bracket LRTT, comma, filed by the writ petitioners before the West Bengal Land Reforms and Tenancy Tribunal has been kept pending for an inordinately long period. Full stop. We find from the order sheet, comma, certified copies of which have been annexed with the present writ petition that there is substance in such allegation, comma, since the matter is posted for hearing and has been adjourned on repeated occasions by the tribunal. Full stop. According in view of the nature of the relief sought to be granted, comma, we dispense with. Have you served on the other side?
No, my lord.
We dispense with prior service of notice on the respondents. Full stop. CO.
Yes, my lord.
It's
Well, it's from the LRTT order.
It can be
That's
both
why it was
CO
a-
and yes.
it can be both.
227. CO 2246 of 2025. Huh?
COLRT 3 of 20.
Oh, renumbered. Thank you. According to COLRT, thank you. COLRT 3 of 2025 is disposed of by directing the first bench, comma, West Bengal Land Reforms and Tenancy Tribunal to dispose of OA number 399 of 2015 within bracket LRTT, comma, pending before it as expeditiously as possible, comma, positively within February 28, 2026. No other extra costs. Artisan shops. Thank you.
Milord.
30th of the petitioner.
35 Milord, Mr. Bhattacharya is appearing.
I beg to reference
calendar.
In this matter, lordship was
Kindly see your lordship's Milord order dated Milord 1st December 2025.
Yes, Mr. Khalid, what is your
My
instruction?
lordship, I have come with the instruction and advance copy has been served upon a learned friend also, my lord. My lord, this authority, my lord, they are asking for certain documents so that the matters can be dealt with. My
There was a
lord,
direction by a learned single judge.
lordship, my lord,
Yes,
summon
earlier.
of this report is, my lord.
What was the direction? Where is the direction? Which page, Mr.
Milord, passed by a landed single judge.
Yeah, yeah, yes.
Yes, yes, it
For
is
19
No, no,
annexed, my
not
lord.
that, not that, not that.
19.
Yes, yes, learned single judge. You see, you
Earlier,
recorded
earlier, Milord, I came up before this honorable court, Milord,
that.
challenging inaction. This honorable court directed consideration of my representation.
Right.
Thereafter, Milord, nothing had happened. Milord, we went to the learned land reforms and tenancy tribunal. If your
Yes.
lordship would kind enough to come to page 118 of the petition, 19th May 2025 order.
Status report was sought, actually.
Yes,
that status report
crucially,
you
Milord, this
requested us.
petition.
Yes, what is the status, Mr. Khalid?
Milord, Milord, may I respectfully invite your lordship to paragraph 3 of the report, Milord.
Files are
Status
old.
sum and substances, Milord. They are
Files
asking.
are old and it might take time. What sort of?
No, Milord, kindly, Milord, next page, kindly says, Milord, language is somewhat. They are asking for trust deed with complete schedule because your trust deed is there without schedule. Here it has been annexed. They are asking for description of the land vested.
No, no. Have you given a hearing to him? You are directed to consider the representation.
In the year 1998, Milord.
Yes, by passing a reasoned order.
To pass a reasoned order, Milord.
Sir, why did you wait for so long?
Milord, there, Milord, he says, Milord, kindly.
He has to come up to this court every time. In 2018, 1998,
I fully, Milord,
there was a direction to consider and dispose of the
Milord,
till
may I,
date you
Milord?
are asking for documents and you never. That means you have flouted the order of this court like anything.
Milord, Milord, may these documents be, Milord, furnished so that it can be, Milord.
Well, Mr. Bhattacharya, they have asked for
Frame
certain
can-
documents.
Let them formally say what are the documents
They
want.
have given an advance copy to you. They have disclosed.
Milord, Milord, it's vague, Milord. What are their specific, Milord? Kindly see paragraph 3 and 4, Milord. It's vague.
Please see
They say
ABCD.
they could not do it, but what are their
Please
requirements?
see ABCD. The second
Yes,
page of
yes,
that report.
yes.
Very clear. You read out
Yes.
ABCD. Those are very clear.
Very well. Then, Milord, what, Milord, I am praying at this moment, Milord, let them give us a hearing, whatever documents A, B, C, D, and in any additional documents they require, we will produce it before the, Milord, district compensation officer, and Milord, they will dispose of the matter. And we will not, Milord, kindly dispose of the original application pending before the tribunal itself.
And kindly give a peremptory direction.
Give a
peremptory direction with a time frame, so that they can.
Who will have to
I don't.
Mr. Galib, who will do it? DLL or
No, district compensation officer.
District compensation officer.
Number 3. Very good. The ambit of the present writ petition is limited. The petitioner submits that despite a specific direction dated September 24th, 1998, passed in WP number 17923 within bracket W of 1998 to the effect that the district collector was to consider and dispose of the representation of the writ petitioner by passing a reasoned order, no such step has been taken. With the said grievance, when the writ petitioner approached the West Bengal Land Reforms and Tenancy Tribunal, a report was sought by the tribunal. It was suggested by learned counsel for the writ petitioner on the earlier occasion when we took up the matter, that instead of the tribunal, if the respondent authorities submit such report before this court, the matter can be expedited. In deference to a direction given by us pursuant to such request of the writ petitioner, the respondent authorities file a report today, from which it appears that the respondent authorities seek certain documents to be furnished by the writ petitioner in order to enable the respondent authorities to decide the representation of the writ petitioner. Full stop. Next para. Accordingly, we dispose of such report is kept on record. Full stop. Accordingly, we dispose of COLRT 4 of 2025 by directing the respondent number 3, that is the district compensation officer within bracket final, comma, South 24 Parganas, to dispose of the representation of the writ petitioner, comma, as referred to in the order dated September 24, 1998, passed in WP number 17923 within bracket W of 1998 in the following manner, colon. Next para, Roman 1. The respondent number 3 shall, comma, within a fortnight from date, comma, issue a notice of hearing, comma, specifying therein the date and venue of such hearing as well as the exact documents which are required to be furnished by the writ petitioner, comma, to the writ petitioner. Full stop. Next para. Such hearing shall be fixed latest within January 15, 2026. Full stop. Next para. Upon such hearing being given on the scheduled date and time to the writ petitioner, comma, along with other interested persons, comma, if any, as well as the state authorities, comma, the respondent number 3 shall come to a conclusion by deciding on the representation of the writ petitioner on the basis of such documents as furnished by the writ petitioner. First of Roman 2, for such purpose, comma, the respondent number 3 shall, comma, if necessary, comma, extend the time for the writ petitioners to produce such documents as required. For sub next para, the entire exercise, comma, up to a reasoned order being passed on the representation of the writ petitioner upon hearing all interested persons, including the petitioner, comma, shall be completed latest by February 28, 2026. Full stop. Immediately thereafter, comma, a copy of such reasoned order shall be forwarded to the writ petitioner. Full stop. We have not entered into the merits of the contentions raised by the writ petitioner in the representation, and it will be open to the respondent number 3 to decide the same in accordance with law on the basis of the materials before the said respondent. No rest to call for the certificate.
The original application before the tribunal is also disposed of.
Acha, by virtue of this order, comma, OA number
2654 of 2016 in bracket LRTT, page 118.
OA number 2654 of 2016, bracket LRTT, pending before the first bench, comma, West Bengal Land Reforms and Tenancy Tribunal, also stands disposed of.
I'm grateful to your lordship.
Thank you.
Grateful.
Thank you.
Item number 36.
For the petitioner, my lord,
Yes,
the
Mr. Ghosh.
Expeditious disposal.
the Thika controller order has been challenged. The next date before the learned tribunal fixed on 4th February.
4th February.
But you have not annexed any of the order sheets.
Yes, but you have to annex the order.
Only page 6.
How do you know that you are not at fault in the delay?
Lord, I have
Only page 6 minute para 8. My learned
paragraph
friend has made an averment.
stated
Page 6
Where are
para
the
8.
certified copies of the order sheet?
certificate copy not annexed.
Not at all.
In your copy, it is annexed.
In my copy,
What is the English of NACA, Mr. Ghosh?
this is
You're
my
asking us whether it's annexed in our copy, when it is not annexed in your copy.
fault. I thought this is original copy, annexed with the original in the my lord's copy.
Original copy will be annexed in our copy, and you won't have a copy of that in your application.
That is my
What sort of ridiculous question you are asking?
No,
No, without the certified copy, we won't pass any order.
not today, my lord.
On the prayer of the petitioner, let the matter stand adjourned till December 22, 2025 for the purpose of the writ petitioner to furnish the certified copies of the order sheet of the tribunal in order to enable this court to pass appropriate orders in the present writ petition. Next. Repetition हो जाएगा ना
Yes, my lord.
experiences hearing.
My lord, I'm
At
playing.
least you have annexed the order sheet. Oh, actual share of time. অনেক দিনের hearing ফেলে দিয়েছি বুঝিনের hearing.
My lord, an application has been filed in the year 2020.
Have you served on the other side?
Yes, my lord.
They have received
Yes, my lord. The
affidavit of service. What is your name?
My lord, I am respondent number 5, Sajahan Mondal.
You cannot be the respondent number 5.
In the sub herein,
What is your name, ma'am?
Kriti Keshri.
Kriti?
Keshri.
Kriti Keshri. How long are you practicing?
My lord, 2 years.
Then your name should go into our order. Miss Kriti Keshri, comma, appearing for the writ petitioner, comma, submits that the present writ petition has been filed seeking expeditious disposal of OA number 1528 of 2020, which is pending before the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal for an inordinately long period.
Yes,
so, in view of the innocuous nature of the proposed order, comma, we dispense with prior service of notice of the writ petition on the respondents. First up, we find from the certified copies of the order sheet of the original application filed by the writ petitioner before the tribunal that indeed, comma, the original application has been kept pending at the hearing stage for an inordinately long period. Full stop. Accordingly, CO LRT 6 of 2025 is disposed of by directing the third bench, comma, West Bengal Land Reforms and Tenancy Tribunal to dispose of OA number 1528 of 2020 within bracket LRTT pending at the behest of the writ petitioner as expeditiously as possible, comma, preferably within February 28, 2026, comma, in accordance with law. Full stop. The tribunal shall act on the server copy of this order without insisting upon prior production of a certified copy. আচ্ছা প্রথম লাইনে না এই একটা করে দিও affidavit of service filed to be kept on record despite service none appears for the respondents তারপর পরে একটা জায়গায় যেখানে বলেছি যে dispense with service ওখানে dispense with further service করো বুঝতে পারলে থ্যাংক ইউ
Number 38.
Yes.
Your Lordship, I appear on behalf of the
The
petitioner.
laptop is bigger than you. What is the matter about?
It's a matter regarding which content pertains to the LRTT WB LRTT order. Your Lordship, and pleased to allow us leave to file a supplementary affidavit on the last occasion. We have complied with that. We have served on a learned friend also. We are we are filing it in court, the hard copy. We are also being led by Mr. Joydeep Kaur, senior advocate, as well as Mr. Rahul Kormakar, counsel, who are both on the legs in already ongoing matters, Your Lordship. We in the view that we have complied with the complied with the order, may this matter be listed for tomorrow, subject to Your Lordship's.
Yes, Mr. Gali.
I don't stand in the
Supplementary affidavit filed today be kept. You have given. You have got what?
I have already.
Supplementary affidavit filed today be kept on record. So on the prayer of the petitioner, let the matter stand adjourned for the day. For the day.
Much obliged, Your Lord.
Thank you.
Much obliged.
আমি পেলে এবার অনেকগুলো হয়ে গেছে
My Lord, Mr. Pradeep Kumar Dash is appearing for the petitioner. On his accommodation, I am praying for not this way.
Expeditious. What is?
What happened on 3rd of November? Mr. Gali?
3rd of November, Lordship was pleased to direct my learned friend for the petitioner that you are to come up with the certified copies so that we want to see that how many adjournments were sought for by you and how many by the state. Oh, I see.
Yes. What happened to Mr. Pradeep Das? He's
My lord,
in the
he's-
tribunal taking the certified copies.
My lord, he is out of station.
You move the matter then. We won't grant any further.
My lord,
Or we dismiss the matter.
my lord, I am not his chamber.
You were given time, the petitioner was given time to produce the certified copies. We had some hunch because nothing was produced. And we also asked you to produce a chart to indicate as to the number of dates on which you had sought for adjournment. And you are out of station.
My lord, I am not his chamber junior, hence.
An adjournment is sought on the ground of absence of learned counsel for the petitioners. Full stop. Learned senior government advocate rightly points out that by your previous order dated November 10, 2025, we had directed the petitioners to furnish certified copies of the entire order sheet of the proceeding to before the tribunal to ascertain as to how far the petitioners themselves were responsible for the delay occasioned in conclusion of the original application before the tribunal. Pushed up, apart from the certified copy of the entire order sheet, along with the second judge's copy, we had also directed the petitioners to produce a chart to indicate the number of dates on which the petitioners sought adjournment, the number of dates on which the respondents sought adjournment, and the number of dates on which the matter was adjourned for some other reasons. Full stop. Unfortunately, today, at the time of call, an adjournment is sought by the petitioners. So it transpires that the petitioners are not serious in moving the present writ petition, which, in the first place, is for expeditious hearing of the application before the tribunal. Full stop. Accordingly, let the matter go out of the list with liberty to mention in the month of January 2026. Go out of list, coordinator.
Number 40.
Yes, Mr. Shamanto, what is the matter? Mr. Shamanto versus Mr. De.
Yes,
You will
madam.
release the other matters?
Madam?
Should you release the other matters?
Madam.
Not necessary. Achha, yes.
Is the affidavit service, madam?
Only state respondents. I mean, no private respondents.
Private respondent is there, madam. Madam,
Service
private,
effective.
the learned advocate appearing with private respondent. Madam,
Oh, you have served on the private respondent.
private respondent, he, madam.
He has received. Devbrata Sardar is the
Yes,
advocate.
yes, yes.
He has received. So move the matter. Yes.
Madam, may I hand over a short list of this because jumble of facts.
Why not? But you have to give a copy to Mr. De also, otherwise he won't be able to follow.
Huh?
Yes, that is a relevant question. Yes, Mr. Samanth, what is the matter? কি বলেছিলাম?
No, father of the petitioners.
Listen.
Madam,
Yes.
because the number of transactions are there, say for that reason, madam, I have made it.
No, you are not at fault. I mean, if the matter is long, what can you do?
Madam, he ought to have been made, madam, so long he has been appearing. Madam, in the other courts, madam, the writ petition pending.
What is the matter about? Just tell us, then we will look into this.
Madam, yes, madam.
Now, what have you challenged? The tribunal order of the tribunal?
Order. Tribunal, madam, during the pendency of the two writ petition, one preferred by the private respondent, another preferred by my client.
What has the tribunal done?
Last page two. Last tribunal, after a long period, my lord, he says.
Dispose of being withdrawn.
Yes, my lord.
So how can you challenge this order?
But yes, for this reason, my lord, entire claim of the private respondent is a fake.
No, who has, not you, the private respondent has withdrawn. He was the applicant.
Yes, yes, sir.
He has been given any liberty to
File a fresh representation with the well or just.
How are you affected?
Because, when the matter is pending with this court, two writ petitions in between the parties.
By the we are to look at the impugned order, Mr. Shamanto. By the impugned order, tribunal has given liberty to the original applicant to withdraw it.
Withdraw it and to file a fresh representation with copy to us.
Was any order?
No other order.
Was any order passed? Was any order passed during pendency of the original application which accrued in your favor?
Accepting withdrawal. Then, why I have come? Because we have.
I want to. If your lordship will see the four lines of the first order. My lord, his lawyer also, my lord, give no objection.
First date happened.
Let the
Samanto's lawyer.
Yes, my lord.
Yes.
That is very serious. On the first
Cannot,
day,
this is not maintainable. Sorry.
you are also carrying only for that.
No, no, consent order. no, no.
1 minute, you are also carrying. I have come with a
1 minute.
yes.
Come with a list of date, that's why.
Only 1 minute. In between the parties, two read petitions are pending.
Yes.
That is going on.
Let that go on.
He prayed for compensation of the land acquired by the government. I also, my lord, on my application, I was awarded amount, and rest of the land, my lord, I wanted to get return of the land.
It's a
I apprehend.
Well, contention of ownership of the land between you and him.
Same land.
So there is a rival contention regarding
rival.
Regarding ownership of
Yes,
the
but but
you claim to be the owner, they also claim to be the owner.
No, their ancestors transferred the land money. If you lost it, kindly come to
whether you and they both are claiming to be the owner of the property.
Same land.
So two writ petitions are pending. Fight those out. He has withdrawn this. Let him be at peace.
No, he has been making a prayer. He has made a prayer for making further representation for the correction of
Nobody can prevent somebody from giving a representation.
After 59 years, if you have lost the KDC,
let him give a representation. Every day you can give a representation and vex them. So that Mr. They has opportunity to...
I appear, my lord, since 2019, I have been fighting.
You agreed to this. You raised no objection.
That is there, my lord. On the first day it happened, my lord.
No.
On the first day it happened, my
lord. The present challenge has been preferred against an order whereby the tribunal permitted the private respondent, who was the original applicant before the tribunal, to withdraw such original application with liberty to file a fresh representation before the BL and LRO Kolkata. Next para, learned counsel appearing for the petitioner submits that the said order is harassive insofar as the present writ petitioner is concerned, since litigation is pending between the parties for 59 years, even at present, it is contended that two writ petitions are pending between the parties. The dispute centers around rival contentions between the writ petitioner and the private respondent as to ownership of a property regarding which both claim compensation. Next para, learned additional government pleader appearing for the state points out that in the impugned order, it was inter alia recorded that learned counsel for the private respondents within bracket the present writ petitioners bracket closed had raised no objection to such prayer of withdrawal made by the original applicant stroke private respondent. We agree with such contention of learned senior government, learned additional government pleader. It is well settled that a consent order cannot be challenged before a superior forum. Next para, even otherwise, despite long pendency of litigation and acrimony between the private parties, fact remains that by the impugned order, the tribunal permitted the private respondent to withdraw the private respondent's original application. There is no illegality or irregularity in such permission being given. Even otherwise, since it is not the case of the writ petitioner that any order was passed at the interlocutory stage of the original application by which some valuable right had accrued to the writ petitioner and which is now sought to be taken away by the withdrawal. Next para, the mere liberty granted to the private respondent to file a fresh representation does not tantamount to directing such representation to be allowed. Next para, in any event, any citizen can give any representation on a legal issue or claiming a right before any authority under the state at any point of time, and there is nothing to prevent such course of action by the citizens. Thus, we do not find any illegality even otherwise in the impugned order. Accordingly, WPLRT 196 of 2025 is dismissed, thereby affirming the order dated October 27, 2025, passed by the second bench, West Bengal Land Reforms and Tenancy Tribunal in OA 2542/2025, bracket LRTT, without any order as to cost, we make it abundantly clear that we have not entered into the merits of the rival contentions between the private parties in any manner whatsoever. Push up the affidavit of service filed to the Calcutta.
Madam, may I make one humble prayer, my lord? Because I moved the petition before the Lordship, my lord. Madam, the representation submitted by the private respondent, I did not submit any objection. Your Lordship kindly grant the liberty so that I can submit my objection to that representation with the BLRO. That your Lordship kindly make it clear.
We further add that in the event any representation has been made in terms of the impugned order by the private respondent, the BL and the concerned BL and LRO before whom such representation has been filed shall decide the same in accordance with law upon giving adequate opportunity of hearing / filing of written objection to all interested persons, including the present writ petitioners. Thank you.
I became affected because of the liberty.
In this matter, I am appearing for the petitioner, my lord.
Yes,
for
Mr.
expeditious disposal of the pending, my lord, kindly 646 and 47, my lord. One application for mutation was made. My lord, that was reported by the BLRO that was disposed of on online in year 2013. That was disbelieved by the Honorable Tribunal, but no hearing has been made, my lord, since thereafter. My lord, long 46 and 47, kindly see.
Affidavit of service filed to be kept on record. The innocuous prayer of the writ petitioner is that the original application filed by the writ petitioners before the tribunal has been kept pending for inordinately long period. Push up.
It has been fixed on, my lord, 27th February 2026.
We find from the last order of the tribunal dated June 12, 2025, that the matter has been fixed next for hearing on February 27, 2026. Push up next para. Accordingly, we dispose of WPLRT 197 of 2025 by directing the first bench, West Bengal Land Reforms and Tenancy Tribunal, to positively take up the hearing of the matter on the next date fixed, that is on February 27, 2026, and dispose of OA number 2941 of 2017 within bracket LRTT as expeditiously thereafter as possible, preferably within 2 months thereafter. Full stop. No orders to cause urgency debate. Thank
My lord, I appear on behalf of the petitioner. But this is my affidavit of service.
Yes.
My lord, that challenge in this application, my lord, the order passed by the
Every time at around this time your matter is called on. Last occasion we have repeated paucity of times.
Yes,
So we don't know whether today is also the same thing will happen.
Yes, but there is time, so I should. My lord, I have challenged the order passed by the Learned Tribunal, order dated, my lord, 2nd of September 2025. My lord, remitting the matter to the appellate authority under section 54 of the Land Reforms Act. My lord, I have challenged this order. Before that, my lord, I placed the facts. Mother of the petition number 1, 2, and 3, my lord, purchased land 1 acre 6 decimals of land by 2 registered deed in the year 1982.
Mother
of the present petitioners. My lord, thereafter, my lord, in the year 1982.
Yes.
My lord, 84, a proceeding was initiated and land was vested. My lord, thereafter, my lord, I made an application to the authority for mutation of the name. The mutation was not done since it was vested. My lord, thereafter, my lord, the mother of the petitioners died in the year 2006, and legally as the present petitioners inherited that land. My lord, they made an application before the authority under section 14U subsection 3 of the Land Reforms Act. My lord, a proceeding, my lord, or that application was not considered.
14U is that irrigable land?
My lord, no. 14, my lord, U3, that is, my lord, if the land, if the pre-vesting,
he can take
Prior
that
to
opportunity.
vesting, my lord, that land of equal, my lord, area of land will be, my lord, taken, and my lord, from the my lord, transferor, and my lord, that will be retained. My land will be retained. That is the proceeding provision. My lord, that was not considered. That application was not considered. I moved an application before the tribunal, and tribunal passed an order. My lord, that is, your lordship, kindly come to page 53. My
You have got the
application is
certified copy, you can.
Yes, my lord, that is not certified copy. Earlier order I have annexed. Order dated, my lord, 8th of April 2013. My lord, page 53. My lord, I am not placing the entire order, my lord.
No, need not.
Relevant part.
Dispose of by directing to dispose of your application.
No, my lord. That your lordship, kindly last paragraph. It is submitted by the learned government representative. Further, the action for distribution was taken, such and such thereafter. After hearing the parties, we are of the opinion that the vendor of the applicants suppressed the material facts before the hearing officer at the time of hearing. For such suppression, the vendor, the applicants cannot be subject to suffer. It is the statutory right of the vendee, that is, my lord, the petitioners, to protect his land under section 14U3 of the West Bengal Land Reforms Act. We observed that the petition was duly filed, but no benefit was granted in favor of the applicants. We cannot allow the state authorities to curtail the statutory right of the applicants.
Yes, it was directed. They were directed to dispose of your application. That is what you said.
That is the ultimate, my lord. But there is finding that I am entitled to, my lord, get the land under section under the law. I am. That is the, my lord.
It is stated only statutory right of the vendee to protect his land under 14U3 cannot be curtailed.
Cannot be curtailed. That is the observation, my lord.
That is law.
Yes,
that is law. That is the law.
My lord, thereafter, my lord, the respond number 3. My lord, passed an order. Your lordship, kindly count.
That does not mean that a direction was given to dispose it of in a particular way.
On the
your statutory right was recognized, which is there. We also agree to that.
Observation was made and direct to consider my application.
Yes.
And your lordship, kindly come to, my lord, page 60. My that application under 14U3 that was considered and that was rejected.
Why rejected?
Rejected on the ground.
Yes.
Since the, my lord, petitioners were not in possession, so it cannot be, my lord, under 14U3, it cannot be, my lord, given to the petitioner, since you are not in possession. My lord, according to provisions under section 14TU3, my lord, there is no such, my lord, provision that if I am not in a possession, that the land cannot be, well, according to, my lord, that, my lord, provision, land cannot be given to the
possession is not a prerequisite.
No, that is my lord point.
As I am interfering, as because, my lord, not only that, my lord, his name was not recorded. He never mutated. 1982, my lord, that was the.
But if he has a title deed, Mr.
Title deeds in 1982 and 1984, my lord, vesting order was done, but they never mutated his name, my lord. For that is 2 grounds.
Title does not go. Title does not go. Even if they did not mute, mutation does not confer title.
Only for 2 reasons, 2 grounds. That is the one ground is, my lord, that his name was not mutated, though previously it was done, and his.
My lord, mutation is done under section 50.
So those are not prerequisite under
as
this.
Because, my lord, how I can know? As because
purchase deed.
14U, there is a provision, my lord, that if anybody purchases a land before the date of vesting, that is the 84, my lord, he will get that benefit. But when we go on proceeding, my lord, that is vesting proceeding 14T, my lord, 14T, if your lordship will knows that when we start the 14T, my lord, when we start the 14T, my lord, there is a, my lord,
due to furnished return and all.
Yes, my lord. Not only
that the original
my lord,
right had to the vendor.
14T, my lord, along with 14T and S, my lord. That is, we must take the possession of that land. If your lordship come to the 14T, my lord, 14T3,
yes,
the revenue officer may, on receipt of return submitted under subsection 1 and 2, on his own motion determine the extent of land which is to vest to the state under section 14S and to take possession of such land.
That is to precede 14U.
That is, my lord, when we take the possession,
yes,
at that time he is not in possession. Now, how the state will know that he purchased this land in 1982. If he mutated his name, then it is the
Is there
history
any
of-
dispute regarding his vendor being in possession?
No, my lord. The vesting, we are taking.
There
the
is no person,
position.
but language of 14U is except where he is permitted in writing by the revenue officer to do so.
We take position.
Ayat owning land in excess of the ceiling area applicable to him after the publication shall not transfer by.
My lord, 14U, I am not disputing. I
So
am
therefore,
disputing on
yes.
14T3.
Can you reopen that issue now? 14T3 at
Yes,
the
my lord.
under 14U.
What is 14U T3? 14T3, my lord, that is fast vesting. That is 94 vesting. Now, according to the provision of 14T3, that is 14S. That is S, my lord. That 14S, my lord, to take the possession along with that. Now we take the possession of the land. At that time, he is not there. For that reason, my lord, BLR rejected his application. If, my lord, he is in possession, then we can, my lord, know that he is in possession. So 14U on that day, his name will be recorded, my lord, according to the provision of 14U.
Your position must have been in accordance with law then. You have to establish under which right to.
We are taking the possession on that day. He is not in possession. 14S.
So you can take possession under 14S
Yes,
of
madam.
land only which is in excess of ceiling area.
The vesting, that is vested land.
Vested
That
land.
his land is vested.
But here his vendor retained that land.
No, my lord. His land was vested.
So that was not a retained land.
No, my lord. If that is retained land, then
My lord,
there is no
14
এক মিনিট দাঁড়াও। এই পয়েন্টটা হয়ে যাক তারপর তোমার এতে my lord, we have no 14U, we are never, we are always ready to give him. But on that day, how the BLR knows that he is not in, if he is not in possession, my lord, we vested that land, and after that, my lord, we are taking the possession. At that time, he is not there. For that reason, my lord, his BLR rejected his application. After that, my lord, your lordship, my lord, after order passed, my lord, that is the BLRO, my lord, issued the notice for fresh hearing according to the my lord. And my lord, on the 5th, my lord, the date was fixed, my lord. If your lordship will see, and my learned friend, my lord, took a time for that.
We have got only one copy.
No, my lord, I am giving you. I am sorry, my lord.
Since the matter is pending before your lordship, that's why, my lord, date was given. I made an application praying for time. The matter is sub judice before your lordship, so I cannot, since I have challenged the
What
order.
has the tribunal done?
Tribunal, my lord, remitted the matter to the, my lord, since it is
BLRO
without giving any reason, order was passed by the appellate authority. It was
So what
remitted.
had you challenged before the tribunal? There was a previous direction by the tribunal to.
Yes, there is a previous direction to consider and pass a
Yes.
reason order.
So what happened? They again rejected.
Again rejected.
Against that you prefer.
Against that I file application, and again, my lord, since no reason was
So
given.
you say instead of remanding it, the tribunal itself should have decided.
Yes, that is my lord.
Even
Even
either way will be usurping jurisdiction.
Well, one thing.
Either if we retain this order, then that the BLLR has to decide this in accordance
My
with
lord,
the.
BLRO should be decided. Otherwise, my lord, what happened?
You lose a forum.
My lord, otherwise, my lord, this is a very peculiar case, my lord. That's because, my lord, my learned friend.
No, if you usurp that jurisdiction.
Only for that reason, my lord. Then, my lord, we act as part. That is a vested land, my lord. We issue patta to them. My lord, patta is now given to them, my lord. That is a very peculiar case. I have never seen such a. Patta is given to the brothers and other them, my lord. But they are not party in this process. So, my lord, I pray that the BLR will consider all the aspects. Those facts were not, my lord, before the tribunal. Only for that reason, my lord, BLR should consider all, and they will make all the parties, my lord. If we have already issued patta, then, my lord, we have nothing to say, my lord. We must BLR will give them.
Mr. Sinha, if you come to the impugned order, page 3 of that, after quotation of the appellate authority's order, which is, I mean, pathetic.
Appellate authority is very bad.
Pathetic order. But the BLR, the tribunal's order is just, why not just bare perusal of the order impels us to conclude that the order under challenge is cryptic, is absolutely correct. Nothing emerges from the order. Mr. Sinha, there was a justification of the tribunal sending it back.
Well, this is
because
second.
No, we are telling you why. Because suppose like in a civil suit, if the appellate court sees that the trial court has not decided anything on merits, then it has to remand it back, because otherwise one forum will be lost by both the sides.
My lord,
There was
since
no
the-
if there was an adjudication, then the tribunal. Otherwise, the tribunal will act as the appellate authority for the first time.
May I, my lord, submit? My lord, since, my lord, if everything, my lord, is before the tribunal, my lord, the documents before the tribunal can decide the matter.
But all the parties were not there, my lord.
All the
That-
parties
Tribunal
are
will
there.
then be the first forum, Mr. Sinha.
No,
Then
my lord,
both
the
of you will leave
appellate
the
authority,
forum.
tribunal earlier occasions, my lord, passed an order directing to pass a regional order to the appellate authority. In spite of that, my lord, appellate authority passed this order. Against that, I again file application. My lord, your lordship kindly come to the earlier order of the, my lord.
No, but because appellate authority did not pass a regional order, that's why it was remanded back to the appellate authority only.
My lord, your lordship
What
kindly,
can be done? Mr. Sinha, there is no scope of interference here.
my lord, your lordship kindly
We are not
consider.
going into the merits of the matter.
Your lordship kindly consider, my lord, since the everything is before the tribunal.
This is perfectly justified. Why should you interfere? This is not an illegal order.
No, my lord, I am placing a judgment before your lordship, my lord, judgment of the Supreme Court. My lord, since all the, my lord, documents are available before the authority, my lord, authority can, my lord, tribunal can pass this order. Your lordship kindly, it is reported in, my lord, AR 99 Supreme Court, page 1125. Well, this is also on civil proceeding. Although, my lord, your lordship, I am relying on paragraph 6 and 7. Even your lordships can decide this.
That is only left to be done.
No, I am not. My lord, Supreme Court has, my lord, that what made the observations. Since because this delay is long.
This was a different. This here all the documents were there. Not only there, those were considered by the trial court. High Court came to conclusion that when the compromise was recorded, hence the trial court was wrong in thinking that present defendants could not have come into possession. So according to the High Court, the trial court was wrong in thinking there was an so the conclusion of the trial court was held by the High Court to be wrong. There it was held that the High Court itself could decide it then.
Yes, High Court.
Here there is no conclusion what the name at all.
There is a conclusion earlier, my lord. There is a observation and finding that, my lord, I am entitled to that land. I am entitled according to section, my lord.
There the materials were considered by the trial court, Mr. Sinha. If you see paragraph 5, please come to paragraph 5 of your judgment. The judgment cited by
yes,
you.
Yes.
Please read it out. Everything was considered by the trial court,
yes,
decided in a particular way. High Court felt otherwise, it should not have been decided in this way.
Yes.
But still, then High Court could have itself decided. Then but still High Court remanded the matter back to the trial court for a fresh adjudication, although there was an adjudication on merits by the trial court in the earlier occasion. Here there is no adjudication.
My lord, there is no adjudication, but there is, my lord, there is an observation, my lord. That's why, my lord, earlier occasion, my lord.
We have read this, Mr. Sinha, we are distinguishing this. We will not.
My lord, then your lordship kindly, my lord, direct the, my lord, tribunal to decide this.
No. The present challenge has been preferred against an order whereby the learned tribunal has remanded the matter to the appellate authority, that is the district land and land reforms officer, Nodia. Full stop. The premise of the remand was that despite a previous direction to pass a reasoned order, the appellate authority passed an order which was cryptic, evasive and devoid of proper reasons and logic, which according to the tribunal was a glaring example of non-application of mind. Full stop. Next para. The learned tribunal, in the impugned order, in fact quoted quoted the order of the appellate authority. Full stop. The appellate authority merely stated that the appellant was present and filed hazira, but the respondent was absent. It further observed that it had seen the case records, especially memo of appeal and order passed by the impugned order of the BL and LRO, Nakashipara in the concerned miscellaneous case, deeds and necessary documents, and also the present status of lands involved in the case. First up, it went on to hold that the order passed by the BL and LRO is on the basis of statute and the appeal was disposed of. First up, next para, ex facie, such order was cryptic and not worth the name of an order at all. First up, it is well settled that reason is the soul of an order, full stop, in adjudications of a quasi-civil nature as done by the appellate authority under section 54 of the West Bengal Land Reforms Act 1955, which decides the rights and which decides valuable rights of parties, such a pathetic, unreasoned order is not desired. Full stop. Hence, the learned tribunal was justified in remanding the matter to the appellate authority, which never exercised its jurisdiction at all. Full stop. Learned counsel for the petitioner before us cites such and such namta party reported at AIR 1999 SC 1128, where it was held by the Honorable Supreme Court that the High Court should not ordinarily remand a case under Order 41, Rule 23 of the Code of Civil Procedure to the lower court merely because it considered that the reasoning of the lower court in some respects was wrong, since such remand orders lead to unnecessary delays and cause prejudice to the parties to the case. Full stop. Next para. However, in the said case, in the preceding paragraph where the ratio was laid down, the High Court, no, the Honorable Supreme Court considered that the High Court, while dealing with the appeal preferred before it, had observed that the trial court had mainly relied upon a compromise decree between the owners and the defendant numbers 20 to 25 in an earlier suit, filed by the defendant numbers 20 to 25 against the owners on the basis of an agreement dated October 14, 1980. According to the High Court, while it was true that the said defendants 20 to 25 accepted the possession of the owners, defendants 1 to 14, the said admission related to the date of compromise dated April 26, 1990 and not to August 14, 1992, when the compromise was recorded, and hence the trial court was wrong in thinking that the defendants 15 to 19 could not have come into possession on July 16, 1991 from the owners. It was further observed by the Honorable Supreme Court that according to the High Court, the trial court was wrong in thinking that there was an admission by defendants 20 to 25 of the possession of the owners as on August 14, 1992, the date when the compromise was recorded, and also in thinking that the defendants 15 to 19 could not have come into possession on July 16, 1991. The admission, if any, related to April 26, 1990, the date of the compromise, and there was, according to the High Court, no inconsistency with the case of defendant numbers 15 to 19 of possession being given to them under the agreement in question. The High Court had also observed that this also makes the factual foundation of the trial court apostrophes order erroneous, on which reasons the High Court set aside the order of the trial court and remitted the matter for a fresh decision. Next para, it is a settled position of law that a judgment can only be a binding precedent for the ratio laid down therein and not what can be logically derived from such ratio. In the cited judgment, the Honorable Supreme Court deprecated the remand order in the facts and the circumstances of the case which we have narrated immediately above. Next para, in the said case, despite all the relevant materials having been considered at length by the trial court and the trial court having come to specific legal and factual conclusions, the High Court was of the opinion that such conclusions were erroneous but instead of deciding the appeal itself, comma, had remanded the matter to the trial court. Full stop. Next para. However, comma, as opposed to the said case, comma, in the present case, comma, the appellate authority has not even paid lip service to the provisions of Section 54 of the West Bengal Land Reforms Act 1955. Full stop. The appellate authority did not advert at all to the materials on record and did not spend a single sentence by way of reasoning for its conclusion. Full stop. Thus, comma, this is not a case where the adjudication was made on merits by the appellate authority and the tribunal, comma, instead of deciding the matter on merits, comma, shirked its duty and remanded the matter back to the appellate authority. Full stop. Next para. In the facts of the present case, comma, if the tribunal were to adjudicate the matter, comma, it would be usurping the power of the appellate authority, comma, thereby depriving both parties of a forum of challenge, comma, since there was no exercise by the appellate authority worth the name at all under Section 54 of the 1955 Act. Full stop. In such view of the matter, comma, the ratio laid down in Ashwin Kumar Supra is not attracted to the present case, where there was no consideration on merits of the matter at all by the appellate authority. Full stop. Thus, comma, we are of the opinion that the learned tribunal was justified in remitting the matter back to the appellate authority. Full stop. Accordingly, WP LRT 198 of 2025 is dismissed on contest without any order as to cost, comma, thereby affirming the judgment dated September 2, 2025, passed by the which bench is this?
Fourth bench.
Fourth bench, West Bengal Land Reforms and Tenancy Tribunal, in OA number 1137 of 2023 within bracket LRTT. Full stop. It is expected that the appellate authority shall, comma, in terms of the directions of the tribunal, comma, dispose of the appeal as expeditiously as possible in accordance with law, comma, upon giving opportunity to all interested parties of hearing. Full stop.
You'll also kindly make a time frame. My lord.
It is expected that the appellate authority shall dispose of the matter latest within 3 months from the date of communication of this order to the said authority. Can one of 2025 stands disposed of consequentially.